All right. And again, as with the similar exhibits, you're saying these are not offered for any truth of what's inserted in there, but simply for the non-hearsay purpose of establishing, if they even do, the extent of any potential damages that flowed from breach of the non-disparagement clause.
Correct, Your Honor. And it also goes to bad faith. We saw yesterday part of one of the messages, one of the posts that the defendant posted on Telegram mentioned Miss Wade receiving replies from Lynn's followers. And so that goes to the defendant's state of mind for our bad faith claim that he knew what was coming from these posts, that his followers were responding to her directly.
All right. Of course, Mr. Wood, and I'll just say at the outset, I recognize that you disagree with that inference or conclusion that might flow from this evidence. But for me to exclude it, I've got to hear why under the rules, the jury shouldn't even be allowed to consider it.
Number one, it's fiction that I knew anything about these. Without a showing that I knew about them, that cannot be evidence of bad faith on my part. So if they want to use these to somehow show bad faith on my part, they've got to connect up causally the fact that I knew about them. I have no idea who these people are. I had no idea that she was receiving this stuff on Telegram. Apparently she didn't block this junk. If you know anything about Telegram, you know it is a deep state social media platform. It is full of bots, computer generated users. It is full of shills, people who are paid to post things to either propagandize or to attack. There is not one iota of evidence that I had any knowledge or any linkage to any of these things that she received. So there's no way in the world under the law that I can be held in any way responsible, either as a state of mind or as an actual act on my part. Now they can put me on the stand and cross-examine me on whether I knew about this stuff. I know nothing about this. I do know that this was the tactic used in the defamation trial. A Telegram channel called Breadbasket was used to generate shills and bots to attack Jonathan Taylor and Nicole. I figured that out from that trial. And then they take those attacks and they try to use them against me. That is a tactic on Telegram and perhaps other social media platforms where they're trying to attack them so they can attack me. I have nothing to do with it, and until and unless they can connect me to it, other than somebody writing my name and saying, Lynn Wood said this. Well, who is that person? They ought to, at a minimum, bring in at least some of these people and put them on the stand and let's examine them as to whether I had anything to do with what they wrote. If they were able to do that, and they should be forced to do it, there's not going to be any connection. So if Your Honor allows this stuff in on bad faith or otherwise, it is totally void of any connection to my state of mind or my actions. And if you allow that evidence to come in, which is not authenticated, which is pure hearsay, to go to the truth of the matter that they were statements made by somebody. Look at some of the names on these people. You can tell they're fake. If they were real, they'd put their name. And if she didn't want to receive these, get off Telegram. Block them. Ignore them. You can't go in and talk about Telegram, a social media platform, like a dummy. You got to know what goes on those platforms. Twitter, was a CIA operation to gather intelligence and to propagandize. I realized on Twitter after a period of time that 60 or 70% of the people on Twitter were fake. They were there to propagandize. I learned the same thing about Parler. I've learned the same thing about Telegram. I hadn't been on Facebook for 14 years, but I believe it's the same deal. They gather intelligence. They use it for their own purposes. Somebody posts on Facebook, I love Dell computers. They'll start getting emails and text. We got a Dell computer for sale. Now, the real world is the real world. There is no privacy. If something is in the air, it's in the air and it's captured. So your text messages, your emails, your phone conversations, they're in the air and they're captured. And they're used for people for nefarious purposes. Create mailing lists. I mean, I've had instances where we were talking about one of the folks that worked for me had purchased a new puppy. And he texted his son about it. The next morning, he was inundated with text messages about, you need puppy supplies? Now, recognizing that all of that information is collected for nefarious purposes, I wouldn't put 2 cents of credibility on anything that appears on social media, unless the person identifies themselves and you're able to go and say, hey, did you do this? Did you say that? I use my name. I don't have anything to hide. But I also know that if everything's in the air, I believe the United States government gets it. So when you have a phone call or you text or you email and you're up to no good and you're conspiring to rig a jury or you're conspiring to harm somebody, I think President Trump's team knows it. And that's why he did Truth Social. It's a sting operation on Truth Social. He's going to drain the swamp. And he's going to get everybody before it's over who has been disloyal to this country, who is involved in child sex trafficking. So I warn people to be careful what you write, because somebody's watching. I believe President Trump and his team are watching. But I can't prove that. But I know that God is watching every move you make, every word you speak, every act you engage in, every thought you have. And the beauty of God is that He knows what you're going to do and say and think before you even do it or say it or think it. So I think it would be egregious error requiring a reversal of this case if Your Honor allows this information and these texts or whatever they are into evidence. No foundation, hearsay, no relevance, no ability to prove authenticity. How am I supposed to cross-examine Zoom Boy? I'm not. Let them bring Zoom Boy in or whoever it is. They won't do it. If you don't like what's happening to you on a social media platform, if it upsets you, get off. Ms. Wade's has had several names on Telegram. I suspect under anonymous names, Ms. Wade reads everything I post. And I'm glad. Because if she reads everything I post, she's going to read the Bible. She's going to learn about Jesus Christ. So let her keep on watching. She's already lied under oath one time when she said she wasn't on Telegram, and then she got caught and had to admit that she was under some name in Jelly Belly or something. And she's got other names. I think Mr. Grunberg does. I think Mr. Wilson does. I think Mr. Bill could have people in his law firm that are in social media to capture what I say. Aha, we got him. He said something. So I'm not being fooled here. I know what's going on. This is not relevant evidence. The issue in this case is breach of contract, advice of counsel, and whether I had signed the agreement at the time, as I understand their theory, that at the time I executed the agreement, they claim I committed fraud because at that time, I did not intend to pay the money. That is a very, very narrow focus. And there's not one shred of evidence yet, nor will there be, that supports the idea that I had a state of mind at that time to commit fraud. The only fact that they have was what Your Honor mentioned at one of the first hearings. Well, Mr. Wood, you didn't pay. Well, there was a reason I didn't pay. But everybody that goes in and breaches a contract, in theory, that doesn't pay, that's a breach of contract case. It is not automatically a fraud case because you didn't pay. Everything that they claim I said before the date of March the 17th, they knew about it. Nothing was hidden from them. They knew what I had said, the positions I had taken. If they claim that it's somehow evidence of fraud now, they knew about it at the time the contract was executed.
Your Honor.
So I think, Judge, the last thing you want, and I want, and I would think they want, is to get a verdict in this case after many days and have it reversed. And there's error already in this case, I believe. This is just additional error that absolutely would require reversal if you let this into evidence. Thank you, Your Honor.
All right, thank you, Mr. Wood. So the specific question in front of me now is the admissibility of exhibits 230 and 231, which are similar in nature to exhibits we've already allowed in, showing what the plaintiffs contend are the result of the breach of the non-disparagement section of the contract. And I believe the plaintiffs are going to be entitled to pursue a theory of, as a remedy, that they should receive everything that naturally occurred as a result of the breach. And as they've indicated, and I think they showed in 215, which was admitted, apparently there was some awareness that on the part of Mr. Wood that there were replies being read by her that resulted from his posts. Whether it was every one of these, whether these people are bots or otherwise, I think that is an issue of fact that goes to its weight, not its admissibility. That's something for the jury to determine. It's something for you to argue in closing during cross and your testimony, should you choose to testify. But as to whether these exhibits are what they purport to be, I think Ms. Wade has laid sufficient foundation. As to relevance, I think I've already shared that as it relates to damages. And as to hearsay, again, it's not for the truth of the matter asserted therein that these people would go out and are going to do or believe all these terrible things. And I can instruct the jury accordingly that it would be for its non-hearsay purpose.
Exception to the hearsay rule that you're applying.
That it is not hearsay, by definition.
It's not an out-of-court statement.
I mean, I don't think we can.
It's the very definition of hearsay. You took evidence in law school.
I sure did, and I've got the book here that I can lend to you if you'd like it.
An out-of-court statement is hearsay.
All right. Well, there are certain
Look at the book,
aspects
Judge.
where it's not entered for
That's
its
why I
hearsay
said,
purpose.
What's the exception?
You don't need an exception if it's for its non-hearsay purpose.
What in the world is an out-of-court statement other than hearsay?
All right, Mr. Wood,
Unless it's
I can lend you some of these things if you'd like them, but for now we got to move on.
I've had them for 45 years. I know.
All
what
right.
evidence
Well, I'm
is. I
applying
know
them as
hearsay.
I've read them. Mr. Wood, we're not going back and forth on this
I'm
so
not
early in the
going back
day.
and forth
Well,
with you.
we kind of are. I've ruled and we need to move on now. I'm just explaining the basis for my ruling. What I would ask you now is if you would like an instruction of me telling them that it's not for the truth of the matter asserted, and I can put this for any other purpose that they find relevant, or we can confine it to what the plaintiffs are actually saying is its non-hearsay purpose. So
Well,
that I would solicit input on, but right now I've ruled that they're coming in.
but I don't want there to be any confusion in the record. It could not be an exception to the hearsay rule on state of mind. It could be an exception
Sure.
to the hearsay rule on their state of mind, but it would not be able to come in on my state of mind. I would have had to have seen it. I would have to know it existed for it to be in my state of mind. Their state of mind is irrelevant. It's not an issue in the case. So I know we disagree. I think it's fundamental black letter law that these types of statements from social media, from unidentified individuals, are out of court statements that are not only hearsay, they are blatant hearsay.
Deputy Scott, while I have you, can we check on the jurors just to make sure, see if they're all here or not? All right, so let me check with the plaintiffs. Is there, if I were to instruct them of the action, that it's not for the truth of the matters, but what it is for, would you have any guidance on what should be said there?
How about we give you a sentence? You weren't planning on doing it right at the beginning, were you?
Well, just when they're tendered, which
Okay.
it sounds like would be very soon.
We'll work on some proposed language right now.
There's no way I can come up with that right now. I'd have to have an hour break to think of, put something together.
I just don't think that's how this trial is going to work, Mr. Wood. I think we can come up with
It's
something.
not working very well for me. I'm not getting treated fairly.
I understand your position. I disagree.
You know my position.
I do. You've made it clear.
I know what's going on.
All right. What's going on is we're
So
moving
does
forward with
God
this trial.
And hey, Judge, and so does God Almighty.
Understood, Mr. Wood.
Reward you according to your works.
Well, how many? We've got them all? Okay.
I like that one.
So we think, Your Honor, just that it is not being offered for the truth of the matter asserted. Period. End of.
You can't offer anything that you think it is actually supposed to be geared towards.
Okay. We just thought that was the cleanest.
That is the cleanest, but it perhaps might be more accurate if we can say what it is actually offered for.
If we had overnight, we had some time, we could look at.
We can come back to
There
this.
may be some case law out there to put this kind of stuff in, and the court's ruled on it. I don't know. We haven't looked at it yet because I wasn't expecting it to be allowed in this trial. There may be something directly on point. When somebody tries to put in a social media post.
So if you'd rather delay on having a limiting instruction, we can do that and come back to it.
I don't think there ought to be any instruction. I think it ought to be ruled inadmissible.
I know we're beyond that point, though.
We are.
Yeah.
So what I would say, Your Honor, is something funny.
Nothing I've heard.
Somebody heard something.
I understand. Mr. Beal.
I've got a second sentence. We could say, it is also, it is not offered to prove the truth of the matter asserted, period.
That's exactly.
It is offered, to show, it is offered as evidence of defendant's intent and state of mind.
Thought we had said that this was for damages flowing from the non-disparagement.
Well, we thought that this was the absolute cleanest following Georgia law. And it goes to the state of mind, which then can create damages. But we don't want to just take it directly to the idea of emotional distress arising directly from this. We want to show the defendant's state of mind or intent, which would give rise to a possible claim for damages and for punitives and for bad faith.
So briefly, Your Honor, by definition, it cannot go to my state of mind. If they have something that I was aware of, then they can say, well, you knew this. Goes to your state of mind. They can't go in and come up with a bucket list of all these statements and claim that that goes to my state of mind because I didn't know anything about them. There's no evidence that I did. I see the statement that I made on Telegram. That does not relate to any specific post or whatever they claim these are from whoever they claim they're from. They are fake. They are creating fake evidence, and Your Honor should not allow it. They're trying to get evidence in so they can go get a multi-million-dollar verdict against me. I wish them good luck. Let them get it.
All right, Mr. Peel.
They're going to hold it on appeal because I know where the final appeal and final judgment in this case is going to be rendered.
If it's, I mean, the point if here in 215 is that even if he knew of some replies out there, how are you going to show that her private inbox is showing his state of mind if he had no idea what her private inbox looked like or that people were going to her private inbox?
First of all, Your Honor, he says specifically, I hope since she's reading, I hope she's reading the replies, acknowledging, and we got that in yesterday at the end of the day. I hope she's reading her replies, which means he knows that people are replying on a regular basis, and then they're reposting. And we got that in yesterday. What they send to her inbox, they're copying and reposting. Remember the whole thing about I sent her love letters, the kissy face, and I did this, and the copies of it. So they are sending it to her cell phone, then they're copying it over onto the channel where he's. And to the extent
they do not put it on my
Mr.
channel.
Wood wishes.
They do not put it on
to
my channel.
Go ahead.
That's a lie.
enter
Mr. Wood, we said we weren't going to interrupt each other.
I'm sorry, but that just to get
I
upset
need
when
to
somebody
be able
sits
to
there
go
and
ahead and
lies,
make this
bold faced
argument.
lies. That's a lie.
And
Drew Bill
you
is a
saw
lie.
it.
Mr. Wood.
I'm sorry.
All right, Mr. Beal. If you can remember.
I'm on best behavior today. I don't know. And
This is.
the what was I saying? Oh, yeah. So and we can show you the exhibits. It's 215 and 213. And if the defendant wants to say, I didn't know about that, cross-examine her and say, how could I have known about that? Or I'm innocent of any association with that. Isn't that just sort of what happens with every piece of evidence?
I mean, I've already said as much, Mr. Beal. So here's what I would propose is that it's not offered, these exhibits are not offered for the truth of the matter asserted, but to show if they, to the extent they do, evidence of the defendant's intent, state of mind, and any resulting damages from breach of the agreement, and leave it at that.
Let me make one other point.
If it's a new point, sure.
It is. At least I think it is. Not perfect. Nobody is. The state of mind at issue would be my state of mind at the time I executed the agreement. They claim that I committed fraud at the time I executed the agreement because I did not intend to live up to it. They don't have any evidence to support that, but that's another issue for another day. What my state of mind was a week later or 6 months later is irrelevant to the main issue in the case.
All right, fair point.
So I go back again.
Let me
It's
hear that,
just
Mr.
not
Beal. Why is this focus? I mean, I know we got the torches, let me just turn it over to you.
He's on the wrong cause of action. That's why. Because
Cause of action
the
alone.
breach of contract and fraud go to his intent at the time he signed the 317 agreement. This is the breach of the non-disparagement, which happens long after. He
Right.
doesn't write this prior to the agreement. Those were the other voicemails. He writes this months afterwards when he's breaching the non-disparagement.
And I think I would add too, you've got a 13611 claim that's
Sure.
premised on bad faith that could also flow from breach of the non-disparagement clause.
And after publication of this to Your Honor and to previous judges in this case, he continued to post it. And he continued to post it because it goes directly to his intent. And yeah.
All right, I think in our final,
May I add, Your Honor, real quick? He's right. I was focusing on this bogus claim of fraud in the execution. Now we got the non-disparagement. And we have litigated that issue before Your Honor in several motions, at least two. And I made it clear at the time, I didn't say anything until May of 2021, when I was representing myself and was attacked in my campaign for chair of the South Carolina GOP party by the allegations, false, that they had published in their original lawsuit that were heinous, salacious, irrelevant, and I was attacked for them. I think that was all planned, but nonetheless. So we go to Mr. Bill saying that I violated it. No, I did not. I have not walked even close to the line of disparaging these people after Your Honor entered your rule. But
okay,
again,
I think we're far afield from the issue at hand,
exactly
Mr.
what I was
Wood.
talking about.
I know, and I understand.
Point, and I'll wrap it up. Again, if I'm gonna be held monetarily liable based on what some unknown anonymous person wrote that may not even be a real person, I have to have the right to know who that person is. I have to be afforded the right to cross-examine that person. And here I am accused with people seeking millions of dollars. I'm sure they'll ask for it. Based on somebody who I don't even know who it is.
Now we're running in circles,
How
Mr.
you gonna
Wood.
hold me
So
liable
it's
for
time to
something
move
that-
on. I've
Somewhat-
tried to explain the basis of my ruling, and I think that I'm sticking to it. So I have the limiting instruction that I've already outlined, and you can preserve the issue when it's
I think I have
tendered.
majority. You don't agree?
I don't think there's any doubt of that. And I heard the jury is ready, so let's proceed. Ms. Wood, Ms. Wade, if you could make your way back to the stand, we'll resume with direct.
Yep, go ahead, Michael.
All right, for the jury. President Conklin.
Thank you, Deputy Scott. Please be seated, everyone. Plaintiff may resume the direct examination.
Thank you, Your Honor. Good morning, Nicole.
Good morning.
Yesterday, I think we ended off on a couple of telegram exhibits. I want to go back to plaintiff's exhibit 215 that was entered into evidence yesterday, and I'm going to give Michael a second to get that up for us. Thank you, Michael. And if we zoom in on plaintiff's exhibit 215, we talked about yesterday that these were two Telegram posts that defendant Wood posted to his Telegram group channel, if you will. I don't believe I asked you yesterday. Do you know when these were posted?
These were posted in June of 2021.
Okay. And all of the replies on the Linwood reply channel that we went through yesterday, I believe that was in plaintiff's exhibit 213, some here in 215, were those posted after the two Telegram posts that we're looking at here?
Yes.
And what about all of the direct messages we saw yesterday? Were those posted after these two Telegram posts from defendant Wood?
The direct messages that were sent to my Telegram inbox were sent. The initial bulk of them was sent within a few minutes after Lynn posted my name, after he doxed me. Yes. And then they continued to come after that, but they were all after.
And by doxing, do you mean this second Telegram post that we're looking at here where he gives your Telegram username or handle, if you will, out?
Yes, correct. And by that, they were also able to, I had signed up using my cell phone number. And so I didn't know even that was, people were able to see that. And so they also got my cell phone number and called. But so yeah, so it was those two ways that he doxed me.
Okay. And I'll direct your attention now to plaintiff's exhibits 230 and 231. Will you take a look at those real quick?
Yes, I'm familiar with these.
Okay, and in plaintiff's exhibit 230, in brief general terms, what are these screenshots of?
These are screenshots that I took of my Telegram inbox of the people. Some of them I took right after the ones that say today, and then some of them I took on June 16th, or you can see the date. But they're all from my my Telegram inbox. These are the things that the people started sending me.
Okay, and are all of these true and accurate copies of messages that you received to your Telegram inbox?
Yes, they are.
And going over to plaintiff's exhibit 231, are you familiar with what is in this exhibit?
Okay. Yes. Yes. I
And
am.
briefly, can you describe what's in plaintiff's exhibit 231?
231 is a copy of my inbox from my computer. You guys wanted screenshots of what everyone was saying, and there were hundreds. I couldn't screenshot them all. So I pulled it up on my computer and just took the inbox because you could see the preview. So when they posted memes or whatever, you couldn't see that, but you could see when the people said the things to me, you could read that. So I screenshotted from my computer, my Telegram inbox, and then I highlighted certain ones that were particularly disturbing and provided them to you.
Okay, and are all of these screenshots true and accurate copies from your Telegram inbox
Yes,
that you took?
yes.
Your Honor, at this point, I'd like to move to have plaintiff's exhibits 230 and 231 entered into evidence.
All right, other than the objections previously outlined for the record outside of the jury's presence, is there any other objection on behalf of the defense?
I want to make sure the record's clear that my objections have been stated outside the presence of the jury and don't need to be repeated now.
No, they are preserved. And so the 230 and 231 are admitted over objection. And I'll instruct the jury, members of the jury, as to these exhibits and to the ones that you saw yesterday with similar contents about social media posts. I'll instruct you that those posts are here intended for your consideration, not for the truth of what they contain, of the statements that they contain, but to show, if they do, evidence of the defendant's intent, state of mind, and any resulting damages. With that, you can proceed, Ms. Brown.
Thank you, Your Honor. Nicole, going back to 230, there's a lot of these, and I don't necessarily want to go through every single one of them, but some of them I'll just read out and direct you to. If we can zoom in on these, the first top two, Michael, please, on page 1. Thank you. Somebody with the name Mark Murphy sent you a direct message that says, "You fucking snake, we the people see you and your lies. We will not stop until you and your pack of wolves are put to the sword. You have nowhere to run or hide anymore. All of your lies will be revealed. Do you feel the heat? You should feel the fear of God now. We won't, it says we won, but I believe they meant we won't stop until we bring you to justice, TikTok." Are you familiar with this phrase here, all your lies will be revealed?
Yes,
And how are you familiar with that phrase?
that is Blenn's catchphrase, if you will. He posts it all the time. He has a meme that it says it like under his picture. He puts it up all the time. All eyes will be revealed.
So I object to her making that my catchphrase. That's from Luke 12:2. Those are the words of God.
All right.
And I'm just repeating what the Lord God.
Your
Almighty-
Honor,
I think that's
this is
something you can
speak-
take up on direct. And Mr. Wood, that is a speaking objection. I'll ask you to refrain from that going forward.
Thank you, Your Honor.
Overruled.
The one beside it from somebody named Penny Griggs says, "Nothing can stop what is coming, Nicole. You mess with the wrong child of God. I'd be scared if I were you." And then does anyone on this first page of Plaintiff's Exhibit 1 specifically reference your deposition that we saw Lynn post about yesterday?
Yes, and I think that's what the reference to "I'd be scared" was as well. But yeah, and then the bottom one says, "Why didn't you show up to give your deposition?"
And going on to this next page, this first one, I'll read it. This person, Easy E, sent you a message saying, "Pathetic loser, you don't deserve to live, air thief." It's on page 2, Michael. Thank you. When you received this message, how did this one make you feel?
Well, this guy had posted on Lynn's reply page as well and said that he had sent me a message. He's one of the guys who did that, who had said he had sent me a message and went back and
I'm not sure
reported.
This is not from my reply.
Speaking objection again, Your Honor.
So
Mr.
she's
Wood.
taking a message.
All right, no,
I don't
I'm talking now, Mr. Wood, so I want to give you some direction. Whenever you make an objection, I need you to refer to the rule that you're objecting over. You can stop there, and then I may already be able to rule. And then from there, we'll go forward if I need further information. So what is the rule you're objecting under?
Hearsay and lack of authentication and relevance, because
I don't need a because. I don't need a because. I haven't asked for a because.
Explain it, Judge.
No, you don't need to
This
because
is
I've already
fine.
heard, Mr. Wood, I'm directing you to sit down. I've already heard these arguments. And to those grounds, as to this exhibit, I've already admitted them. You can
Well, then
proceed.
I move-
Thank you, Your Honor.
Ma'am, I move to strike her testimony that these direct messages that she's received somehow came from my reply channel. There's no evidence.
All right, that is denied. You can proceed.
Thank you, Your Honor. Nicole, I believe you were saying something about Easy E and how you're familiar with this individual that sent you a direct message here.
Yes, this person, and this, to be clear, is from my Telegram inbox. But then this person, like many of these people, went back onto the Linwood reply channel under he had several posts about Jonathan Taylor and me and our pictures and everything else. But so they went back to those posts and would say, yeah, I sent her this message. I sent her that message. And he had sent me another one too at some other point, but he's one of the people who went back and reported that he had direct messaged me. And
So
so
similar.
I knew he was someone who was doing it because of what Lynn had posted.
So this individual here is similar to the Dave individual we saw who sent you a direct message yesterday, who then went back on the reply channel and said that he sent you a message.
Yes.
Okay. And if we go over to the next one, Carolyn G at the top says you're a correct POS. You're going to jail. Karma is a bitch. Bye-bye. You will be worm food. Somebody with the screen name Foom says, hey, you're a stupid cunt bitch. Are these the types of these sentiments, the types of responses, excuse me, the type of direct messages you received from numerous individuals?
Yes. Hundreds.
I know yesterday we saw some responses on the reply channel talking about taking turns and sloppy seconds. Were there other direct messages that you received that you perceived to be threats of rape?
Yes. And other things. I mean, the ones of people hanging by a noose or I mean, yes, I took a number of these to be threats.
If we go to the next page, are the bottom two on this page 4 of this exhibit, are these the noose examples that you're referring to?
Yes, and these, when they came, they actually, they're GIFs. I don't know how you say that. So the guy, the guy down here, he was like swinging it's just really gruesome. It was, yeah. There were worse popping up on my phone and little beat up dead guys swinging. Yes.
And a lot of these, I believe you said, were received shortly after Defendant Wood posted your Telegram handle on June 16th. Is that
Yes,
correct?
within, I mean, all that day, I just was receiving them, just one right after the other.
And how did that make you feel to receive so many back to back like this?
Well, it was threatening and it was very disappointing because this is the kind of thing we had tried to prevent. We settled with Lynn. He wasn't supposed to be disparaging us, and it was awful. I couldn't believe he was doing this to us.
And if we go over to the following page, Michael, page 6, the top 2 messages, please. Thank you. The top 2 messages here, one from Allison says, hello, we missed you at the deposition. Was it too scary for you? Perhaps you should drop the lawsuit. And Bob says, why did you not show up for your deposition today? I am filing an ethics complaint against you with the Georgia State Bar. Seems you're scared, right? Panic. You seem to have bought off or something, excuse me. What about your moral commitments you took as a lawyer? The world is watching you. You will now see how we, the people, expose corruption. How did, well, one, do you know who Bob or Allison is?
I do not know these two, no.
Okay. How do you believe that these two individuals knew about your deposition?
Because Lynn had posted, we were supposed to have our depositions taken in this case. That week, those days, Lynn had posted about us the week before. He hadn't doxed us then, but he had posted our pictures. He had posted about us. And people had started making threats like this. People had started calling our law firm. People started emailing us. Our receptionist was getting messages. And then he posted a picture of the place, of the building where he was going to take our depositions. And so we were nervous, and we filed a motion with the court. And so we were very nervous. So he showed up and did a videotape of us with an empty chair and making fun of us, and he posted it online. And so that's what, when he said maybe she wanted to see her deposition, he had posted the video. And so these people are all saying, we missed you at the deposition. That's what Lynn had been posting about that day, was the deposition.
And you and Jonathan and Taylor were all eventually deposed in this case, is that right?
Of course.
Okay. And
We did it at the Georgia State Bar where there was security.
and is that because you guys were scared?
Yeah.
And this Bob individual referenced filing a bar complaint, an ethics bar complaint against you. Did you receive any bar complaints against you during this time?
Yes. I don't even know how many of these people actually filed bar complaints against us, but it was a lot of them. They were all dismissed by the bar out of hand, but that was also a little nerve-wracking. I had never been attacked before or had a complaint or anything like that, so none of us had. But yeah, these people, when they said they were going to file a bar complaint, they did. And you saw Lynn posted that. He knew it. He said it.
And as a lawyer, having a ethics complaint filed against you, how did that make you feel?
Well, it threatened my entire livelihood. I mean, I don't want to be reporting to the bar. That is the worst thing that you can do, is report someone to the bar for something, right? I mean, he said he was going to try to get us disbarred, which would mean we can't practice law again. Now, I knew there was nothing to any of this, but at the same time, that was horrible. Absolutely horrible. And he knows we're good lawyers, and he knows we're ethical.
Objection to that move to strike that. She doesn't know what I know.
I'll sustain. You can move on to the next question.
Yes, Your Honor. We also see this Bob individual use the phrase, "we the people." Are you familiar with that phrase as well?
Yes, that's a phrase that Lynn uses all the time. We the people, or you the people.
And did you receive other messages from direct messages to your Telegram inbox using this phrase, "we the people"?
Yes.
And can we go over to page 8, please, Michael? The bottom two. Thank you, Michael. Is this example of a direct message from Annie Crazy Cat Lady one of those such examples that you're talking about?
Yes.
And she says you can run, but you can't hide. We, the people, in all caps, are in control. Bye bye, Nicole. What did you perceive this message to mean?
I took it along with all the other messages that it was a threat.
And again, I don't want to go through every single one of these, but because there's so many in this exhibit and we can scroll through them if needed, but were there other direct messages sent to you talking about your livelihood and a career as an attorney?
Yes, other people said that they had filed bar complaints. Other people said that our law practice was going to be, destroyed. And there were a lot of messages along those lines. A lot of people said, I'm filing a grievance with the state bar against you.
And if we look at the first one on page 9, I believe you're already there, Michael. Can we just zoom in on that? From somebody named on Telegram, Trump Girl. Can you read this one into the record, please?
Nicole, you are a disgrace to humanity. You were dishonest, a cheater, a coward, and an untrustworthy lawyer and human being. I hope you drink from your own venom and get what you deserve. Leave Lynn Word, I think it should say Wood, and all honest people alone, or you will answer not only to we the people, but most importantly to Almighty God. It does not matter if you believe in him or not, that's your prerogative. But our Lord does exist, and sooner than later, you will get repaid for all your skims and lies. Repent before it's too late, fix your ways, and ask God for forgiveness, and you may have a shot at a peaceful and happy life. Otherwise, be prepared for the wrath of God. No one escapes it.
And did you receive other messages in addition to the one we see here from Trump Girl, where defendant Wood is specifically mentioned by name?
Yes, many of them said, stop going after Lynn Wood, drop your lawsuit against Lynn Wood, things like that.
And if we can go over to Plaintiff's Exhibit 231, please, Michael. And if we can zoom in, Michael, on the first highlighted ones down. I'm just gonna read some of these that are highlighted. Why didn't you show up at your deposition with Lynn Wood today? He's a God-fearing patriot that never loses because he speaks truth and God's got his back. I wish. And it continues. Somebody with the screen name American Bacon says you're canceled. Another individual, Kathy, says pray for forgiveness. Nicole, Patricia says good luck with Lynn, better come clean. Another individual, Boyes, says where the hell were you today? Running from something. You can run, but you cannot hide. God wins. Lynn wins. If you don't see the error of your ways and cease. And it continues. And we can just scroll through the next page of the highlights, Michael. Nicole, these pictures in 231, they look different than the pictures in 230. Can you explain to us what the difference is now that we're seeing them?
I think that's what I was trying to explain before, and it may not have come through, but this is me going on my computer and pulling up my Telegram and my inbox. So this is just what it looked like if you just didn't open the messages. And after a while, I didn't want to open them because then the people would see that I had opened them and they would write back to me again. So I stopped opening them. But this just gives you the first line. And then like the ones that say sticker, it didn't show up in the picture, but those are the ones like the hanging person or the person plugging in something and then getting fried. That's what like the stickers or some of them. One woman sent me one that was like, panic. Those sorts of things. That's what the stickers are. But I didn't open them and take a picture.
And approximately how many messages to your Telegram inbox would you say that you received?
I had counted them at some point. I don't recall. Hundreds, a couple hundred. I don't remember. I don't know. Page after page.
Would it be more than what's listed here in Plaintiff's Exhibit 230 and 231?
Yes, I took these. This was just like 2 days after he had doxed me. I mean, they continued.
In all of the posts that we saw that defendant Wood posted on Telegram that we spoke about yesterday, were they all posted after the execution of the March 17th settlement agreement?
Yes.
What about all of the responses on the Lynn Wood reply channel? Were they all posted after the execution of the settlement agreement?
Yes.
And what about all of the direct messages?
They were all after the settlement agreement.
And I believe I asked you this earlier about the responses and direct messages we saw yesterday. But as to the direct messages we looked at today on 230 and 231 and everything depicted, were these all received by you after the post of in June 2021 where he gave out your Telegram username?
Yes.
Yes.
Plaintiffs have nothing further at this moment for Ms. Wade.
All right, cross-examination.
Good morning, Nicole.
Good morning, Len.
What is your date of birth in the flesh?
Objection, Your Honor.
Give me the grounds. Yeah. Sustained.
Her birth date?
We don't need her birthday. You can ask her.
How old are you?
Sure.
How old are you?
Same objection, Your Honor. Relevance.
You ask a witness, every witness, where's your address? How old are you? You married? It's a legitimate background question. I've got her on cross-examination. I just simply ask her what her birth date was and how old she is.
You can ask her age. You can proceed.
54.
So you were not that good at math.
It doesn't matter the year she was born. I can't see that.
I'm sorry.
Well, the year she was born, is that you're trying to backdate it?
I was trying to relate it to when I was born to see the age difference between us.
All right.
I mean, just tell us if you don't mind. What year were you born?
You're 18 years older than I am.
I was born in 1952.
I know.
860. So you were born in 1970.
Yes.
Is that right?
Yes.
7 years before I graduated from law school. Right?
I don't know if you say so. I don't
Overruled.
know.
What was your answer?
I don't know. I don't recall what you're used. I mean, I don't know. I didn't know you then. I think that's right, but I don't know for sure. If you say so.
So born in 1970, right?
Yes.
When were you reborn?
Objection, Your Honor.
Sustained.
Relevance.
On what basis? What's the objection?
Relevance.
To whether she's been reborn of the spirit is irrelevant?
Yes, that is relevant to this trial, Mr. Wood. I direct you to move on.
Well, let me ask you a different way. Have you been reborn?
Sustained on the same grounds, Mr. Wood. Move on. And if you continue this, you'll forfeit your cross-examination.
Continue what?
Asking irrelevant questions that I've already excluded.
About faith?
That's true. That's correct.
We live by faith. We're supposed to.
Keep going, Mr. Wood. We'll see what happens.
Matt, may I?
No, continue your cross-examination.
You attributed the statement, every lie will be revealed to me in your direct examination, right?
I said it was your catchphrase.
For there is nothing covered that shall not be revealed, neither hid that shall not be known. Therefore, whatsoever ye have spoken in darkness shall be heard in the light. And that which ye have spoken in the ear in closets shall be proclaimed upon the housetops. Are you familiar with that?
I am.
So overruled.
I am.
From Luke 12, verses 2 and 3.
I know it's from Luke. I can't quote the chapter and verse.
So it's
but
the word of God
yes,
that every lie will be revealed.
yes,
Do you believe God?
I do.
So you know every lie will be revealed.
Do believe that.
You understand the sanctity of an oath.
Do.
When did you join Telegram?
I don't. Still tied to my cell phone number, but now people can't see my cell phone number. Whereas at the time, before I learned how to do it, when they clicked on me and they went to my profile, they could see my cell number.
Did you not see when you joined that there was a specific statement that said whether you wanted to block your cell phone number or not? You didn't see that?
I didn't notice that, no. I didn't. If I did, I didn't see a reason to block my cell number. I wasn't trying to hide.
Well, I think most people block their cell phone numbers on social media, but nonetheless, you didn't block yours.
Obviously not.
So you made your own phone number public.
Apparently so.
Now, have you ever been on Telegram under any other account name other than, is it Nellybug? What is it?
It's my first two initials, NJ, and then Ellie Bug, which was what I called my dog. Her name was Ellie. I would call her Ellie Bug.
Have you been on Telegram under any other username other than NJ Ellybug?
Yes.
What other names did you have?
I set up another account called Jan Brady.
I'm sorry?
Jan Brady.
Jan, Jan,
Mm-hmm.
last name Brady,
Yes.
Brady.
Yes.
When did you set up the account under the name of Jan? Your name's not Jan Brady.
No, it is not.
So when did you set up the account under the name of Jan Brady?
I don't remember that. I don't remember when I set that up. I don't know. At some point.
Well, was it
At some point in the
before-
last couple of years. I don't recall.
So the last couple of years. So were you first on In Jellybug and you say that you joined that at the time that you knew that I joined Telegram?
Yes, that was the only reason I joined Telegram was because I knew you had joined Telegram. Maybe you had posted that on Parler or something. I don't recall. It was for that purpose, so it was sometime around that time frame.
Why did you want to follow me on Telegram?
I've always followed you on Twitter. I followed you on Parler. I wanted to follow you on Telegram.
So then sometime a couple of years after make sure I'm clear on this. So you chose not to put your real name up. You put up In Jellybug.
NJ Ellybug, yes.
Ellybug, I'm sorry. So if somebody saw a post on Telegram by NJ Ellybug, they wouldn't have any clue who it was. True?
True.
You could say things about people. Mean things. Defamatory things. Threats. Under the username Jellybug, and nobody would know it was Nicole J. Wade, would they?
I didn't do
I
that,
didn't say that. I asked
but
you.
I suppose you could, sure. I mean, at first they could trace it back to me because they could see my cell phone number, but after I learned how to block that, then correct.
How long did it take you to learn to block your cell phone number?
Took me a couple of hours after I started receiving messages on June 15th.
Did you receive any messages today?
I don't know. I don't have it now. I also at that point had it, I guess when you sign up, it gives you, it would like automatically pop up when someone messaged me. I figured out how to turn that off as well. So I don't know. I could have.
When was the last time you looked at your Telegram account?
I looked at it, I think after you posted my picture this weekend, I looked at it.
It's a good picture.
One we've seen up here. It's the one you've posted several times now.
You posted it on your website.
I know,
You made it public.
I know.
I think it's a very attractive picture. Don't you agree?
It's fine. I was younger then.
You're not telling me I did something wrong because I put up an attractive picture of you and said, this is Nicole Wade.
I don't understand why you would have posted my picture.
Because I made reference to this lawsuit, but not to you directly. And I put up your picture. Didn't say a word about you, did I?
Think you did, but nonetheless, you put
Show
up
me
my
what I
picture.
said then. If you think, let's find out.
I don't recall exactly what you said, Lynn.
So you don't know what I said.
I don't recall.
So let's go back. Do you still have the account under Jan Brady?
I do.
Have you ever had any other accounts on Telegram other than NJ Ellibug and Jan Brady?
No.
I'm sorry?
No.
Do you have any other, do you use any other social media accounts other than Telegram?
I have a Facebook account. I have an Instagram account. I have a Twitter account.
Well, it's X now.
I have an X account. I guess I still have a Parler account. I don't know if it even exists anymore. I can't think of any other social media.
Or you're on Truth Social?
Truth Social. I think I set up an account there, maybe, or
I don't know. I'm just saying. Truth Social was the social media platform linked and founded by President Trump.
I don't remember. I remember going at some point to set up an account there. I think I did. I just don't recall.
What name did you use there?
I don't recall.
On Truth Social, you had to identify who you were by name. Did you know that? So that the people at Truth Social, no matter what username you pick, they know exactly who you are. Did you know that?
Objection, Your Honor, lack of relevance. There has not been any Truth Social posts coming in to evidence.
Well, she just said she was on it, so I'm questioning her about it.
All right. We can go a little bit down that route, but I don't think we need to explore the nuances of social media platforms that aren't at issue here. So I'll overrule the objection for now. You can renew it if we continue.
Thank you.
I don't recall.
Do you know whether Jonathan Grunberg is on Truth Social?
I have no idea.
Do you know whether Taylor Wilson is on Truth Social?
I have no idea.
Do you know whether Jonathan Grunberg is or has ever been on Telegram?
I know he has been on Telegram.
And when did you learn that he was on Telegram?
I don't know. At some point after you started posting things about us, we went to see what you were posting. I think we all had accounts.
And what was his username?
I don't know that.
We'll ask him. To your knowledge, was Jonathan on any other social media platform other than going on to Telegram to see what I was saying?
Jonathan has a Twitter account, and Jonathan has an Instagram account, and Jonathan has a Facebook account. I don't know what else he has. He may have others. I don't know.
And you don't know how many accounts he may have on Telegram?
I have no idea.
You recognize that you could subpoena Telegram and learn information about the users.
Objection, Your Honor, relevance.
Overruled.
That you can, I'm sorry, what was the question
You
again?
could subpoena Telegram
Oh,
to
subpoena
get
Telegram.
information about people that are posting on it. You know that.
I guess you could. You'd have to have an action, I think, that involved that. I don't think Telegram would give you that. But
Have you ever tried?
I mean, in other cases, we've tried to do that. Not in this case. Are you talking about this case? Not in this
I'm
case.
talking about this case.
No,
Now, do you know what name, is Taylor still on Telegram?
I don't know.
Do you know what username he used or uses on Telegram?
I don't know.
Do you know how many accounts under different names he has on Telegram?
I don't know.
Do you know whether Mr. Bill or anybody affiliated with his law firm is on Telegram.
I don't know if they are. I don't think so because I don't think so, but I don't know that for a fact.
And you don't know what username Jonathan has on one or more of his accounts on Telegram. You don't know his username?
I have no idea. The only thing I go on there for is to look at what you post. I have no idea. You don't like have friends there like you do like on Facebook, but I don't know.
Do you go on Jonathan's account on Instagram or Facebook or to see what he's posting?
Objection, Your Honor. Facebook and Instagram have not come into this case. Seem relevance grounds.
Mr. Wood, we leading to an area of relevant, you want to respond to the relevance? Just briefly?
They have made postings on social media platforms part of their case. I'm entitled to a thorough and sifting cross-examination on their knowledge of social media platforms and their involvement on social media platforms.
All right, overruled.
Thank you.
Do you want me to?
Do you,
Sorry.
go ahead.
Oh, I didn't know if you wanted me to answer that question. I'm sorry. Go ahead.
You read the question back, please, Mr. Reporter.
You go on Jonathan's account on Instagram or Facebook to see what he's posting.
I had never done that until you took pictures from his Facebook and posted them on Telegram. And so then I went and looked at his Facebook. Well, I didn't know where you had gotten them. So I went and looked at his Facebook and his Instagram after that. Before that, I had not looked at them, no.
You don't know where I got them because I'm not on Facebook or Instagram.
Well, you have accounts and I don't know where you got them. I know you have accounts. You have an account on Facebook.
Oh, that account hadn't been activated in 14 years. How
Yeah.
do you know I have an account on Facebook when I know I haven't had one in 14 years?
Because you have one on there. I mean, I think we're still friends on there. I don't know. I don't know.
Well,
But I know that the pictures that you posted were on Jonathan's, I think it was Facebook or maybe Instagram. And so the answer to your question is, after you posted those, I went and looked, and that's the only time that I had looked at
and you
his
found that the
postings.
pictures that I posted had previously been posted by Jonathan Grunberg himself publicly, didn't you?
Yes, I did.
Now, how much time do you spend on average per day on social media?
I mean, per day, it would have
On
to,
average.
none to a minute. I mean, I don't know over what time. I mean, I'm not on social media very much.
Except to look at what I post.
And I don't even do that anymore.
When did you stop doing that?
I don't know. At some point after your number of followers dropped to, I don't know, 500,000 or something. After that, I stopped.
You know, the numbers on my Telegram page have dropped significantly.
Yes.
Do you know why, in terms of how many people we have discovered were bots and shills and propagandists, and we got them out?
Objection.
Did you know that?
Objection, Your Honor. Lack of foundation assumes facts not in evidence.
If you want to rephrase the question, Mr. Wood.
Do you have any knowledge yourself as to how many people that follow me on Truth Social or Telegram have been deleted or banned by my administrators because they thought they were bots, shills, or propagandists?
Objection, Your Honor, calls for speculation.
She's monitored his platform. She either knows or she doesn't. Overrule.
I only know what people have said back to you or what people have sent to me. I've had people reach out to me about it. So I don't know.
Who has reached out to you about it?
For example, Tammy Shaw, whose name was up there yesterday, who was laughing at some of the horrible things that were said
What did Tammy Shaw reach out? When did she reach out to?
last year and said that she was very sorry, that she realized that she had made a mistake and that you were not who she thought you were, and that she apologized for the horrible things that she had said about us. And was
Do you
she?
know who Tammy Shaw is?
I had looked her up initially because she had been one of your most faithful, posted all the time. And so I found, I was able to find where she lives. And I mean, a bunch of these people I was able to
Where
find.
she lives,
Yes,
her address.
yes.
Were you aware of the fact that my admins banned Tammy Shaw despite all the nice things she said about me? Because they determined that Tammy Shaw was a.
Objection, Your Honor.
Yeah,
Please
Mr. Wood, do you have
testify.
any good faith basis to think that she would know any of these things?
I'm sorry?
Do you have any good faith basis to think that she would know these things?
Yeah. I think she knows a lot about Tammy Shaw.
About your admins, though, and how Telegram has
Well,
treated your
I'm asking
platform.
if she's aware. She said Tammy Shaw was a supporter. Tammy Shaw turned against me apparently. And I'm asking her, was she aware of why Tammy Shaw was banned?
And why would you think she would be aware of that?
I don't know. She may have talked to Tammy Shaw. She's apparently communicated with her.
All right, well, you can start there if you don't have actually a basis for thinking
Well, I'm
why she
trying-
would know it.
I was trying to start.
Otherwise, you're injecting facts into your
No,
question that have
This is
been.
not a fact. Do you know why Tammy Shaw was banned from my Telegram channel?
I don't know that she was. She emailed me and said that she had seen the error of her ways. I don't know. I don't know if she was banned. I don't know if she stopped following you. I have no idea if anything she said was true. All I know was that she apologized.
How did you get her address?
I Googled her. I went and I looked up a bunch of these people.
On all these social media messages that you've tendered into evidence, where people were threatening your life, right? And
I felt that they were threatening
you
messages.
put in those messages, you read something on Telegram or wherever you go, and they said they were making threats against you, right?
I felt like they were threats, yes.
They were real threats,
I was concerned that they may be real threats, yes.
threatening to gang rape you. Did you take that as a real threat?
I did, Lynn, yes.
Well, it's an abomination that people would do that, but the point is, it struck you as real.
It's an abomination that people would allow that to remain on their social media pages without having their administrators take it down, especially when they know that that is triggering to someone.
Well, let me go back now, Judge. She's opened the door. How do you know my administrators do not take that kind of nonsense down? We don't allow it.
Because you didn't take these posts down.
How do you know they were on my reply channel?
Because I saw them on your reply channel.
Did you bring it to my administrator's attention? Because we can miss things.
No, we brought it to your attention.
Did you know that I had given specific instructions to my admins to immediately remove?
Objection.
Yeah, which unless she was part of that conversation, you think she was, how would she know?
I just asked her, do you know? I got to lay a foundation.
I think it's
I'm being
phrased.
blamed for what anonymous people put on my reply
Sure.
channel. And I'm simply asking.
But this witness has no knowledge of the things you're asking her. You can get it through your testimony if you choose to testify, but
I don't know if she does or not until I ask her.
she said she has no idea already what your administrators do. I think that was already your testimony.
You have no idea that
mind
my
answering.
admins ban users from Telegram,
Well,
my accounts.
I know that they do because I know they banned me the one time I tried to post on
So
there.
you do know that they ban.
So I do know that they ban people.
So
Or they or you, I don't know who did it.
Do
I
you-
know that someone who has control of your channel banned me.
I believe you're right, and I believe I know exactly why. So you know that the admins ban people from my channel. Do you know what instructions I give them on who to ban if they see something posted that I believe is inappropriate?
I do not.
How many real threats of harm do you estimate that you have received as a result of what you believe is what I said about you and Jonathan and Toby? How many real threats would you estimate you received? Just an estimate.
I don't know, Lynn. I consider all of, I mean, I don't know which person who sends a picture of somebody hanging from a noose. I don't know which one. There were a lot. So I considered that at least some of them, at least one of them, it only takes one. I considered that at least one of them could be a real threat.
Well, I didn't ask you that. I asked you, could you give the jury an estimate, your best estimate, as to how many quote unquote real threats you believe you received on social media, including apparently your direct mail? Just a ballpark.
I don't know. Why would you let us receive any? I don't know. I don't know. Hundreds. I don't know. Dozens. I don't know.
Dozens, hundreds, or thousands?
I don't know. It's not thousands, less than thousands.
So dozens or hundreds?
Yes.
Now, of those alleged real threats, that you thought were real threats, how many of those have you taken to law enforcement for an investigation?
I have, I mean, you know the answer to this. I've consulted with law enforcement. I have not filed complaints.
So you filed no complaints with law enforcement about any of these alleged people threatening to gang rape you? I guess you took it they were gonna hang you by a noose. And you took those as real threats, but you did not file any complaints with law enforcement, am I right?
That is correct.
Now, you've been involved, and your website says so. You've been involved as a lawyer in social media lawsuits.
Yes.
You worked with me on a matter for Joel Warnick, the former CEO of P.D. Putney Memorial Hospital.
I did. Yes.
You did. And you knew that one of the problems we were looking into for Joel is that someone had circulated on social media or otherwise cartoon of him at the hanging of a black person in a KKK robe.
Objection, Your Honor. Relevance calls for speculation, lack of foundation.
Well, if we can get to the point you're trying to make, Mr. Wood, understand, I think where you're going with this, we'll get there. All right, overruled for now.
Did you knew that? You remember the Phoebe factoids?
I do recall that. I don't, not in detail, but yes, that does ring a bell with me. Yes. I remember the Phoebe factoid thing. Yes.
So Joel Warnick, when he felt that he was being defamed on social media or in the community by distributions of faxes, he hired me to take action, right?
All
Objection, Your
right,
Honor.
we don't need the full factual history of some other claim. If there's a point you're trying to make as it relates to this case, let's go there.
That's exactly what I'm doing.
Well, we're taking a bit longer to get there, so I'll ask you to get to it. I have the discretion if I feel it's under 403, we're not being as direct as we need to, so please get there.
So trying to get there as quickly as I can. And I don't think I'm being, Your Honor, with all due respect, this witness has been on the stand for a number of hours. And I have the right to a thorough and sifting cross-examination. And I know it's subject to your limitations on time. I don't think you'd cut me off. That at least give me enough time on cross that she had on direct. So I know to make my time well spent. Thank you. I'm simply trying to reach this point. If you had felt seriously threatened by anybody's post on social media, you knew as a lawyer that there were steps you could take to investigate those posts and that there were legal remedies available to you against the people that posted them, both civil and criminal. You knew that, didn't you?
Yes.
But you didn't do anything, did you?
That's not true.
You didn't file a criminal complaint.
That's correct.
Did you investigate and file any civil complaints for defamation?
Yes,
How many?
not against other people.
Well, no, I'm asking you, how many? I'm asking you about the people that you say threatened you or defamed you on social media, all these
De-
exhibits,
defamation.
excuse me, all these exhibits.
She's
you put in-
objecting. She's
I
objecting.
wasn't through.
Well, the question may be objectionable as already stated. So
Well,
what's the grounds for the
I think the record
objection?
would allow me to complete the question before it's.
Not necessarily, Mr. Wood, and you haven't extended them the same courtesy. So I think I want to hear the
I've
objection
extended them.
first.
I haven't cut them. I haven't,
Mi-
I don't know what you mean, Judge.
All right, if you could approach on that. All right, defense may proceed.
Try again. Just so the record is clear, of all the people on social media that you've, and I'm limited to the people, not me right now, but all of these other posts that you've put up into evidence, have you ever used your legal training and experience to investigate who these people were, to sue them for the heinous things you say they said about you? Have you ever done that?
I investigated some of these people, tried to figure out who they are and where they lived.
Did you find out?
I found out for some of them.
Who did you find out about?
I found out the guy who was up there yesterday, Tim Arkbauer. I don't know how you say his last
Yeah, that
name.
was up here.
I mean, that was up here. One of the guys who had posted some stuff. You saw the one, Dave. I couldn't get any information about that, or the smoke guy, as you said, whatever his name was. I couldn't find anything about them.
Couldn't
The
figure-
ones that
Couldn't figure out who in the world Dave was, could you?
correct. The ones I did find, none of them lived in Georgia. And so after consulting with some people we know, I believed that there was nothing I could do legally with respect to complaints against those people criminally because they don't live in Georgia.
After consulting with who?
Someone that my boyfriend knows who worked at the GBI.
And who is that individual?
I don't know his name.
Did you meet with him?
No,
Did you show him the text? Did you meet with him?
no,
Did you show him the text or the post?
Bobby did.
So you didn't have any direct contact with Bobby's friend at the
No.
GBI?
No,
But you got names and you had addresses on upwards of 9 or 10 of these people, right?
yes, plus the people who filed, I forgot this, but I didn't have them at the time, but the people who filed bar complaints, they had to give their address.
So
So-
you knew their names.
So we had their names and addresses only after the bar had dismissed their complaints. But then they sent a letter to the people and we were copied on them.
So we've got the 9 or 10 that you identified by address, you say on social media, right?
Yes,
And then we've got how many that you say file bar complaints where you knew their name and address?
I don't know, there were a dozen, I think, I don't know, dozen, something like that.
A dozen? Okay.
Maybe more, I don't recall.
Best recollection is a dozen, right?
Yes,
With respect to any of these people that you identified on social media, 9 or 10, or the dozen, 12, that you knew about from the state bar, you with me?
yes,
how many of those individuals did you take any legal steps to redress what you claimed was the harm that you had suffered by what they had said or done?
Action against those people?
Yes.
None.
You could have written them a cease and desist letter, right?
Guess. I mean, I guess.
Well, you know that that's one of the first things a lawyer will do sometimes is to say, you're making these statements. Stop it. Or I'm going to sue you.
Well,
It's a cease and desist letter, right?
but what we did was ask you to stop it. That's what we did. We asked you to take them down and you wouldn't.
Nobody asked me to take anything down.
Yes, we
Nicole.
did.
Do you have any documentation of that?
Yes, I do.
What is it?
We filed documents with this court asking that you take these down. We had a hearing right here. I sat right here and you cross-examined me about it,
So we've
about this
already-
exact same thing. And you've left them up for, I don't know if they're still up. You've left them up for years, Lynn. You left these things up for years.
Prove that. Show
Yes,
me one.
I
Show me one.
can.
Show
I
me one.
saw them.
Show
You've
me
never
one.
denied it.
So you came to me and me only.
Yes, it's
as
your
part-
it's
as
your
part-
page.
As part of a hearing court on this very issue, right?
More than once.
How many hearings have you had in court on this issue besides this one?
2 or 3, I don't remember.
What courts?
This court.
Any other courts?
Objection, Your Honor, relevance.
I think as,
Not on these.
well, hold on, there's an objection.
Oh, sorry.
I think as we discussed our last bench conference, we need to confine the question to something we haven't already addressed by motion to eliminate.
So in this court, you raised the issue of disparity, right? In 2 or 3 hearings, right?
We raised the issue of the threatening posts. We filed a motion for protective order with respect to our depositions because we were nervous because you were posting our picture, you were posting our firm address, and where the depositions were going to be held. We filed a motion for protective order asking this court to not make us go to our depositions until we could do it in a secured location because we were nervous.
And you never got a ruling from the court.
Well, you filed a motion against us after that for, I don't know, all kinds of things, contempt and to dismiss the case. And eventually we were able to have our depositions taken at the state bar, which we felt was a more secure location. And so we did that. That's how that happened.
So I want to talk about the disparagement, where you said there'd been 2 or 3 hearings on these issues about you being disparaged on social media, for which you seek to hold me responsible. You say you've had 2 or 3 hearings that covered that, didn't you?
Yes.
How much money have you?
Objection, Your
received?
That's sustained, Mr. Wood. We've already handled this in pretrial motions.
Not this issue.
I think, well, if you want to approach and explain to me, I sure think we have.
Oh, she brought it up. It's the one that said so, Johnny, you did. No, I did not. She brought. I don't know. That's what I thought about now. She's one of the rules. She opened the door and said she's going to do those. So. No, she said one of the hearings was where they saw.
Brother. I was saying, if the jury doesn't hear this, they're not trying it. I mean, come on. It's gotta-
So, no statement. Not only they were included. Oh, I think absolutely. I think they're relevant to my position. Thank you very much, Judge. May I proceed?
You may.
Thank you. Jan Brady. Where'd you come up with that name?
Brady Bunch,
I'm sorry.
the Brady Bunch.
So you took on Jan Brady from the Brady Bunch and used her name on social media, on Telegram.
Yes,
Now, under the name of Jan Brady, you could say anything you wanted to, and they wouldn't know it was Nicole J. Wade, would they?
no,
You could go out and attack somebody or disparage somebody or threaten somebody under the name of Jan Brady, a fake name, and the person that's attacked or disparaged would not know that that was Nicole Wade, right?
right? Unless I told them.
Do you not think that that's absolutely true with respect to some of the many fake names that you have put into this courtroom in evidence? Names so fake, 66861 Form Halls, FORMHALS. Great Experiment. Do you know who Great Experiment is?
No clue.
Crypto Spider. Do you know who that is?
No clue.
Bob.
No clue.
Ivar the Boneless.
No clue.
Bellaby.
No clue.
Annie Crazy Cat Lady.
No clue.
Illuminati Killers.
No clue.
Trump Girl.
No clue.
Callie Chick.
No clue.
Shy Guy 2012.
No clue.
Dave.
Told you I could not figure that out. I tried.
1776 Patriot Voice.
No idea.
Fight Like Flynn.
No idea.
Unfinished.
No clue.
Texas Cowboy.
No clue. Except for the ones I've told you, I don't know who any of
I'm
these
sorry?
people are. Except for the ones I've told you, I don't know who any of those people
These
are.
are the ones you put into evidence.
I understand.
Twinda 93.
No idea.
All right. At this point, she's testified. She doesn't know who any of them are except she's mentioned, so I don't see a good use of our time to name every one of them.
There's only just 2 or 3 more pages, Your Honor. I think
No, I'm going to ask you to move on. We don't need 3 more pages.
you think the point's made that
I'm not
That's
telling you what the
who
point
these
has been made
people
if there is one, but in terms of use of our time, I believe she's
But this is
answered
my-
and answered your question.
This is my cross-examination. I'm free
Understood?
to use it, and if I go past the time, which I think I'm entitled to as much time to cross-examine her as they examined her.
I disagree.
problem.
I haven't set a time limit. And all I'm going to be imposing is whether it's cumulative or a waste of time under 403. And so if that's more or less than however long her direct is, we'll see. But there's no time limit right now. It depends on what topics are covered.
Thank you. Got a lot. Let me shift gears for a moment. Well, first, do you still post under the name Jan Brady?
I have never made a post under the name Jan Brady.
Or are you still online on Telegram under the fake name of Jan Brady?
Yes,
So you don't post under that name?
correct. I've never posted anything under that name.
So why in the world would you be online under a fake name of Jan Brady?
To see what you're writing about us.
So when you were banned under the name of NJ Ellibug, you set up a fake account so that you could get into my account to find out what was being said.
Yes,
And you did all that in disguise under the
Yes.
name of Jan Brady,
yes,
hidden from me,
hopefully, yes.
hidden from my administrator
Until now, yes.
until now. Because now what was hidden has been revealed, right?
Apparently so.
Let me shift gears and talk about Dexter King. Your representation of the estate of Dr. Martin Luther King Jr., Inc. was a case that was brought to you to help by Rick Miller, who was your partner at Powell Goldstein and later your partner at Brian Cave, right?
I think he brought it to you and you brought me in.
Okay.
But yes, it was Rick's
Well-
client. It was Rick's client.
Thank you for correcting. So the estate
want
of
the
Dr.
truth,
Martin
Lynn.
Luther King Jr., Inc.
Inc.
was a case and a client of Rick Miller's,
Correct.
a senior partner or older partner than you at Powell Goldstein and Brian Cave.
Correct.
And your recollection is that Rick Miller asked me to handle that case
Yes.
for Dr. King's PC.
The first case, yeah, it
And it was
wasn't a
also
PC,
a
but
lawsuit not only against the state of Dr. Martin Luther King Jr. PC, Inc. It was a lawsuit directly against individually Dexter King.
there were a couple of different suits. That one, yes. At some point, Dexter was brought in as an individual defendant. I'm not sure that he was at the beginning. In fact, I'm pretty sure he wasn't at the beginning, but at some point he was, yes.
Plaintiffs were Bernice King and Martin Luther King III.
Yes, correct.
You remember the big hearing we had down in Fulton County? Went kind of late at night.
Objection, Your
We had
Honor.
several.
Relevance.
All right, let's
Give him some light.
get to the main point you're making here. I don't think we need all the details of representation unless you think they tie into something here.
I'm not even close to going into the details of representation.
All right, let's go to the next question.
It's about a hearing. You remember the hearing?
I remember several.
You remember the
Long
hearing
ones.
where I got Bernice King on cross-examination to admit that she had committed perjury?
Objection, Your Honor. Relevance.
Overruled. See
I'm
where it
not-
goes.
Oh, sorry.
You can answer.
I don't know that she admitted perjury, but you clearly caught her in a lie. You clearly caught her in a lie. I don't think she said, I admit, I perjured myself, but you caught her in a lie. Yes.
You've seen me take a lot of depositions, haven't
Many,
you?
probably
You've
hundreds.
seen me try 2 or 3 cases,
Yes.
and you've seen me use the art of cross-examination to catch witnesses in lies. You've seen me do that, haven't you?
Over and over.
I'm good at it. God gave me a talent.
You were very good at it.
So, in fact, I was asked to conduct a series of lectures.
Objection, Your Honor, is testifying.
If she knows about it, then she can answer it. So, Mr. Wood, if you want to phrase it that way.
You're aware of the fact that outside of Powell Goldstein and Brian Cave, that I had been asked by various legal groups to do a presentation on the art of cross-examination, right?
Yes.
And then I was asked by Brian Cave to conduct that same seminar to all of their offices in the United States, right?
Yes. I'm not sure we did it in every office, but most of the offices.
Most of the
Yes.
offices, the larger offices.
Yes, correct.
And I asked you to help me do that, to help me prepare it.
Yes, you did.
And it was a powerful presentation, wasn't it?
It was.
Remember that time when I finally got the lady from the Atlanta Journal and Constitution to admit the truth, and the people in the seminar burst out in applause?
I remember that.
You bet. So there were monies owed by Dexter King to you.
Objection, Your Honor, calls for attorney-client privilege. And relevance.
Yeah, Mr. Wood, I'm now with the phrasing of the question, as I've already ruled yesterday, I think, I'm wondering if you're aware of and cognizant of what it can be included in your question. If not, you can approach and preview what your question is.
I'm happy to approach and preview my question.
All right.
My conversation. People are talking. He was my friend. That's all I wanted to say. The record's going to show where you have to talk about it. Because it was privileged. I'm gonna do this my way.
See,
Let me just try to simple by just asking, do you know I represented Dexter?
that would do it. That would do it.
Thank you, Ron. Nicole, you were aware that I provided legal representation to Dexter King, true?
Yes.
And you were aware that I provided legal representation to the estate of Dr. Martin Luther King Jr.?
Inc. Yes.
Yes. Do you remember the night that we went and had dinner with Dexter and his, I believe, girlfriend?
Leah. Yes.
You remember that?
Yes.
You remember when Dexter told me that I ought to write a book about my career?
I do.
I was flattered.
You should have
Remember,
been.
he said, a book about your career in life would be compelling. Remember him saying that?
I do.
You remember me saying, I don't have time? I hadn't finished the chapters in the book yet. Do you remember me telling him that?
I remember.
Dexter King had great respect from me from what you observed, didn't he?
He did.
Your Honor, we've been going about 2 hours. It's 11 o'clock. Could we take a 10-minute break?
Do you have any estimate of how much longer you think you have on cross?
Probably the rest of the day. I hope not, but I don't know. I haven't had time to
Members of the jury, I
reach that
think,
calculation. I can give it some thought during the break if you let us have 10 or 15 minutes.
all right, we haven't had a break yet this morning. We'll take one. You let me know by the light when you're ready to proceed. Maybe we can limit it to about 5 minutes, get another hour in before we break for lunch.
Right for the jury.
All right, we'll take 5 until the jury's ready to proceed.
Okay. Liz,
Liz, nice to meet you.
likewise.
Thank you.
Well, because the judge said, don't talk about contempt rulings, and he ruled against us, and he was kind of forceful.
Saying, did you take any legal action? Did.
Right.
Right.
And so it is possible that that.
Okay.
I don't want to talk about your testimony. The judge is-
Where she talked about.
Remind them about the light, by the way. They didn't use it this morning. I think you got another coffee coming.
Yes.
All right.
Have a habit of figuring it out.
What was that?
I think it was the Kamara.
Yes, I brought it.
I think it's good. That's my favorite thing.
Have a habit of picking it up and then just setting it down.
It's, I don't love it though. I did this work.
So I remember she was talking.
An old bar here.
Yeah, G-Time tag. Not too long ago, 5 years ago.
Yeah, 2022.
It always happens. They say they don't want a break. And when we give them one, they're back there for like 15 minutes. Change their mind.
I think one person in the bathroom and everybody.
So what? Okay.
And not in this case though.
All right, you can bring back the jury.
Would you like me to
Thank you.
Rise to adjourn. Mr. President, John.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, we're going to go for at least another hour until we take our lunch break. Defense may proceed.
May I proceed, Your Honor?
You may.
Thank you. Nicole, you went through your legal career in terms of employment. And you were first at Powell Goldstein, as I recall, and you were what was called a lifer until it was purchased by Brian Cage. Right?
It was a merger, but yes.
Well, you and I know it was a purchase, but that's okay. A merger to the public.
But yes, I was a lifer. I had been there my whole career.
That was the year that Powell Goldstein missed revenue by 45%. Remember that?
I remember that well.
Brian Cage wasn't too happy with what he had bought when it found out, was it?
No.
You, and then you had worked your way up to equity partner at Powell Goldstein.
Yes.
And then when the firm became Brian Cave, you remained for a period of time an equity partner.
No, I became transitional. They put a bunch of us in a category of transitional, which was kind of, I don't remember. They did some sort of weird hybrid thing. They didn't want to just come in and de-equitize everybody, so they put us in a transitional.
What was your understanding of transitional? They weren't willing to say you were an equity partner.
Right. It was like you're on probation or something. They recognized that we had met the standards for Powell Goldstein, but didn't necessarily meet the standards for Brian Cave.
Yeah.
That's a screenshot.
Oh, that's okay.
That's just where you will.
Okay, thank you. Thank you. So how long did you remain a transitional partner?
It was a 2-year probationary period, as I recall, or transitional. And then after that, I was demoted to non-equity, if you will.
And then did that ever change before you left?
No, I did not become I did not become an equity partner at Brian Cave. I was always non-equity partner
So let me
when
make
it was
sure I
Brian
got it.
Cave.
You started off as an associate
Correct.
at Powell Goldstein. You then later became a partner, but not an owner partner. You became a non-equity partner,
Correct.
where you worked for the partnership, but you had no ownership interest in it, right?
Correct.
Then you later were elevated to equity partner, right?
Correct.
Where you did have at that point a designated ownership interest. I think they called it points,
Yes,
which would determine what points were used, basically a percentage, to determine how much of the firm's profits you would receive each year.
yes,
And then when Brian Cave, and we'll use the word merged with Powell Goldstein, you were not an equity partner at that time, were you? In Brian Cave,
correct. I was transitional.
which was in effect, they wanted 2 years to see how you would produce. Do you
Yes,
agree?
agreed.
Could you bring in your own book of business? They wanted to see it for themselves,
Correct.
right? And they would have been familiar, you believe, with your background. They would have studied all the partners. True?
Sure.
And after the 2 years of evaluation, you were demoted in effect permanently at the time to non-equity partner.
Yes.
That was a big step down, wasn't it?
No, a lot of people were in that.
That firm they were.
That's what I'm saying. A lot of people were transitional and then dropped to
They
non-equity.
were not happy. They left, didn't they?
Some people did leave, yes.
And you were not happy.
I wasn't happy, no.
And that's what led ultimately to you wanting to leave Brian Cave, right?
That's not true.
Why did you leave Brian Cave?
A lot of reasons. Brian Cave was not the same as Powell Goldstein. As you said, it was a whole different world. We were ruled out of St. Louis with a bunch of people who didn't know what we did, and Atlanta office was the redheaded stepchild. And so it wasn't about equity, non-equity. I didn't think I was getting paid enough, but it wasn't about equity versus non-equity. It was more like I told you when I came over. I just wanted to be paid what I knew I was worth, whether that was more or whether that was less. I wanted to get paid based on the work that I did and what I was bringing in instead of through some big red tape bureaucracy.
Well, and if you bring in business, it's fair that you be paid for what you bring in. I think you call that eat what you kill.
Correct.
And if you don't bring in any business, you don't eat. Isn't that what you told me?
That's the phrase.
Because you're not supposed to, under the theory, if you're a real partner and an owner, you're not supposed to eat what others in the law firm kill, right?
Yes. I mean, that's the theory.
And that's the way you know it works in practice. You're the one that discussed it yesterday, remember?
Yeah. Well, I mean, it was in your email. I mean, a lot of lawyers use that phrase.
Absolutely. I don't disagree with that at all. So when Brian Cave acquired or merged with Powell Goldstein, at the time, I was an equity partner in Powell Goldstein. Do you remember that?
I guess you probably were at that point. I know you came in to all laterals came in non-equity. So you probably were equity at that
Yeah, I
point.
didn't want to be equity. I told them that. So I was non-equity, no ownership interest in the firm, paid a salary. And then my third year, they elevated me to equity partner and I accepted. Remember that?
That sounds right.
Which was, with what, that sound right?
That sounds right.
Which was terrible timing because the firm lost its rear end that year. I didn't make very much money out of their profits, but that's okay. At Brian Cave, when they acquired or merged with Powell Goldstein, Brian Cave brought me into that firm as an equity partner. True?
Sure, that's true.
I was not transitional and I was not demoted.
You would not have been transitional.
They
or
had
demoted.
looked at my record and felt that I deserved, based on bringing in business, to be an equity partner.
Correct.
Mary's testimony again.
I have the witness on
I
cross-examination.
know, but I don't know if she has any basis of these fine details that you.
She just agreed with me.
All right, well, you can continue. Overruled.
Nicole, you kept, Powell Goldstein, you knew how to get into the firm's computer system, and you kept a spreadsheet when they would announce who was going to get paid what, didn't you?
It wasn't getting into, I mean, they announced it. It was when you were a partner, whether you were equity or non-equity, whenever they announced it in March of every year, they would send out the list, they would publish it on the firm intranet, and you'd see what everybody was making. So yeah, we kept a
And there were a lot of times,
sheet.
when you weren't happy between what you were making and what other people in the firm were making.
That is very true.
In fact, that happened often, didn't it?
It did.
And you voiced your displeasure.
I did.
Or you just didn't voice your displeasure and you just might not work quite as hard, remember?
Objection, Your Honor. I'm trying to give him latitude, but what does any of this have to do with the case?
All right, overruled, Mr. Wood. Let's
Thank you.
keep moving it along.
You understand
We
my
can't
question?
dwell on this subject forever.
I think that's a stretch, but there was one time I recall doing that,
Doing what?
saying, okay, if they think I'm not working, I'm going to not work.
And that was about a year you took off.
No, it was not a year I took off. I mean, are you talking about after my divorce?
No, I was talking about time you didn't work because you were upset about not being paid fairly.
Objection, Your Honor.
He's just directing her
That's
to,
not in-
all right, overruled.
There was like a month when I didn't work very hard. I mean, I did everything I had to do, but I didn't have a lot of cases and I was angry. It's one reason why I left. I didn't want the comparison. I didn't want to be worried about, am I making enough objectively versus am I making enough compared to this person? I just wanted to get out of that and make what I was going to make.
But you were supposed to be evaluated based on the amount of business that you brought to the firm, right?
That was one of the factors, yes.
Both in making you an equity partner and then changing you down to a transitional partner and finally changing you down to a non-equity partner, right?
Yes, that would have been the,
Obviously, that would reflect a concern that you were not bringing in enough. You were not you were not eating what you killed.
I was not killing enough. That's correct.
You weren't killing enough. Okay. So if you don't kill enough, you don't eat enough, right?
Correct.
And that's the problem that you were experiencing.
Correct. I did not have as much business as some people.
Now when we worked together very closely in 2006 on the Alec Hitz,
Thomas Shaw.
what was his name?
Shaw.
Tommy Shaw. They were the heirs to a Coca-Cola small fortune from their grandfather.
Yes.
And they got into a big lawsuit against SunTrust Bank.
Yes.
And you probably heard me say, and if I didn't, I say it now. That's when the firm asked me to meet with Ray Fortin,
Yes.
in-house counsel for SunTrust, to try to sell him on the idea that I could be the lead counsel because he was not happy with John Marshall, who was trying to settle the case.
That's correct.
And Ray didn't want it settled.
That's correct.
Ray wanted a jury trial. Do you remember that?
Well, or the case to go away, but he did not want to pay anything. Yes.
And after you worked with me, case went away, didn't it?
Did.
They didn't receive one dime.
They did not.
In fact, one of them had to pay the bank. Remember that?
Well, I don't know. I don't think he paid the bank, but he had to
He had to pay
ask
up.
the bank to let him keep his accounts there, and they finally
I
agreed.
thought one of them had to pay his loan back. The other, he asked to keep his accounts and they let him do it.
And they said, and then the other one, they said no.
Not
Yes,
Alex Hitz. And when I took Hitz's deposition,
I do.
and here I was, and here he was, and he spent the whole time.
Objection.
Yeah, Mr. Wood, I mean, I know you've got a lot of war stories, but we can't
I got a
cover
lot of
all
war
of them.
stories.
I know you do, but
Well, it just shows the nature of the relationship Nicole and I had.
she called you I think it was a great lawyer in her direct, And so I don't know what more time we need to spend on that.
You're
Right?
telling me that her objection is,
At this point,
Sustained?
I think that's sustained. Let's move on to another
okay.
topic.
Well, she knows what I'm talking about. So I got a smile out of her.
I remember it.
It was crazy. So now this was part of your help with me preparing my seminar on the art of cross-examination. Remember?
Yes,
You remember the one witness that swore himself in again, a guy in South Carolina?
I do.
That was hilarious, wasn't it?
It was.
Nicole, we had a very good relationship. We had fun.
We did.
Now, I quit drinking at one point, but I still would go out with you and others in the firm and down to Vini Vidi Vici. And y'all would have some drinks. I'd drink what I was drinking. I'd quit drinking scotch.
Arnold Palmer.
Huh?
You would get an Arnold Palmer.
I'd get an Arnold Palmer. That's exactly right. And then almost every time I picked up the tab, didn't I?
Always.
Always. More than happy to do so. True?
Yes.
We went to lunch.
Objection, Your Honor.
Overruled.
I would pick up the tab.
Every time.
If there was an L. Linwood PC holiday party at Christmas time, I held it at my house and I picked up the entire tab, didn't I?
Yes.
Didn't ask you, didn't ask Jonathan, didn't ask Taylor for one thin dime, did I?
No.
All the booze they could drink. Sometimes they drink a little too much, but that was at a
That
time
is
when
sustained. The jury will disregard that comment entirely.
I can ask Taylor about it on cross.
You cannot, because I've directed that it is not admissible. You can move on to your next question.
Okay. Let's transition for a moment away from Powell Goldstein, Brian Cave, and L. Linwood PC for a moment. I want to talk to you, but I won't do it quite yet. I want to talk to you about the law firm of Wood, Wilson, Grunberg, and Wade.
Okay.
You remember that, don't you?
I do.
I had made known in late 2019 that I wanted to semi-retire.
Objection, Your Honor. This isn't a question, it's testimony.
Overruled.
That I was planning to semi-retire. I wanted to write books. And I wanted to finish the litigation that I had, which primarily at that time was Nicholas Sandman. So it wasn't an announcement of a full retirement, was it?
Correct.
I remember telling my family that at Thanksgiving. I'm sure I told y'all shortly thereafter. And so we began to talk about what would happen when that day occurred. And that was the genesis of the discussions regarding Wood, Wilson, Grunberg, and Wade, right?
I don't remember it that way, no.
Well, you were going to be a partner in that firm, weren't you?
Yes, but we didn't discuss it. You just called me and told me that's what was going to happen. We didn't have any
Sure.
discussions about it.
There were no discussions? Is that your testimony?
I don't know what you and Taylor and Jonathan discussed or talked about. I just know from me, there were no discussions about that.
Did you know that they voiced objections when I first proposed the firm to be Wood, Wade, Grunberg, and Wilson? They have voiced objection because they didn't think your name ought to be second.
I have no idea.
Yeah, I need 25. Would you mind taking a look at plaintiff's exhibit number 25?
Yes,
You recognize that as an email chain dated January the 24th of 2020.
yes,
And you were on the email chain, were you not?
I was, yes.
On January 24, 2020, at 4:21 p.m., I wrote to all of y'all and said I was about to hop on the jet, but I spoke with Charlie. Charlie was my son, you knew that.
Yes,
He was taken aback when I told him that as of Monday, I was joining a new law firm. When I told him the name of the new firm, he loved it. So will everybody else. I know you all will love it too. I sure do. And that was the firm name of Wade, Wood, Wilson, Grunberg, and Wade, right?
that is what you were talking about. Yes,
And then Jonathan, still on exhibit 25. This is January the 24th of 2020.
right.
Jonathan Grunberg wrote back and said, "Wow, what a great way to start the weekend. Thank you. Safe travels and enjoy your family." Have I read that correctly?
You have, yes,
January the 24th of 2020.
right.
And then on that same day, January 24th, 2020, at 4:13 p.m., Taylor Wilson wrote an email, copied everybody. And he said, "It's all happening!" Exclamation mark. "Thanks, boss. Pinch me. Enjoy your weekend. G. Taylor Wilson." I read that correctly?
Yes,
That was January the 24th of 2020.
yes,
Now, you knew Charlie when I was talking about Charlie. I was talking about Charlie Wood. Charlie's my youngest son.
yes.
Having been around, you were around my children many times.
I was around Matt and Charlie. I met Chandler a number of times. I met Ashley a couple of times, maybe once or twice,
Maybe at the holiday party,
probably something like that. Yes.
but Matt much more so.
Well, Charlie worked at the firm for a while, and then
Yeah.
of course we had the trial with Matt. So yes, I had been around them some.
The trial you're talking about is the case of Vernon Unsworth versus Elon Musk
Correct.
in California.
Correct.
And I had asked y'all to maybe we'll go through this in a little more detail after lunch. But Charlie was at the trial. I was paying him to kind of be my assistant to get things for me.
Correct.
You saw how I interacted with my children, didn't you?
I did.
And over the time that you knew me as a lawyer, starting in 2006, right?
Yes.
Through the time period of let's say the Elon Musk trial in December of 2019. A time period of over 13 years, right?
Yes.
You knew that I had a very close relationship with my children, didn't you?
Yes. I would say before, if we cut that off before the Musk trial, I would say yes, absolutely.
Something happened right around the time of the Musk trial when I sued the richest man in the world. But before that, everything you observed is that my relationship with my children was excellent. True?
Yes.
My relationship to them and their relationship to me.
As far as I saw, yes.
And in fact, although we had business differences, until we got close to the beginning of the Elon Musk trial in December, the first week in December of 2019, my relationship with Jonathan and Taylor and you was good, wasn't it?
Yes, I think Jonathan a little less so, but
Why?
certainly Taylor even more so, Jonathan a little less so. But yes, we
It
all
was
had
a
a good
good
working
relationship.
relationship.
Have you seen the video? I posted it on Telegram. In August of 2019, after I took Elon Musk's deposition, he called me a shakedown lawyer. Matt and Taylor and I were outside the Beverly Hills Hotel, and we were laughing, singing the song Shakedown Lawyer. I was dancing a little bit. Taylor was dancing a little bit. You could see how well we got along, couldn't you?
Yes.
What happened? How did I go from the close relationship with all of y'all to everything changing just before the Elon Musk trial? The trial against the richest man in the world. Something happened, didn't it?
I don't know what happened
I know,
to
but
you,
something
Lynn. I
happened.
don't know.
You knew something happened. There was a dramatic change.
Something happened to you. I don't know what it was.
Or something was done to you. You don't know. You don't know, do you?
You became different. I don't know why.
My life became different. I was responding to a different set of circumstances. Do you know anything about a psychological operation, a PSY?
Only what I've read on your Telegram page.
So now you're educated on it.
I don't know if you could say I'm educated by what I read on your Telegram page, but I know what I read on your Telegram page. That's
And
it.
you know that they exist.
I know.
Utilized by, sorry,
I'm sorry.
I'm interrupted.
I thought you were done. Sorry. Go ahead.
Realize that psychological operations exist. They exist. You read it on my Telegram page. It's there for research for others that wanted to look at it. Psychological operations have existed and been conducted in this country against people in this country for decades by the CIA. Did you know that? Or did you learn that?
I know that that's what you have put on your Telegram page.
Do you have any reason factually to dispute that I was targeted by the Central Intelligence Agency with a psychological operation?
I have no idea, Lynn.
You don't know. You only know what I've written and what I feel
Correct.
and how things change dramatically.
Yes.
Have you read in my Telegram page that I believe, based on the time I spent with him, researching him in connection with the trial against him, I spent a lot of time researching Elon Musk, didn't I?
Yes.
And I spent 8 hours with him on cross-examination. Remember? You weren't there, but you knew it. And then I think you had him on the stand for 5 hours during the trial. And somebody asked me, you may have asked me, what's he like? Is he a genius? And I said, no, I'm afraid Elon Musk is a dummy.
Objection, Your Honor.
Yep, we're getting into war stories again, Mr. Wood. Let's
No,
get it
this
to a
goes to
point.
psychological operations.
But if she doesn't know anything about it, then
No, that's not what she said. She's learned. She doesn't know whether I was targeted, but she knows about them for no other reason than she's admitted that she looked at it and learned about it from my Telegram page.
so everything she knows is through your statements.
Correct.
And anything she did to follow up on it, whether it.
Okay, why don't you ask her if she knows anything outside of your statements and we can go from there.
Did you ever look into psychological operations yourself? Read the Mike Flynn book, 5F Warfare?
No.
Do you recall me saying to you at some point in time that I thought Elon Musk was a Central Intelligence CIA construct.
You asked me that during my deposition in this case, and I said I knew nothing about that.
You didn't know one way or the other.
I don't even understand what that means, Lynn. I have no idea.
Well,
You don't need testimony. Let's just ask a
I
question.
just said will.
Well, and it sounded like you're about to explain it
You're
to her.
guessing what I'm going to say and
Because I've heard a
objecting to
lot
it.
of what you've had to say. And so let's keep it
I'm
to the
sorry.
form of a question. All right?
Judge, that's not fair. You're
You can
now
ask the next
presupposing
question.
by my saying will, that I'm going to do something wrong. I've
Hey.
conducted a very professional examination of this witness.
You can ask your
Remember, I
next
gave
question, Mr.
instructions
Wood.
on the art
Mr.
of
Wood,
process.
you can ask your next question. This isn't a conversation.
I'm just not sure why that particular.
And I don't need any more commentary. You can ask your next question.
All right, I was about to, before I was interrupted. Now I've lost my train of thought. Give me a second to regather it. Were you shocked that the Elon Musk verdict came in 30 minutes?
I was surprised it came in that fast and disappointed. I don't know if I'd say shocked.
I mean, we talked about it. That wasn't even hard time to select a jury foreman. Remember that?
I do.
And you're aware that I believe the richest man in the world, Elon Musk, rigged that jury.
I'm aware that you believe that, or that you've said that you believe that.
Do you have any fact to prove that I'm wrong?
I know that you've accused me of that, and I know that I did not do
didn't
that,
ask you.
so I don't know.
I've never accused you of that.
Okay,
I have suggested that well, here we go. That I had concerns, and I'm gonna limit this to you to stay away from other cases, okay?
Okay.
You understand what I'm saying, Judge?
Okay.
I had concerns, not about you, but I had concerns that my son Matt and Jonathan and Taylor might have somehow gotten themselves involved in a situation where they were involved in rigging the jury in Unsworth versus Musk. I made that clear, haven't
you
I? I
have,
didn't accuse them of it, I just raised the concern.
yes, you have said that, or you have written it.
Yeah, I speak the truth.
I know of nothing that would support that, Lynn.
I'm sorry?
I know of nothing that would support that.
Well, you haven't looked into it, have you?
No, but I was there.
No, you haven't looked into it after being there. You say there's nothing to support it. You're not gonna find anything to support something if you don't look into it. You have not looked into it, have you?
No,
I have. Now, you knew there were serious problems going on starting at least in November, if not a spit before that with Jonathan. You knew there were some serious problems going on at the office between Taylor and Jonathan and me. It happened in front of you.
about the Musk case.
No, about what they were saying about my mental health.
Objection, Your Honor, lacks foundation.
You could rephrase the question.
You knew that I was upset with them because of what they were saying about my mental health.
Not before the Musk trial. What time period are you talking about?
It would have been just before the Musk trial, November,
No, I was not aware of that.
December.
I was not aware that that was an issue at that time frame. No.
Do you remember sitting in my law office? You were sitting and they were standing. And I said, I ought to sue every damn one of you for going out and defaming me, talking about my mental health. Do you remember me saying that?
I remember something like that. I don't remember when it was,
And
though.
you quickly looked up and said, I've never said anything about your mental health. Remember that?
I don't remember that.
And
but-
I looked over and I said, no, you were too smart to do it. Remember that?
Your Honor.
She said she doesn't remember this conversation.
I'm going through it as a refresher, maybe.
She
Remember-
doesn't remember it, period.
May I finish, please?
No, you may not. You can abide by my rulings. And I've said you have to move on to the next question because she has no recollection of this conversation.
She did not say
You can testify
that.
to it. All right, ask her if she remembers this conversation at all.
You remember generally of that conversation?
When you describe me sitting there and them standing up, there, it rings a bell, but we were in your office so many times. I don't remember a conversation where you said that about the mental health. I don't remember that, especially
don't-
not prior to the Musk trial. I don't
So-
remember any conversations like that before that.
May have been after, but nonetheless, you don't have any facts to deny my recollection of it, do you? To
No.
dispute it. Do you remember that when I had my law firm at the time, Alston and Bird? Can I have the March 17th, so. Yeah. Checking it out.
Here it is.
Do you remember generally that in the months of December and January that I was unhappy about Jonathan and Taylor talking about my mental health, even Jonathan suggesting that I need to be on lithium? Do you remember that?
I remember becoming aware of that issue. I don't remember when it was. It was at some point after the Musk trial. I don't remember if it was January. I don't remember exactly when it was, but I remember becoming aware of that issue some point after the trial.
And it was before March 17th of 2020, wasn't it?
Yes.
Do you have the March 17th, 2020 agreement in front of you?
I'm sure I do, but I don't know what number it is.
Could y'all point her to it?
The March 17th.
March 17th, 2020 settlement agreement. Could you point it to her so she has a copy? I've got my copy. Is it a problem? Haven't you put it into evidence? You haven't put this into evidence, the agreement?
We just
Well,
need
let
the-
me read from the
we
agreement.
just need
sure-
the exhibit number. It's
I'm
been
sure it's in
admitted.
the notebook. I just don't
I
know.
believe it's
where.
102.
So
you could-
look at 102. Thank you, Judge.
Oh, thank you.
Thanks.
Yes, this is it. Thank you.
Do you recall that prior to the time this agreement was executed, that I had expressed concerns to Jonathan and Taylor, maybe lesser to you if at all, about their comments about my mental health, because I thought those comments could damage my then efforts to get Richard Jewell posthumously the Presidential Medal of Freedom?
I remember that you voiced concerns about that. Yes.
And concerns that they were, at least, well, both Taylor and Jonathan, concerns that they were acting in concert with my son, Matt, to have me undergo a mental health evaluation. You knew that, didn't you?
I did not, that's just not true as far as I know.
You haven't seen the text messages between Taylor and Matt and Jonathan and Matt about that very issue?
I have seen them and they show that they're in fact not conspiring at all.
What were they doing talking to my son about my health, mental health? With Dr. Phil McGraw, about Dr. Phil McGraw.
From reading the text messages, which is all I know, Matt had reached out to Taylor like he had reached out to
That's
me.
not in the text messages. I'm happy for you to read the text messages, but don't,
Objection, Your Honor.
I object to her going beyond the content of the text messages.
Why should she be talking about text messages she's not even a part of? If she's saying she doesn't, all she's done is read them. You're going to have another witness here who's going to talk
Oh, I'll
about who wrote
talk,
them.
that works fine. I'll talk to these gentlemen about it.
Let's
Thank
move on
you.
to the next topic.
Thank you. But you knew that I had generally concerns about what they were saying about my mental health. For whatever reason, it might impact my relationship with my son, Richard Jewell, and my ongoing representation of Nicholas Salmon. You knew that I generally had that concern, didn't you?
I knew that you voiced a concern at some point about what you thought that they were saying and that it might negatively impact your ability to get the Congressional Medal of Honor, Richard's ability to get the Congressional
My
Medal.
ability to get it. My ability to get it for Richard.
Objection, Your Honor.
Please
I
let
think she misspoke.
Well, you can let her finish and then you can correct her if you think it needs to. So please finish your answer if you had anything else to say.
I didn't misspeak. You said you as well, but
I said, what?
that you were trying to get it as well. But
When did I ever say that?
February 10th,
That I was trying to get the President of the United States to give me the medal? Or did I say, wow, I wonder if he might be considering doing that? Isn't that what I said?
I think it was a little stronger than that. I don't remember your
Well, I can
exact
go
words.
into it if necessary, but I don't really think it matters. I haven't asked for recognition for anything I've done in my entire career.
Objection, Your Honor. His
I
testimony.
was fighting for Richard Jewell. to get it.
Mr. Wood, that sounds exactly like testimony. You're going to have your opportunity. Please
I look
ask a
forward to
question.
it. I look forward to telling the truth to
All
this
right.
jury and to you,
I'll direct you to refrain from testifying while asking questions.
only to the extent I have to, because it's the leading, I mean, I have the right to ask leading questions. But let me go back. Look at paragraph 6F of the March 17, 2020 settlement agreement.
Yes,
Now, that settlement agreement was negotiated in terms of the final terms by Joey Burby and Chris Marquardt of Alston and Burford, and Andrew Bill, your attorney, right?
yes. I mean, it wasn't heavily, yes, they sent it, they drafted the agreement, they sent it to us. We made some edits and we had to sign it the next day, but yes,
Didn't have to. I mean, you just decided, I wanted it signed, and nonetheless, we talked about it.
we had to if we wanted back into the office to get our
Paragraph
stuff.
6. I'm sorry?
We had to if we wanted back into the office to get our stuff, but
To get your stuff. You already done that in February.
no, we had not.
Well, I've got the records to show that. Nonetheless, if you wanted to get back into the office, you would have had to negotiate that between Andrew Bill and Joey Burby or Chris Marquardt. I was not involved at that point in time, right?
We tried.
I was not involved at that point in time.
It was your office space.
It was my office space,
Yes.
just like it was my firm.
Objection, Your Honor.
Right.
Testifying.
Yes.
Not on that comment. Overruled.
Right?
Yes.
Just like you said under oath yesterday. With respect to L. Lynn Wood, PC, all the decisions were Lynn's, right?
Yes.
You recognize that that was my power, that I had the power in that group of lawyers, that all of the decisions were mine.
You made that very clear.
And you knew it.
I did know it.
And Jonathan Grunberg knew it. And Taylor Wilson knew it.
Your Honor.
Sure they did. Oh, sorry.
You're aware of the fact they knew it, aren't you?
You said it repeatedly to all of us, so I'm sure they knew it. Yes.
So be nice to the to the boss if you know he's got all the power. And was I good to you?
What point in time?
How about in 2018,
Yes.
when I gave you
Objection, Your Honor.
I'm sorry?
Motion in limine.
There's no motion in limine about the CBS case.
If you want to approach, sure.
Before we do that, let me withdraw that and come back to it because I want to finish this area and I think we're getting pretty close to when you want to break for lunch. Back to the agreement. If you look at page 5, under paragraph 6, miscellaneous provisions. B, jointly drafted. The parties and their respective counsel mutually contributed to the preparation of and have had the opportunity to review and revise this agreement. Accordingly, no provision of this agreement shall be construed against any party because that party or his counsel drafted the provision. This agreement in all of its terms shall be construed equally as to each party. Have I read that correctly?
You have.
And is that the truth of what you agreed to?
Is that the truth of what we agreed to? Yes.
Thank you.
We put this in all the agreements, whether it's true or not.
Whether it's true or not, you put
We-
something.
It's boilerplate. We put it in. Sometimes it's more true than other times, but yes, we certainly had an opportunity with our counsel.
Well, if it's boilerplate and you put it in the agreement, you're stuck with it, aren't you?
Yes, no, this applies. Absolutely.
You're not gonna come in here and contend that Mr. Bill and Chris and Joey and you or Taylor and Nicole or me, I'm sorry, Jonathan, that we didn't contribute to the preparation, have the opportunity to review and revise this and agree to its terms, right?
I do not disagree with that.
No dispute about it.
Correct.
Now, at number 6F, under acknowledgements and competence. Read with me. The parties represent that they have read and understand the provisions of this agreement. That they are entering into this agreement knowingly and voluntarily, and that they sought the advice of counsel prior to executing this agreement. Have you read with me so far?
I have.
Have I read it correctly?
You have.
Is it the truth?
Yes.
Continuing. The parties further agree that upon information and belief, meaning what you know and believe, right?
Right.
Each party to this agreement is mentally and physically competent in all respects. Have I read that correctly?
Yes.
Including their ability to enter into this agreement in any and all prior agreements which form the basis in whole or in part for certain disputes between the parties which have been resolved by this agreement. Correct?
Yes.
Clearly acknowledging that both from a physical and mental standpoint, I was competent in all respects, right?
I agree that what this says is what we meant.
And that's what you agreed was true, right?
I agree that what it says here is what we meant.
Is what,
Is true. Yes. What is in this provision is true.
what I just read about my mental and physical competence, right?
Yes, it's an entire paragraph, and when you read it all together, it is true.
I don't want to try to set your schedule, Judge, but it's 12 o'clock and I wonder if this would be a good time to take a lunch break.
I wanted to get a full hour, so let's cover as much ground as we can. If you got another topic other than the one you want to defer, let's get to that
Full hour for what?
before we break again. We've only gone about 45 minutes.
Well, we've been going since 9 o'clock this morning, Judge. I'm 73 years old. I get tired and I get hungry. I'm asking simply, would Your Honor consider going ahead and having a lunch break now, which will give me an opportunity to hopefully look over what I've done, to hopefully be able to be more efficient in the afternoon. It seems like a fair request.
All right, members of the jury, it's 12:05. I'll ask you to be back at 1:05. Don't discuss or research this case with anyone, including amongst yourselves. And let me have juror 28 stay behind just for a moment, and we'll see you then. 105. Wait, you can sit down.
Thank you, Judge, thank you.
You can sit down. Juror 28, I just wanted to inquire if you've gotten any other updates for us or information we should know in considering your request regarding your work conflict. Anything new on your end?
No new updates, but just been reassigned, so I'm still working on the contract, just not in the leadership position at the moment.
So has the hardship evolved in some extent? I know it's a hardship in some capacity, but before you were saying this would impact your work for the next 3 months. Has that changed?
Well, no, like I still will be working on it. It's just that my responsibilities will be a little bit different. So I'm not gonna,
You're not going to lose the contract.
yeah, we're not gonna lose the contract.
And I know you're not going to want to hear this, but I hear that and it sounds like it's less of a crisis.
It's less of a crisis, but it is still sort of a problem because, you know, I am kind of, I wouldn't say the sole breadwinner, but my mom is retired, lives in my home. So my income is pretty important currently.
And you being here is preventing you from getting any of that for the duration.
I would have gotten, but I am still receiving it. So it's not going to end my life, right? But it is a setback, small.
Could you be switched back to a leadership once you're out of this?
I believe so. Well, I think after the 4 months is over, it's going to be mostly a monitoring role. So like this 4 months is really a launch period. So.
Okay. All right. Thank you so much, Juror 28. You can, we'll see you back at 105.
Yeah.
Thank you, Judge.
Well, not yet.
Oh, okay. Take back my thank you.
Understood. Okay. I want to finish the thought here. Defense had asked for more time to consider whether they want to stipulate to an 11-person verdict. Should that be required? I wouldn't plan to be excusing him today, probably not even tomorrow, but if at some point we do, then we've got 12 and then some other emergency comes up. Do you have any position one way or another on 11?
I would insist on a jury by 12.
All right. Just wanted to check that box.
Constitutional right.
Understood. Okay. Anything else we need to take up before breaking for lunch on behalf of the plaintiffs?
If we want to handle this objection,
I'm presuming we can jump to it if you still think this is something you're wanting to go into, but this, it sounded like you're about to communicate perhaps a settlement amount in the case. I certainly think it's relevant. You're saying how much, the theory that you bestowed benefits on, or that you were a good boss, that you did these nice things for. Their concern, I think, is that you're about to disclose a settlement amount.
I'm going to disclose.
Or maybe I got that completely wrong.
Disclose what they received in the Burke Ramsey case. That's not confidential.
he wants to get into how much he gave the 3 plaintiffs
How much they
out
paid
of
them.
their fee sharing, and that violates the motion limiting order on financial status of the plaintiffs.
No, that goes to the fact of what I paid them when they spent all day talking about what a bad boss I was, an abusive boss. And I have the right to show, in response to that door they opened, that I was a very generous boss.
Your Honor.
They made, excuse me,
Yeah.
excuse me. They made more money in 2019, because it was paid the beginning of January. Nicole Wade made more money on that one case than she probably had made in any year of her law practice. And these young lawyers made more money that year than they
Okay.
ever made. And I'm entitled to show my generosity in a case that I had handled for 20 years. I didn't have to give them a dime.
All right, I understand, Mr. Wood. So, as I think we've indicated in other rulings, when it's a question of intent, that's really opening the floodgates to some extent as to all these kind of issues. So if he's not talking about their net worth or how well they're living or things they've bought and that sort of thing, and he's just saying, here's what I did to show you that I wasn't trying to be mean to them later, I think that would be relevant to his state of mind.
Thank you, Your Honor.
But I'm going to let Ms. Brown respond.
Your Honor, the time period that he's just talking about, the 2018, 2019 time period, his actions have not been called into question at all during that time. In fact, Ms. Wade has testified how great their relationship was during that time. So he doesn't go to rehabilitate anything that he did in early 2020 and thereafter that's continued till today.
All right, understood. I think it's going to just be part of the difficulties or lack thereof between the parties. I think it's relevant under the rules.
Thank you very much
It's-
for the lunch break. Judge.
All right, we'll see you back at 1:05. We're in recess.
Bring that to us.
I think we need a, can you come in here?
I won't need it for. Okay. Did I reach you?
So when you get back, you'll be right next to it.
That's what are most.
Can someone figure out, well, oh, it's just when that's the camera that's on me. It's that. It's so far, so.
Without moving the thing, I'm plugging this into this extension cord.
I shot to-
I get that. I put a ticket and I paid.
That's what I'm saying, put a ticket.
Okay, now we got to turn it on.
She said.
It got power. Now we just need to turn it on.
He's got the remote.
Oh, you got the remote? Okay. We're good. Thank you.
Hey,
But which outlets don't work so we can,
I think they use it over here.
Jonathan, were you saying this outlet dead?
Oh, they tripped the circuit probably.
maybe probably even call them if you can.
I'm gonna put a ticket in and call the guy.
Okay.
Cause he's gonna say, what's the ticket?
I
Yeah.
believe it's just council tables, which on the plaintiff side were.
I don't know. All right, well, for now, let's forge ahead with what we can do. It didn't seem like the monitor was being utilized during cross as much, so we can continue with that. And if we need to take a break for technical issues at some point, we'll go. Looks like we're back on the record already. Thank you, Mr. Court Reporter. We'll bring in the jury now. We're ready.
They may have, I don't know if that is. I think ours is number one.
I think it's theirs too. Yeah.
All rise for the jury.
Yeah.
I'll give the present judge.
Thank you, Deputy Scott. Please be seated, everyone. Welcome back, members of the jury. Thank you for being on time. Defense may resume their cross-examination.
May I proceed, Your Honor?
You may.
Thank you. Get some lunch? Did you get some lunch?
I did, thank you.
Right before we took the break for lunch, I was asking you, or started to ask you about the Burke Ramsey versus CBS case.
Okay.
Now, when you, if I can do it in one question. Either from the time that you worked with me at Powell Goldstein and Brian Cave, and then later worked with me at L. Lynn Wood, PC.
Yes,
And even, I'm sure I would say before that time period, you were aware that I represented John and Patsy Ramsey and their son Burke Ramsey in connection with defamation cases on behalf of Burke, their young son, and later on behalf of John and Patsy Ramsey. True?
yes,
My representation for the Ramseys, from your recollection, started as early as I believe John Benet died on Christmas Day of 1996. And I was hired by the family in September of 1998. Does that jive with your recollection of how long I represented them?
I thought it was even sooner, but yes, it was early, very early on. You represented them
So
for a
as
long
of
time.
2018, 2019, you were aware that I had been representing John and Patsy Ramsey and their son Burke for at or slightly over 20 years. True?
Yes,
And certainly between you and Taylor and Nicole, I'm sorry, you and Taylor and Jonathan, your knowledge of the Ramsey case would pale in comparison to mine. Wouldn't you agree?
sure.
Your knowledge of the facts of the case would pale in comparison to mine.
I think that's true.
When did you first begin to help me on the Burke Ramsey versus CBS case?
After the CBS series, or actually, I guess it was before the series even aired, whenever that was.
Like a 3-day series, 3-part series?
Right. I don't remember if that was 2016 or 2017. I don't remember what year that was, but whenever it aired.
Well, it's 2017, I think, but you were aware, and I asked you to help me. And I asked Taylor and Jonathan to help me do various things. The case was pending in Michigan, right?
Yes. One of them. Well, I guess they both were.
You're not sure what the second one was. It was connected to the first.
Yes.
Oh, yeah, it was, I sued Werner Spitz, Dr. Spitz. And then separately, I sued CBS.
Right.
Spitz, because of his statements in the CBS series. Remember that?
Yes.
And with your help, we put together, drafted and filed, and I say your help, I think Fairley, Jonathan, and Taylor were involved in drafting. We drafted and filed those 2 lawsuits, I think in 2017.
I'll take your word on what year it was, but yes, all 3 of us worked with you on that.
So as I recall, we had a motion before the judge where they tried to dismiss it. And we successfully defended it. And the case was not dismissed. You recall that?
I do.
Then it proceeded to discovery. Remember that?
Yes.
And the first witness, the only witness as it turned out, but the first witness that I deposed on cross-examination was Dr. Werner Spitz. Do you remember his deposition? Were you there?
I do.
It did not go well for Werner Spitz, did it?
No.
Because it was obvious, and even you saw it, that Werner Spitz was a liar, wasn't he?
Yes,
And I nailed him, didn't I?
you did.
And it was shortly after I took Dr. Spitz's deposition that CBS came in and wanted to settle the case. Remember that?
But yes, it was some point close in time. Yes.
I think it was in late 2018, but that's neither here nor there. Without discussing the amount of the settlement, you know that in January of 2019, I gave you and Jonathan and Taylor each $750,000, didn't I?
It was somewhere around that. I mean, we had worked our butts off, but yes, you paid us.
Not for 20 years.
No, not for 20 years.
No doubt you jumped in and helped me get those complaints filed.
And prepare for the depositions. We all
And
spent
who
a lot
took
of,
and who took the depositions?
you took the deposition. We all spent a lot of time helping you prepare, but yes, you,
And you got paid $750,000 each,
yes,
right?
yes.
Prior to that time, at any time in your legal career, had you ever earned for a year $750,000?
Objection, Your Honor, relevance,
Yeah,
motion limiting.
You can explore the benefits that you've conveyed to her.
I'm sorry?
You can explore all the nature of your relationship with her, with the benefits you've conveyed to her.
It goes directly to my relationship with her. That in that 1 year.
No, we don't need to speak objection, Mr. Wood.
Just trying to respond, Your Honor. So.
You
let me-
can place it in context. I'll overrule this objection.
Thank you.
Not
So
even close.
you've never made that much money in 1 year, had you?
Not even close.
And that's not all the money you made in 2019, working at the time at L. Linwood PC, is it?
I don't remember how much I made in 2019 specifically. I know that there was the Ramsey payment. I had a couple of cases. I don't recall what else I got paid for. I don't know.
Best year you ever had.
Well, because of that case, yes, absolutely.
And you only benefited from that case because of me. True?
Sure. So your
I didn't have
client.
to give you that much money, did I?
No, I mean, you had to pay us for our work,
I had
but,
to- I
and
would've
so,
I did
Just
it
let
under
her
an
finish
agreement.
her answer, Mr. Wood, then you can ask another question.
I made an agreement to pay you X amount, didn't I? Percentage.
yes, it was the same. I mean, it was the same percentage you paid us on everything. Like I said, in fact, this one, that was one of the ones where I was saying yesterday, like, you said, how much do you each think you should get? And we each said 15% because that's what we'd gotten in other cases. And you said, well, the compensation committee met last night and we're giving you 18%.
Who was the compensation committee?
That was you,
Just me.
just you.
So I had the power to determine how much I would pay you and Jonathan and Nicole. I mean, I don't know why I keep doing that.
And
You
Taylor,
and Jonathan and Taylor. It was totally within my control about what I pay you on a case-by-case basis, true?
yes, we had an agreement on hourly fees that was agreed on contingency fee cases. Yes,
Well, you say we had, when you first came to the firm, you and I had an agreement in writing.
yes.
But then after that, and I didn't do much hourly work, did I?
Well, sometimes yes, sometimes no.
Well, overall, you recognize that I primarily made my living as a lawyer on contingency fee cases.
That's correct, yes.
And then in the latter part of, I guess it was we'll call it around 2018, I was asked to represent Steve Wynn. Steve Wynn of Las Vegas,
Right.
Wynn Resorts, the Mirage, Bellagio. You know who Steve Wynn is, don't you?
I do, yes.
And I was going to represent him, I agreed to represent him in defamation-related matters, remember?
Yes,
And I did it on a hourly fee basis.
correct.
And how much if you worked an hour, what percentage did I give you for your hour?
I don't remember, Lynn.
I would bill,
think it,
I would bill Wynn, list the hours. You had them. Taylor had them. Jonathan had them. I put my hours in the bill so that Wynn's people knew exactly how many hours each lawyer spent. And then I would compensate you from what he paid to me, giving you a percentage of your hourly work on the case. We didn't bill him monthly, right?
yes,
It was a great source of income for you, wasn't it?
yes.
I don't recall, and we can find it, but I think I gave you and Jonathan and Taylor upwards of 70 or 80% of each of your billed hours.
I think that's right. I think it was, I was going to say, I think it was 75%. And then at some point you raised it to 80%. I think that's my recollection.
So if you billed $1,000 in hours on a Wynn matter, you would get $750 or $800 and I would only take 250 or 200, right?
Right.
And I could have made that division anything I wanted to. I could have taken 80% and given you 20%. If you agreed to take it, that's what you'd get, right?
If, I wouldn't have agreed. I mean, I think I would have done my own work, but theoretically,
Got your own case.
I mean, I had different cases. So, so I don't think I would have worked for that, but yes, you're the one who set the amount.
Right, you would have, if I looked at you and said, Nicole, I'm gonna give you, for every hour you bill Steve Wynn, I'm gonna give you 10%. I'll keep 9. You had the right to look over and say, I ain't gonna do that, right?
Correct.
But I had the right to tell you that, and then you could say, I ain't gonna do it.
Correct.
And I would either have to get somebody else, or I'd have to strike a better deal with you. Acceptable. The deal I made you and Jonathan and Taylor on that representation was a very good deal for each one of you, wasn't it?
It was.
I was generous, wasn't
Yes.
it? In your career with me, up until I guess we'll stop at the Musk case. The history you had with me as someone that had control over your income was that I was always generous to a fault, wasn't I?
Yes.
I was a generous boss.
Why I trusted you. Yes. Trusted you. Yes. You had always been generous.
Well, you didn't just trust me because I gave you a lot of money, I hope.
No, I
You trusted me because you knew me as a lawyer, right?
I trusted you for a lot of reasons. Yeah.
You trusted me because you believed that I was an honest man who kept my deals. True?
I believed that you kept your deals. Yes.
So you ever heard them? And didn't you go out to Las Vegas? Didn't I pay for you to go out there to meet Steve Wynn?
We went out there and yes, I mean, we were working. We interviewed people, met with people, but yes, we
But
went out there and you paid for it.
And
Yes.
I didn't have to take you.
No.
Didn't you go with me when Wynn invited me down to see his yacht?
Yes, we went on his yacht.
I think young Taylor went with us, didn't he?
Yes.
That was a pleasure trip. If you like $250 million yachts, I'm not a water guy. But it was an incredible yacht, wasn't it?
Yeah, it was incredible.
And Wynn was an incredible host, wasn't he?
He was, yes.
And that wasn't a business trip. That was just a client relation type trip. He wanted me to come down and see his yacht. Right?
That may be. I don't recall if we did any business at that time or not, but that very well may be.
But I paid for you to go, and I paid for Taylor to go, didn't I?
Yes.
And that was quite an experience for you, wasn't it?
Yes.
It was for me. I'd never seen a yacht like that.
Me neither.
Were you aware that I had, in 2 matters, one in Florida and one in Nevada, Las Vegas, that I had been retained by Sheldon Adelson, a major benefactor to the Jewish community, that I had been hired by Sheldon Adelson to represent him.
Yes.
At the time of my representation, did you know that Sheldon Adelson was the 14th richest man in the world?
I knew he was up there. I couldn't have told you 14, but I knew he was high on the list of richest men in the world. Yes.
You recall whether I got you involved in any of the matters that I represented Sheldon on?
Yes, you did.
And was it essentially the same arrangement as I did with you when I got you to help in the Steve Wynn case?
Yes.
You would bill your time, and then I was generous in the percentage of what I paid you. Probably the same thing I paid you and Wynn, 75, 80% of what you got paid, what you billed.
Yeah, I don't remember the exact number, but it was something like that. Yes, it was, yes. It was somewhere in there, probably around the 70 or 75.
And there was a fringe benefit to representing Sheldon, wasn't there?
Sure was.
He put us up in his hotel when we were there on business.
Yes,
And you and I like to play blackjack at the time.
we did.
So while it was mostly business, it was also pleasure, and we had a good time, didn't
Yes,
we? I was out there on one case to represent him for a 2-week deposition. You remember that?
yes,
Were you there for any of that part of my representation?
I was.
Sheldon loved me, didn't
He did.
he? You remember when Sheldon gave me one of his canes?
I do.
Back was bad.
I do.
This is the cane. You recognize it?
I do.
Had you ever had an opportunity as a young lawyer, and I still think you're a young lawyer. You can say thank you.
Thank you.
Well, you are. As a young lawyer, did you ever envision, as your career progressed, that you would have an opportunity to work with another lawyer to represent someone like Sheldon Adelson, Steve Wynn, John and Patsy Ramsey, and Burke to do work on the Richard Jewell case? Did you ever envision having that kind of an opportunity?
Nope,
Who gave you that opportunity?
you did.
I gave them the same opportunity, didn't I?
Yes,
And so when you can try to evaluate somebody's relationship, you can evaluate it based on money, right? And you've told me before 2020, you always found me to be a very generous person in how I treated you and the people that did work for me, right?
yes,
You can also evaluate the relationship when you work somewhere based on the benefit you receive from the work experience itself, right?
yes,
And I believe you will tell me, and I won't ask you to speak for these two young lawyers, that I was not only an excellent mentor, but I was a good teacher, wasn't I?
yes,
I explained to you why I would do things and my strategy. And you learned from it, didn't you?
yes,
And it benefited your law career, didn't it?
yes,
You remember in the SunTrust case, they had an expert witness. Can't remember her name. Do you remember? I
no,
can see her face. And I took her deposition. And it didn't go well for her, did it?
no,
She was a liar, wasn't she?
it was.
And I revealed her lies, didn't I?
You did.
So much so, do you recall that you and I took the position with SunTrust that they should not identify a rebuttal expert?
Yes,
And they went crazy. We got to do that. We can't take a chance and not have a rebuttal expert. I said, take a chance. Remember that?
yes,
And the powers that be, Ray Fortin, they didn't agree with me. I said, this witness is going to be struck. And let's don't give them a chance to name a rebuttal witness, right? Remember that?
yes,
Objection, Your
Yeah,
Honor.
we're going back into the weeds on a war story, Mr. Wood.
Finish
Thank
this
you, Your
story
Honor.
because it has importance.
All right,
So-
we'll see.
So we took the unheard of approach of not identifying a rebuttal expert, right?
yes.
And what happened to the plaintiff's expert?
She got struck.
She got struck. And they had to fold.
Correct.
And my strategy went against what I was being told by lawyers at the time, Powell Goldstein, and the lawyer for SunTrust Bank, Ray Fortin. They all said, no, we disagree with you. But they finally agreed to do it the way I wanted it done, right?
Yes,
And I was right.
you were.
And because I was right, they won that case.
That's true.
You were probably amazed that I wasn't gonna name a rebuttal expert, weren't you?
I was.
You thought I was a dummy,
I knew by then you weren't.
huh?
I knew by then you weren't.
You knew by then I knew what I was doing.
I did.
Your initial impression of me was, I got some plaintiff's lawyer coming in here.
It was.
But over time, when you got to know me and who I was as a man and a lawyer, you thought I was the best lawyer you'd ever met.
I did.
Thank you for that compliment. Coming from you at that time meant a lot to me. I took it as a compliment. I still do. A lot of simple truths in life. Ted Turner had one. See if you're familiar with it.
This doesn't sound like a question, Mr. Wood.
All right, let me ask the question.
Okay.
You ever heard of, and I want to attribute it to Ted Turner, Captain Outrageous, and it's probably been said by others. A simple truth. Lead, follow, or get out of the way. Have you heard that before?
I have.
Well, we'll see where he goes with it.
Sorry, Judge.
Proceed, Mr. Wood.
But was that overruled?
You can proceed.
And that's the way it is in any team, whether it's a team of lawyers, a team of doctors, a team of missionaries, individuals that have gone into combat together. Somebody's got to lead. Somebody's got to follow. And if you're not the leader, you got to follow or you got to get out of the way. That's a simple truth about life, isn't it?
I guess so.
Okay, thank you. There was reference made turning to the Nicholas Salmon matter.
Yes.
You admitted yesterday that that was a case where before it settled, that you and Taylor and Jonathan and I had not reached any agreement on how to divide the fee, right?
That's correct.
How many years had you known David Vigilante, the general counsel for CNN?
Only through you. I didn't know him.
Were you aware that I had been doing business with David Vigilante and CNN since 1997 and had settled many cases where I was suing CNN?
I knew that you had settled many cases with him for CNN. Couldn't have told you what year, but yes.
Were you generally aware of the fact that I had a good working relationship, even though he was my opponent, with David Vigilante of CNN?
Yes.
You know who negotiated the Nicholas Salmon settlement with CNN?
You did.
I did with David Vigilante, didn't I?
Yes.
You also, I believe you did know this, with respect to the Nicholas Salmon case against the Washington Post. The lawyer for the Washington Post was Kevin Bain, right?
Yes.
Did you know how long I had known Kevin Bain?
I knew you knew him. I don't know how long.
Were you aware that Kevin Bain represented Tom Brokaw in NBC in the claim I brought against them for Richard Jewell?
I didn't remember that, but I'm
That
sure
refresh your
It-
recollection?
very well may be true. I'm sure it's true. I don't know.
So Kevin Bain had settled that case with me when I was going to sue Tom Brokaw and NBC.
Objection,
And, excuse me, And the case settled.
Oh, there's an
You know-
objection.
I don't have, I
Objection, Your
haven't
Honor, this witness
finished.
testified
But
that she didn't
mid-
know.
I'm sorry?
The witness testified that she didn't know about
The
the facts,
details
lack
of this
foundation.
case.
I'd asking for details.
All right, we'll hear it.
You were generally aware of my career, weren't you?
Yes,
You knew that I had taken on roll call in NBC, didn't you?
yes,
I don't know if you realize that Kevin Bain and Jack Vardaman represented them at the time. They were from the big firm in DC called Williams and Connolly.
And-
But you know that Kevin Bain of Williams and Connolly was representing the Washington Post in the case that was filed for Nicholas Salmon.
yes.
And who negotiated the settlement of the Salmon versus Washington Post case?
I'm sure you did.
Me and Kevin Bain.
I'm sure that's correct.
Big media defendants. I think you know this from your overall knowledge and experience. You sue NBC, you better buckle up. Susan Weiner, the general counsel, she'll fight you to the death. You know that, don't you?
Yes,
Because they got all the money.
yes,
So you go into a litigation with a major media defendant, you better come in well-armed, well-financed, and be prepared for a long battle, right?
yes.
CNN folded the cards in Salmon, didn't it?
After we got it reversed and back in court, yes,
Yeah.
yes,
And then the Washington Post folded their cards quickly, didn't it?
yes,
Just like Tom Brokaw and NBC folded their cards quickly when they were going up against me, didn't they?
I assume that's true. I believe that to be true.
Now I want to talk to you just a minute about correct me if I'm wrong, you're younger. I believe the judge in the Nicholas Salmon case was Judge Bartlesman.
I think it was Bertelsmann, maybe?
Bertelsman. See, I told you your memory would be better. He was an older man. He was, I think, in his 80s.
Yes,
And we had filed working under Todd McMurtry. He represented the clients. He engaged L. Lynn Wood, PC, to work with him, right?
yes,
And you've heard him say that I was picked because of my reputation.
yes. I think I said that yesterday. Yes.
Didn't know you.
No,
He didn't know Jonathan.
nope,
He didn't know young Taylor.
nope.
And we sued CNN, the Washington Post, NBC, CBS, the New York Times, and Rolling Stone magazine. Right?
Some of those were after I left, but yes,
I don't have the timing of the dates, but you're generally aware of all the lawsuits.
yes,
And before I got fired by Nicholas, I had negotiated a settlement with CNN and with the Washington Post, right?
correct.
Apparently sometime after I had been fired, Todd McMurtry, I guess, negotiated a settlement with NBC.
Yes,
And did you know that on the other cases, that Todd McMurtry lost every one of them?
yes,
He didn't take the deposition of the Native American Indian. Were you shocked to hear that?
it was, yes.
I mean, they let the guy testify by affidavit he'd given. How many stories has he told? A lot.
A lot.
And McMurtry didn't even bother to depose him and establish the fact that his story was 10 different things, did he?
Nope.
Now, because of the timing of how quickly, I mean, I would think that you would agree that you would have been very surprised, I was, at how quickly CNN folded the cards. True?
I mean, I guess, once it was reversed, I think they were worried that they had a big problem, but
Well, they had to go into discovery.
right, and they did not want to do that because
They knew
we
who
had
was-
the goods.
They knew who was going to be on the other side taking the depositions, didn't they?
That's true too.
They knew once it got into discovery and we started taking depositions, they were going to have to deal with L. Lynn Wood. True?
True.
And they folded
They folded.
so quickly that we had not made any agreement on how a recovery to L. Lynn Wood PC would be divided. True?
We had not made an agreement. That's true.
So it was only after everybody knew what the pot consisted of that then everybody wanted to try to divide it up. True?
No.
You knew what the settlement was. You knew the amount. You knew what the amount of the attorney's fees were. So you went in, unlike other cases, not knowing in other cases whether there'd even be a pot. True?
Went into what?
I'm sorry?
Went into what?
To an agreement. You'd make an agreement and meet with me on a case-by-case basis in a contingency fee matter where you didn't know whether we would recover a dime. Like in the Musk case.
You would send us an email like you did in the Musk case.
But you went into it not knowing whether there would be any recovery.
Correct.
So you could have made an agreement, worked hard, and come away with zero.
That's the nature of the contingency fee work,
I
yes.
know it well. I had it happen a couple of times, fortunately not too many. Thank the Lord. But with the salmon case, the efforts to reach an agreement on how to divide that up, everybody already knew the pot. It was sure money. Because it had settled. There was no contingency based on it being successful in settlement, right?
That's true. It had already settled when,
Settled in terms of the amount. But you knew at the time that Nicholas Salmon was a minor, 17 years old, right?
yes,
In the course of your career, how many minors settlements have you been involved in?
several.
So you know the general procedure is if the case is not in litigation, that in order to settle a case for a minor, you have to go before the probate judge, who will generally appoint a guardian ad litem. And the guardian ad litem and the probate judge will decide whether the settlement is reasonable and whether the attorney's fees are reasonable. You know that, don't you?
Yes,
But in the Salmon case, because the case had already been filed in federal court, you were aware that a probate judge in Kentucky first had to approve the amount and the fee, right?
first he had to get a conservator appointed.
Which would be like a guardian ad litem, which I
Yes,
missed.
yes.
And then the federal judge, Bertelsmann, would have to look at it too to decide whether the amount and the fee was reasonable.
He had to sign off on it, yes. I don't remember the standard, but yes.
But he didn't have to because when it settled, he was 18. So when we were dealing with Salmon, you knew that everything could change based on what either the probate judge did or Judge Bertelsmann did, right?
Theoretically, it wasn't likely. It was a very good settlement for Nicholas, so
Let her finish her sentence, Mr. Wood.
I'm sorry.
Just let her finish her sentence, or her
I think I've
response,
been
rather.
very good about that, don't you?
I'm not expressing any opinion, sir. You can finish
Uh-huh.
your sentence, Ms. Wade.
I
Sorry.
was,
I said, I'm not weighing in here, Ms. Wade. You can finish your response.
I was just saying that it was a very good deal for Nicholas and I would have been shocked if anyone had said that it wasn't or contested it. So, I mean, we certainly expected it to be approved, but I mean, sure, something could, the judges had to approve it, yes.
A judge the age of Bertelsmann and the era that he came up in, he could have possibly said, this is a great deal for Sandman, but it's too much money for these lawyers. He could have done that, couldn't he?
Objection, Your Honor, calls for speculation.
Yeah, I don't know how she,
He had the right to do that, didn't he?
I don't know if Bertelsmann had the right to do that. I think
Federal
the
judge?
Yeah, I think the probate court judge probably had the right to do that. I don't know if Bertelsmann did, but
You don't know one way or the other.
the probate court judge probably did.
Did you ever look into what Bertelsmann's options were?
No. I know Taylor had looked at that and worked on that. I wasn't working on that piece of it at that time.
I had asked Taylor to work with Todd McMurtry in putting together the paperwork, remember?
Yeah, Taylor put together the paperwork, yes.
And then I pulled him off of it,
When we left,
pulled
yes.
Taylor off of it.
When we left, yes.
I don't know the timing, but I pulled him off of it.
After we left, yes.
Now, I thought I heard you say something yesterday, correct me if I'm wrong, that you and maybe Jonathan and Taylor had gone to Kentucky to attend a probate hearing. Did I misunderstand you?
That is not what I said.
Because there was no probate hearing, was there?
That's not true.
Well, there was, as I understand it, I found out later that Nicholas's mother was appointed as the guardian.
Objection, Your Honor, testifying.
sounds like testimony, Mr. Wood. You can rephrase.
She was.
She was. I didn't know it, but that's okay.
Well,
But she didn't have a role to play because you knew that Todd McMurtry had negotiated a deal with CNN to not pay the money until Nicholas turned 18, right?
no.
You didn't know that?
I don't believe any part of that to be true, the timing or who did it, but
Are you familiar with the testimony that you're going to present from Todd McMurtry on that issue?
I think Todd says that he worked with CNN. And you may have had him work with CNN. I don't know.
That I had nothing to do with the probate and how the timing came out. Do you remember that testimony?
He may have said that.
Well, we're going to hopefully have his
Hear it
testimony
from him.
read because he said that,
They'll hear it from him.
and it's the truth.
Objection, Your Honor.
So-
Testifying.
It's true, Mr. Wood, that's not appropriate. And we've been over this again and again and again. You can ask her questions, you can do responses, but the commentary is not appropriate.
I apologize. It's not meant to be commentary. It's meant to be a flow of a thorough and sifting cross-examination.
That's, when you comment, that is not cross-examination. So please confine yourself to questions and we'll go from there. You can continue.
Yes, sir, Your Honor. I apologize. Even if we disagree, I respect you're sitting there on the robe, and I apologize. I don't mean to interrupt the witness. I'd like to move on. Were you aware that a deal had been made by Todd McMurtry with CNN? That CNN would not pay the money until Nicholas turned 18. And in consideration for that, that they would pay interest on the money from January 1 until he turned 18 on July 24th.
I'm sorry, the question was
Were you aware of that?
when? At some
At any
point,
time?
at some point, I guess during this litigation, probably, I became aware of the fact that there was an agreement. I don't know when it occurred, but yes, or when I became aware of it, but I know at some point.
Todd McMurtry testified to it.
That very well may be. There's been a lot of testimony and documents. I just don't remember where I got that.
So you're aware that CNN was interested in making that deal because it would lessen by 2 the opportunity for the settlement to leak out. No opportunity if they don't probate it?
Objection,
No,
Your Honor.
may I finish,
testifying
please,
again.
Your Honor? Would you please let her ask?
No,
instruct her, let
because
me finish?
sometimes a question midstream can be objectionable. So
I've
she's
never
allowed
heard of
to
that.
interrupt you.
I don't know how that could ever be true.
All right. Well,
I could change the question at the very end. But let me go back. This is not simple. I'm not trying to, these are undisputed facts, but let's go back.
I can answer the question.
So-
Yes, CNN wanted to push it off.
you can proceed.
Thank you. Thank you
All
very
right.
much. So, see, now I lose my train of thought. Bear with me. Were you aware that CNN wanted or was willing to delay payment in part so that it would lessen the chances of the settlement amount leaking out in the probate proceedings and the federal court proceedings?
Yes, CNN had requested that from the beginning.
And you know that because of what Todd McMurtry told you.
No, I know that because I was still at the firm when you told Todd that that was not going to happen and that if you needed to get involved, you would, because a deal was a deal and they were going to pay the money and nobody was going to wait until Nicholas turned 18. So
When did you ever, what do you base that on?
an email that you sent to Todd, you and Todd kind of got into it.
Do you have that to put into evidence? I haven't seen it.
I have no idea if it's in
I'm
my
not aware of
notebook.
any such email.
Objection, Your Honor.
I'm asking her if she has the email.
But when you say I'm not aware of it, you are testifying.
So I moved to strike her testimony about an email that she hasn't produced and we're not able to look at to cross-examine her on.
Have her testimony, the jury can do with it what you want.
Yeah, I have her
It's denied.
testimony about an email that she hasn't produced. How am I going to examine her on an email she hasn't produced?
Objection, Your Honor.
It's,
One, it's a speaking of objection. Two, the email was clearly an email that Mr. Woods sent. Three, we've produced everything in discovery, so these repeated comments.
Now she's testifying. I object to that.
You're allowed to testify. so I
Don't
can
raise your
cite
voice
you
at me,
to-
please.
Mr. Wood,
Instruct
you will
counsel not
stop
to
right
do that.
now. No,
Instruct
we're going to
counsel
move
not to
on. Your
raise her
motion is
voice at me.
denied. You can answer your next question, Mr.
Raise my
Wood.
voice at her, I would not. I have respect for my fellow lawyers. May I proceed?
You may.
Were you aware that the probate hearing that had been set to consummate the Sandman settlement got postponed
Yes,
because of COVID?
yes,
Were you aware that Mr. McMurtry was trying to see if the judge would conduct the hearing by telephone?
yes.
And then the judge refused.
They didn't conduct it by telephone.
The judge refused.
Well, they did it by Zoom.
So they had a probate hearing by Zoom
Yes.
to approve the amount of the Nicholas Sandman settlement?
No, to appoint Julie Sandman as conservator.
Well, I'm sorry. Do you have a copy of that Zoom? I've never heard of it before.
I saw it in the record at the probate court.
So did you meet with Todd McMurtry when you went up to Kentucky?
I didn't go to Kentucky at that
Watch the
point in
Zoom.
time.
I'm
Objection,
sorry.
Your-
I'm learning about something I never heard before. How did you know it was going to be done by Zoom? Who notified you?
I didn't know it at the time. I only learned it during this litigation.
I thought you said you were participated in the Zoom.
No,
And did you learn about the Zoom from Todd McMurtry?
no,
Did you learn about it from me?
no. You
How did
told
you
us
learn
she
about
was,
it?
you told us that she was never appointed. And you told us that she was never appointed. You sent us an email
I
on
didn't.
April 16th and said that you had no idea when the probate court was going to be able to schedule the hearing to approve her and everything else. And after all this litigation, I mean, I believed you at the time because I believed you. And after all this litigation started, I went back and started digging and I found that in fact, the hearing had taken place by Zoom the day before you emailed and told us that, and that she was in fact
Well,
appointed.
thank you.
That's
didn't know
what
it
I
either.
know.
You and I were both in the dark.
You're
on that.
testifying, Mr. Wood. We've been over this many, many times. I'm directing you to not to do that again. You will have your chance to testify. You can ask your next question.
Do you have any evidence that you can point to that says that I knew about that Zoom hearing before you did? Not speculation, evidence.
I have no idea. I downloaded a copy of the order from the probate court, but I don't know if you were listed on the docket. I have no idea. I don't remember that. I just know I went back to see if what you said, which things that you said to us were actually lies, and that was one of them.
And you said I was lying?
Yes.
Because I lied on about what?
You said there is uncertainty about when the probate court and the federal court will be able to hold the hearings.
I did tell you that.
Yes, and in fact, the hearing for the probate court had taken place the day before, and she had been appointed, and the order was entered on April 16th, the day you sent us the email saying that.
But you are assuming that I knew about it.
Well, the point of your email was to report to us on what was going on with the settlement, and you said in there, I will continue to keep you apprised of what happens. You were purporting to tell us what was going on so that we would know when we were going to receive the money that you had agreed to pay us. And so we believed you. We believed you.
March email that I sent when I found out about the hearing. It was March.
Yeah, and non.
That I sent to Joey Burby and Andrew Bill.
I got that. Yeah. I did.
This was in April. Just FYI.
Well, your recollection is April. I'm gonna ask you to look at something else.
I know, but you're not talking about the same email that I'm talking about, but
I don't know what email you're talking about, Nicole, with all due respect.
I'm talking about an email that's April 16th. I'm sure it's in the notebook somewhere.
Well, if they got it, Judge, could I see it?
Yeah,
Could I
but
see the
exhibit
April
we're referring
16th
to?
email?
We have it.
Is it a marked plaintiff's exhibit you were planning to tender at some point?
Yes, through Mr. Wood.
Well, let's put it out there now. Let
Any
me see
objection to
it.
tendering it at this time?
No, I mean, he needs to
Just-
tender his own.
Just tell me where it is
Yeah.
and
Just show it to us.
What's
Let
the
us move
exhibit
on.
number?
Trying to find it, Your Honor. It's plaintiff's exhibit 76.
All right, any objection to entering plaintiff's 76 from the defense?
Take a look at it.
Your Honor, is he objecting to his own exhibit?
I'm not sure yet. I think he's taking a look at it and we'll see.
all right, 70.
It's not the email I sent. Because I copied Andrew Bill on it.
Yes, that's the one. Thank you.
I wouldn't do anything from April 16th. I see the email of April 16th. I don't recall it. I do recall sending one in March. Remember?
Yeah, the question to you is, do you have an objection to entering plaintiff 76?
I want to look at it before I make that decision because I don't recall. I do recall an email I sent in March.
Well, we don't need to hear your testimony on it, Mr. Wood. If you're
The
not
answer is,
ready to
let me have
proceed,
some time to look at it. How about that?
well, you can ask your next question on cross. Otherwise, we're going to move on. We are mid-trial,
I understand that.
so let's keep it moving.
I'll get back to you on whether I have an objection. I may not. I just want to make sure what I'm looking at before I say it's right or wrong. I think you can understand that. You and Taylor and Jonathan sued. After you sued me, you sued Todd McMurtry, right?
Yes.
Huh?
Yes.
Did you sue Joey Burby?
No.
Did you sue Chris Marquardt?
No.
Did you sue Nicholas Sandman?
No.
you knew that Nicholas Salmon was the client of Todd McMurtry, who was the lawyer that controlled him. You knew that.
I know that Todd represented Nick.
He was the relationship lawyer. It was his client.
Yes,
And he, at the time, retained me when he was representing the mother and the father, because Nicholas was a minor.
correct. And so Ellenwood PC then also represented Ted and Julie. Yes,
I was associated by Todd McMurtry to work with him to represent.
yes. I mean, you had an engagement letter with them.
So
Yes,
it was your position that Todd McMurtry committed a fraud on you and Jonathan and Taylor because Nicholas Salmon objected to the settlement amount in terms of the fee, right?
that's just not true.
Well, about what grounds?
Say it calls for facts, not evidence, but the witness is seeming like she can answer it.
Okay, the objection is withdrawn. You can proceed.
Go ahead.
That it's not true.
What were you contending that Todd McMurtry did that committed what you said was a conspiracy to defraud you and Taylor and Nicole?
Jonathan,
Jonathan,
you tried to get Todd, and he did it. In February, you started in February, and you sent Todd emails and asked for Todd to get the Sandmans to say that they wouldn't agree to the fee split that you had already agreed to on February 17th. And you asked him to please, I need for you to please help me. I need for you to ask them to do this for me. And you asked him to get them to not agree so that you could put in this whole bogus defense so that you wouldn't have to pay us what you had agreed to pay us.
hang that right there. And Todd McMurtry conspired with me to prevent you from being paid?
We believed that, I mean, I would put it the other way around. You conspired with Todd. You're the one who dragged Todd into it. But yes, that point in time, yes.
Do you think I put a gun to his head, or does he, if I got him to agree to conspire with me, then he agreed to conspire with me? And that's what you said when you sued him.
Well, you contributed $150,000 to his Senate campaign. You got him a telephone call with Jack, I forget his name, the guy who worked at the White House. And yes, you called yourself his #1 supporter. When he wouldn't answer your phone call, you texted him or emailed him and said, you better call me, your #1 supporter, or you're going to be in trouble.
Do you have any idea what time frame you're talking about?
Yes, February 2020.
Do you know when I made any contributions at Todd McMurtry's request to a PAC that was supporting him when he ran for Congress?
I don't recall the dates. It's probably here somewhere.
Go online. It's easy to find out when Todd announced he was running. And the time period is wrong, but that's argumentative about withdrawal. So are you saying to this jury that Todd McMurtry, in response to my making a campaign contribution to his PAC, would engage in a conspiracy to defraud you? Is that what your testimony is?
No, you did other things. You also paid him or paid his law firm. At first, it was supposed to be $100,000, and then I think you reduced it to $75,000 that you gave them out of your cut of the Sandman fee. So you had done that.
Not out of your
Objection,
cut.
Your Honor, she's still on.
I was done.
All right, you can continue.
It wasn't out of your cut, proposed cut.
That's correct.
You were aware of what I was trying to do and why to help Todd McMurtry and his firm out of my pocket. Were you aware of why I did that?
It was my understanding that there was some female partner who was leaving his firm who was raising some sort of issues, I don't know what exactly, and that they were trying to settle with her, and so you gave them or agreed to give them an extra 100,000. And yes, you agreed with, you said, I'm not taking that out of the part that I'm paying you. You said
Right.
that. You took that out of your share.
So you recognized it was my effort to help Todd McMurtry and his law firm settle financially a dispute that they were having with a female partner in the firm who was going to leave, right?
I believed at the time that's all it was, yes.
Now you think it was part of some conspiracy. Is that what you're telling me?
Well, now I've seen the February 22nd, 2020 emails that you sent to Todd, trying to get him to get the Sandmans to not agree to pay us what you had just agreed to pay us.
Well, I'll take on those emails and what they mean later. I understand what you think they mean.
I think,
So, but you already knew that. You had that information when you sued him, didn't you?
we had that when we sued Todd, not when we sued you.
So when you didn't have the information about the back and forth in February of 2020, at the time you sued me, it was back and forth with you. Did you not have that?
Objection,
You're talking about two
Wait, hold up.
different things.
Well, unless you,
I'm sorry.
what's the
I'm
grounds for
sorry.
the objection?
Lack of foundation and assumed facts not in evidence. I thought we were talking about.
Let me withdraw
emails
the
that
question.
Mr.
Okay.
Let me
Woodson
withdraw.
taught
All right, the
before.
question is withdrawn, so we can move on.
Save myself from having to
apologize.
do it.
I'm just,
So you sue Todd. You don't sue Joy, and I mean, the whole idea is it's somebody in your theory conspired to get Nicholas Salmon to not agree and to object to your payment of attorney's fees, right?
no, Nicholas never objected to our payment
That's
of
not what I
attorney's
asked for, Your
fees.
Honor.
Objection, Your
Yes.
Honor. He's playing along again.
Yeah, if you can finish your question.
I think you're,
You're asking her for general theories of her conspiracy, open-ended.
You know that Nicholas Sandman on January the 24th objected to the amount of fees that I had agreed to pay you and Taylor and Jonathan. True?
that's not true. First of all, I think you meant to say July 24th.
I did mean to say July 24th. Let me go back and rephrase it. You knew at some point in time after July the 24th that Nicholas Salmon had objected to paying the fees to your firm unless he received some documentation as to the services that you rendered. You knew that, didn't you?
It's not true.
Let me have George Burby's letter.
Have it. It's not true.
That's right here.
Nicholas never objected, Lynn.
That's all, that's
And it
not
wouldn't have-
responsive. That's not responsive. Don't let her start playing lawyer. Would you move to strike that?
Your Honor, it is directly responsive.
It was
You can
not.
just ask your next question, sir. You've been open-ended questions, and I think that invites commentary on her part.
Sorry?
You've been asking open-ended questions that aren't leading, and so when she has extraneous comments, that happens. So you can ask your next question.
So if I ask a non-leading question, that allows her to give extraneous comments, not in response to the question? I've never heard of
I
that.
found it responsive. You can ask your next question.
May I approach the witness?
You may.
I'm sorry. I'm trying to answer the questions.
I know you're doing the best you can. Do you have Joy Burby's letter of August 28th?
I'm sure I do. I know the letter. Is it in here, guys?
It's Defense Exhibit D12.
Which one?
D12.
Oh, defense. I don't have
Wait,
defense.
Let me, I got an extra portfolio for her.
Hold on.
Is this also a plaintiff's exhibit?
All right.
Just what exhibit number is it, guys?
It may be your exhibit 12. I'm not sure if it's yours or mine.
The 24 is D7.
That our exhibit?
Yeah, that's ours.
No, it's not 12. Who said not?
Defense 12.
Let me hand
I don't
you.
know. Is y'all want an extra portfolio?
No.
He's approaching with what's been marked as defense 12. You may.
Nicole, let me hand you what has been and will be marked as plaintiff's exhibit 7.
Your Honor, this is not
And-
plaintiff's exhibit
I
7.
think you mean defense exhibit 12.
Exhibit 7. There'll be a 12 coming after. I went with 12 when I meant to go with 7.
You just said,
You
okay.
said plaintiffs, you meant defense.
Ah.
Yes.
Plaintiff's lawyer too long. This is defense exhibit 7.
Okay.
Can I just approach and give it to her, Your Honor,
I mean, if he's got, are you giving her a copy?
and have him
If you tell me what number it is, it's in here.
find it in our book? I
Okay.
have the earlier letter and don't have that.
Okay, thank you.
Sorry.
Thank you. All right.
Book at 7.
Okay, thank you. Okay, got it.
July.
I got it. I got it.
We do have one here.
That's my water. Don't take my water, please. Thank you. It's fun. This is fun. Okay.
John,
This is the rejection.
March 17th, settlement agreement.
Yeah, I got it.
Do you have it in front of you, Nicole?
I do.
And if you don't mind, what's the number that you're looking at? What exhibit number?
I'm looking at your defendant's exhibit 7.
Thank you. So we're on the same page.
Yes,
And it's redacted.
correct.
Look at the beginning. This is a letter from Chris Marquardt of Austin Bird to Andrew Bill, your lawyer,
Correct.
dated July the 24th of 2020.
Correct.
Dear Drew,
Let me just stop there. Are you, before we publish it to the jury, and are you tendering it or?
it's not really time for me to tender my evidence, but if you want me to tender it, I will.
I mean, I think you can tender it at any point.
Well, then fine. I tender
Okay,
the
so is there an
evidence.
objection to D7?
D7.
No objection from plaintiff's, Your Honor.
Okay, then D7 is admitted. You can do what you want.
Dear Drew, I hope you and your family remain safe and well in these pandemic days. Have I read that correctly?
Yes,
The settlement agreement between our respective clients provides that LLWPC shall pay to WGW a portion of the fees, its fees earned in 3 settled cases. 2 other pending cases. Have I read that correct?
yes, and the case names are redacted. Yes.
Right. Follow on. The fee splits for these cases require client consent in order to comply with Georgia Rule of Professional Conduct 1.5E. LLWPC has therefore requested that each of the clients in question provide their consent to the fee splits. The clients in the blank cases have consented, but we have just learned that the client in the blank cases, and I think we know he's referring to Nicholas Salmon,
Yes.
has declined to consent and indicated he will only approve payment of a quantum merit fee to WGW. Accordingly, please provide LLWPC with documentation of the services rendered by WGW, including contemporaneous time records, and a proposed fee based on the total hours worked so that it may be presented to blank, which we know is Nicholas Salmon, for his review and approval. Now, next paragraph says, without client consent, the fee splits pertaining to the Salmon cases in the settlement agreement are void. The other provisions of the agreement remain valid, however, and LLWPC intends to honor them and expects for WGW to do the same. Now, and that goes on and starts talking about the lease, right?
It does. It says how much you were demanding that we pay you instead of you paying us.
No, actually, the lessor determined that you owed $285,000 on the lease and that I agreed to take that 285 that you owed the lessor out of what I paid you to make sure that the lessor got paid, in case you changed your mind, didn't want to pay. Now,
Your Honor.
None
I
of,
think that needs to be in the, that needs to be, in Mr. Wood, I'm speaking.
I wouldn't finish my question.
That doesn't matter because you already violated my directions, which is that wasn't even in the form of a question and you're testifying. So if you've got a question there, you can try it that way.
but I would like to answer that because he did make a statement that I know to be false.
Are you withdrawing the objection? Okay.
So
That is
can we go
false
back and have the court
because-
report- Wait a minute.
She
May
said-
we have the court reporter read the question back now so we'll know what
Sure.
she's responding to?
Mr. Kavanaugh,
No.
I would just, well, now I need to know the question
do
here.
too.
Okay?
Actually, the lessor determined that you owed $285,000. That I agreed to take that 285 that you owed the lesser out of what I paid you, to make sure that the lesser got paid in case you changed your mind and didn't want to pay.
Did you know that?
The answer is that is entirely false. That whole sentence is false.
What sentence?
That sentence that you said, did I know that? And what I know is that that is false. You entered into agreement with the lessor. You had already settled with the lessor in July and paid less than you had gotten us to agree to pay you in March. And what you were doing here was demanding that we pay you the 285,000, even though you had decided you weren't going to pay us what you owed us for the work we did in the Sandman cases.
So I'm confused. Let me make sure I understand. You made this agreement with respect to the $285,000 on March the 17th, right?
We agreed that the $285,000 would come out of what you were paying us for Sandman.
And you did that agreement with full advice and counsel of Andrew Bill.
Yes, we agreed to give up that money to settle the case and move on with our lives. That
Now,
was
are
the
you-
hope.
Are you testifying under oath that I had already made a deal with the landlord as of March the 17th?
Not of March, no, not as of March, no, as of July.
It was in July,
Correct.
after this deal was already made.
After what? The March
After this
17th
deal
agreement.
was made on March the 17th.
Yes.
Okay, so I thought I misunderstood
It
you.
was
but now we're
before
right.
this letter that you made the deal with the building. You were going to
I
get
did, I
more.
wanted, well, I can't testify. But I can tell you that,
Well,
do you have any basis to dispute that I made the deal with the landlord because by July, I decided that I did not want to keep the office space for myself?
Objection, Your Honor, calls for speculation.
overruled.
I am aware of that, and I am aware that you entered into the deal and you paid the landlord less than you were getting from us. Yes, I'm aware of that.
You haven't paid a dime on your responsibilities under the lease with the landlord, have you?
You have kept every penny that you agreed to pay us, Lynn. I haven't made anything for the time that we worked that you agreed to pay us for Sandman. I paid for a quarter of the lease the entire time I was there and the entire time I was working my butt off for you. And you agreed to pay us what was fair, and you agreed it was fair. And then you got angry and you decided not to pay us, and you concocted this entire scheme, and now here we are.
So I concocted a scheme with Todd McMurtry, Bowie Burby, Alston Bird, and Nicholas Sandman to not consent to the settlement. Is that's what you're saying, isn't it?
No, I'm saying that you concocted a scheme and put it into place. You paid Austin and Bird $1 million to give you a letter based on the information that you gave them. They didn't even go look at our website, Lynn. Why didn't you take the position? You could have taken the position.
All right, Ms. Wade.
Strike-
I'm sorry, I'm sorry.
Wade.
I'm
Excuse me,
sorry.
I moved to
Yep.
strike that testimony. It's not responsive and it's
All right.
hearsay. And
Jury will disregard that last statement. You can ask your next question.
let's go to, and Joey and Chris, you know they're going to be here to testify.
I do.
You've heard them testify in court before on these very issues, haven't you?
Objection, Your Honor, relevance.
Again, if they're going to be here,
But I'm talking about her knowledge today. She's sitting here saying things under oath. And I'm showing, at least I'm trying to say, that she already knows what those two lawyers are gonna say because she's heard them say it before under oath,
all right, you can proceed.
haven't you?
I have.
You think they were lying?
No, they said that they had not gone and looked at our website. They said that they were relying on the information you gave them. I've seen their bills. Yes,
Or-
I've seen it.
Or, see, where's the agreement?
Right here.
Oh.
Right here.
So if you go back to
Lynn,
the settlement agreement,
got it, you got it. Settlement
which
agreement.
I believe is your exhibit one, I'm sorry, I could be wrong.
Your
It's
exhibit one.
Yeah, I mean, y'all got it as exhibit two.
I've got it here. It's your exhibit one.
All right. It's your exhibit 102, and it's already in evidence, right?
Yes.
So look at your exhibit 102.
Okay. Go ahead. You can ask the question while I'm finding.
Said I paid Austin Bird $1 million. Do you know what I had to pay them that for?
I've seen their bills. You hired them basically to come up with opinion that you could use, try to use as an excuse to not pay us.
Oh, the bills, are you saying the bills say that? Or do the bills say that I hired them to draft and finalize an agreement with your lawyer, Mr. Field?
They say a lot more than that. I know that you paid them $100,000 retainer.
What they asked for.
They said that's what you offered. That's what they testified to.
That's what?
They testified that that's what you offered to pay them, that they did not request that.
Testimony?
Your Honor, he's interrupting.
I'm gonna bring them to court
Overruled.
to tell the jury the truth.
Good.
So let's stop for a moment and look back at the settlement agreement. It was drafted in part by your lawyer and you, according to the reciters at the end.
Objection, Your Honor, calls for facts, not in.
Your Honor, the settlement agreement's in evidence.
It's already in
I
evidence.
know, but
So
the fact that Ms. Wade somehow participated in the drafting
Well,
of it, it's
let
not like
me-
he already said the lawyers.
I thought I
prepared it.
covered this. Let's cover it again.
all right.
Look at paragraph 6B.
I reviewed it and approved it and signed it.
Yeah,
I own it. I
You own
approved
it.
it, signed it. Yes,
you own it.
I have abided by every word in the settlement agreement.
So regardless of whether that's true or not, you own it. You approved it. You agreed to it, right?
Yes,
And look now under recitals.
yes,
Whereas Nicole Wade, Jonathan Grunberg, Taylor Wilson, and Wood are lawyers who practice law and shared office space together for several years. Have I read that correctly?
yes,
You'd agreed that was true at the time, right?
yes,
Whereas WGW never held any ownership interest in L. Linwood PC, but have worked as lawyers of L. Linwood PC on cases since 2018. You agree that's the truth, don't you?
yes.
All right,
We were
now,
lawyers of your law firm. That's the truth.
worked as lawyers of, not in, but we'll fight about that later. Look at paragraph. Number one, fee split for legal work. And I apologize. Judge, do you mind if I lean on this bench?
That's fine. We'll keep moving.
Thank you. So see under fee split for legal work,
I do.
see paragraph A,
I do.
read that to the jury, please.
LLWPC shall pay to WGW a portion of its fees for the following cases as set forth herein, or, as applicable, WGW will pay a portion of fees to LLWPC, subject to the offset for lease expenses described in Section 2 below.
So the agreement for the split of fees and payment of fees was not with L. Lynn Wood. It was by the very terms of the agreement that you helped negotiate. It was the obligation of L. Lynn Wood PC, right? Oh, we just read it.
Yes, I mean, that's you, but yes.
Thank you. And it goes on it several times and talks about what LLWPC would pay. And then L. Lynn Wood entered into some other agreement, but the agreement to split the fee and pay it was on the part of L. Lynn Wood PC, who had been hired to receive the fee, if any, right? Hired by Todd McMurtry.
Well, hired by the clients, the
By the client, I'm sorry.
agreement was with the clients. Yes, I know now that your lawyers had put LN Wood and LLWPC and you changed it to LLWPC.
Now, you say I changed. What evidence do you have that I changed it? Strike that, doesn't matter. Whoever changed it, Ms. Wade,
We'll see it.
whoever changed it, you signed it
I did sign it.
and you own it.
I trusted you, Lynn.
No, you
I
trusted
did.
yourself, ma'am. You read your own document. Your lawyer negotiated it. Did you trust your lawyer?
I trusted you.
Did you trust your lawyer?
Trusted you.
I ask you, did you trust your lawyer?
Yes, I trust my
And
lawyer.
he drafted it with my lawyer, and you looked at it, and they looked at it, and it became, as you say, your agreement, quote unquote, your words, I own it, right?
Yes.
Now, do y'all have in your numbers for her to look at for Joey Burby's August 28th, 2020 letter to you, Andrew?
D12. That's D12.
It's D12 for us.
I wasn't planning on using it. It'll take me a minute to
No,
find it.
they haven't. They just said what it was.
Let's just go to the D.
Okay.
D.
So let's
It's gonna
go,
be as
and
D12.
we'll submit a copy that's not highlighted, Judge.
Oh, the court already has an electronic version,
Which exhibit?
D12.
I should.
Defendant's 12.
Yep.
Okay.
Do you have it in front of you, Nicole?
I
So, Your
do.
Honor, at this time, I would tender into evidence defendant's exhibit number 12. Make a note that it's admitted.
Your Honor, we have an objection, multiple objections to this exhibit.
Okay. Just generally what on the grounds.
Then hearsay and also,
Okay. All right. Why don't we, counsel, you can approach to lay your objections on the record.
Yes, sir.
Every letter along the lines, on the hearsay, but he had knowledge of it. So from the standpoint, if it's hearsay, then we could. She's gonna say she was well. Bill's gonna be great.
Or is the dragon to step into the back so we can hear you from this little bit?
What's next?
All right, the jury's.
Margaret, sit some down.
Okay, let me get the objection on this down and then be with you. All right, Ms. Wade, you can step down. It'll probably be a few minutes here. Ms. Brown, if you just want to lay out the full basis of your objection here to D12.
Your Honor, can I?
Can I
Take
pass
this.
the baton?
It's fine.
It's hearsay because in it, Alstenberg talks about what co-counsel Todd McMurtry is saying about what Nicholas Sandman might have said to him. And there's no authentication. This letter came from Chris to me. And so, you know, certainly when Chris comes in, he'd be a better source for this. But it is hearsay upon hearsay. They're talking about settling the case. If you do this, we'll figure out numbers. It doesn't swap numbers in this, but we also think that it is part and parcel of settlement negotiations.
May I respond real quick?
You may.
Number one, he's wrong. This is Joey Burby's letter, not Chris Marquardt. It takes time to read it. This is a letter, and Joey will testify to it. There's no hearsay in here. This isn't settlement negotiations. This is Joy informing Drew of the problem of getting the client to consent. And Mr. Bill got it. I'm sure he acknowledges that he got it. I don't think he would lie about that. And I'm sure that his clients were aware of it. I only have one area that I want to ask about right now, but this document is clearly admissible, subject to Mr. Burby coming to court and testifying to it, which Your Honor may not know, but Mr. Bill knows that Mr. Burby has already done so in the federal case. This is no surprise. This has been authenticated. This is the real deal. It tells the truth.
Your Honor, nobody has said that it was a surprise. It hasn't been authenticated in this case. The fact that a verdict was rendered across town in another courtroom doesn't have any bearing on us here. And if Joey, as counsel has said, as Mr. Wood has said, Joey's going to come and authenticate it and talk about it, it's a much better witness for him to put it in with. I shared all the communications with my clients with their knowledge of individual pieces of mail are always going to be different from the sender or the recipient. And that's
All right. And to
hearsay at this point. If Joey wants to come in and say, I wrote it for this reason, it could be a hearsay exception. But at this point,
May I respond briefly?
what is, well, and let me direct you in this way. What is you're trying to prove through this, the fact that they communicated and made this demand to her? Is it as simple as that?
No,
Then what else are you trying to prove with this?
what the letter says. But what I'm trying to show in the letter, as it says, is that they've been complaining about timesheets. Joey Burby made it clear. Does your client not possess time records reflecting how many hours they worked on the cases? If that is the case, can they not prepare an affidavit describing their work, estimating the number of hours involved, and proposing a total fee based on an hourly rate, akin to what would be included in a fee petition to a court? So Mr. Burby was saying and said very clearly to Drew Beal, who I think very clearly communicated to Wade, Grunberg, and Wilson, that Joy was willing to get an affidavit from them describing their work. And they knew it. The problem is they didn't do it. They didn't do anything. And I think I'm entitled to show on cross-examination of Ms. Wade that the request was made and established that no affidavit was prepared. That's all I want to get.
Okay. And with that, I mean, the only core thing I'm really zoning in on here is that there are representations of what Sandman told to him, which he's then telling to them. So I do see that as something that shouldn't be coming in through this letter.
Thank you, Ron.
But the rest of it is just simply conveying a demand for timesheets and that sort of thing, and that seems fair game.
He can certainly ask her. Did they ever ask for timesheets? Did they ask for an affidavit? Did they do any of that? I'm sure she's gonna say yes, yes, and yes. But getting this document in builds in the hearsay.
No, it doesn't.
Well, Bill, you mean the remaining aspects of this?
Sure.
Or-
And he's coming in himself, so he can
Yeah.
just ask her, did my clients, did I ever ask through my attorneys for timesheets? She's gonna say, absolutely.
She who? She who?
Absolutely.
She who?
And she has never, can I just go ahead and finish?
I just wasn't sure you're talking
Can
about.
I just go ahead and finish?
Absolutely.
All right, we don't need to get back and forth
One thing
again.
to remember here. Sorry, Ron. Is that she has testified to that. Everybody's testified to that. Did we ever ask for timesheets? Yes, you did. So there's no point in putting in a hearsay document to get to the same thing. They can just ask her.
There's no way, Your Honor, that this is a hearsay
I
document.
don't need to hear anymore. I'm ready to rule. So, I mean, again, it's coming back to what is the definition of hearsay? And what I'm hearing from Mr. Wood is he's not actually putting it in for whatever truth is being asserted in here. It's the fact that there was a request made of her. Regardless, the statement within it talking about what Sandman said at some point should not be referred to. If this document is going to be admitted, that should be redacted as part of the record. But if he's just simply confirming and showing them that there was a request made for timesheets at some point in August, which shows that I believed there was a 1.5 dispute, then I think, again, that's going to the state of mind. It's going to some of these other issues that have been percolating.
If we're gonna redact that
Okay.
one paragraph,
All right. I'll clear there.
Let me try to do it this way, if you don't mind. Instead of trying to redact and put it into evidence now, let me try to ask her a question or two that will not create the concerns he has, but will address the testimony I need from her. Okay?
All right. So you withdraw on the tendering of 12. You can ask about the contents, the fact that she was sent a letter, what she did in response to it, but the statements within documenting or purporting to document what Sandman may have conveyed
Well, we know
is not what comes in. That might come in through other ways, but it shouldn't come in through this way.
Yeah, we know the truth of the matter, what Simon did.
Um,
Hear the truth. Let me try it again. Let me try it this way.
1.3 matter.
Sure. We're going to have to take up a few things though. Yeah.
Counsel has repeatedly nicknamed clients Young Taylor.
Ah,
There've been some nicknames in this case and they need to stop. And that needs to stop here for any reason, whether it is a good faith mistake or a bad faith or whatever. But it can get out of control in a hurry, as Your Honor can probably imagine, and it has in this case. So I would like really renaming people to cease immediately. And
Okay. We don't need a long discussion of this. I would just say this. Look, there's no denying that there's a long history here. There are personal relationships. Frankly, it makes me a little uneasy when people are referring to each other by their first names. I mean, we're supposed to be a little more formal than that. So I would just say to all sides, let's remember the formality of where we are. Okay?
I mean, if you want us to go by Mr. and Ms. or whatever, I'm happy to do that.
Let's just stick to that.
He just can't call him young Taylor. That's.
Right,
Okay.
he objected, I call my puppies puppies. You're just doing that to get sympathy. Are you kidding me?
That may be some other case. I don't really remember
Yeah, it
that.
was.
Okay.
Here's
Here's the bottom line. I want to weigh in. I do want to give you all a second. I know our court reporter needs a minute. But just the way things have been going, I'm going to be bringing back the clocks. And so we're going to have a discussion of exactly how much time to allot per witness from here on out. Because at this point, I don't think the Monday estimate plaintiffs gave me was accurate. I'm not saying and weighing in at this point of why, but I don't see that Monday date being accurate. Maybe you can surprise me, Mr. Beal, and say that I'm wrong here on that point.
Well, the next two witnesses are correspondingly shorter. The third one is the much shorter. I didn't know that we were going to hear Mr. Wood's legal career and stuff, and
I get it. So we're going on, by my estimates, we're coming up on the 4th hour of cross here. She was on the stand for about 4 to 4.5 hours. She was,
Staying all yesterday afternoon.
I've kept track. She was on the stand about 4.5 hours. Remember, we had
She was on the
openings.
stand this morning for how long?
It was from 9:40 when we started, and we turned it over to you at right about 10:05. I've got it. So regardless, we're going to get through this witness, but then we're going to start imposing clocks for all the witnesses going forward.
As long as it's fair.
And from here on out, do you have any idea of an estimate of how much longer or how many other topics you have on this way generally?
If I heard Your Honor correctly, if you'll give me part of that break, 10 minutes, I'll confer with my folks and try to come back with a solid answer.
All right. Let's
It's
come
not
back.
going to be that much longer, but then what does that mean? That's in the eye of the beholder. I'll come in here and say, well, it's going to be an
Okay,
hour.
let's take advantage of this break before the jury tells us they're ready.
10 minutes. Thank you. Man, I don't know why you're.
Thank you, sir.
But it would be my preference that you leave. These two ladies, so they have been, I just don't want them to put these two. Yeah, these two ladies with letters.
What's that? He can express his preference, but
Yeah, you can express it.
it's up to them. They want to stay, they can stay.
Yeah. Yeah. I got you. He can express his preference. If they want to stay, they can stay. If they want to leave, they can leave. It's all important. Because we know.
Thank you.
Yeah. No, I'm trying. Who got killers? Okay, I'm trying to figure who's.
yeah, you're
Look at the. Put that on, the onus goes back on them.
Yeah. The second.
Feels warm in here. Maybe she's all her
It is.
I appreciate
Is the monitors back on?
Right. He can't handle it from That's. It's fragile, no ego can't handle it. Thank you so much for your help.
Oh, no problem. You see,
I hear when this week's gonna be over.
that's why the judge trying to put time clocks now back. Because if not, it's already went past that estimate time of.
Predicted that at lunch.
He already, that's why the judge said we're gonna bring back the clocks. Cause, yeah, it's.
Yeah. Said you can want everything. You could say, I've never seen that before. Really?
There's that, but.
Well,
That's amazing.
No worries.
You know, I did.
Yes.
I thought, no, this one.
Good afternoon.
What I did this? Thanks, Judge. Scott, you good?
No, I do not want you and I'm gonna start laughing.
Okay. Oh, yeah, absolutely. Absolutely.
Going, exactly. But I do appreciate. It's short. And it's short.
Your Honor, Mr. Wood's on his way, just forgot his cane, he's moving slower, I guess go give it to him. Do you want? Yes, sir.
Sure, let's go ahead and do that.
Apologize, Judge. I went downstairs without my cane, so I walk about twice as slow.
All right, understood. I think we're ready to get back to it. Let's bring in the jury. We're on the record again. Do you have an update for me, Mr. Wood? You said on time remaining?
I'd like to believe that I can wrap this witness up in 30 minutes or less.
All right.
And I hope it's less.
And from there, Mr. Beal, for your next witness, sorry to interrupt here mid-sentence here, but for your next witness, what would be the time you'd be requesting?
Well, depending on how long the objections go and or interruptions.
I mean, I'll say this, I will pause the clocks for extended objections. Some I can rule summarily where it's 5 to 10 seconds. And I'm not going to pause it at the outset for that. So
3 hours, Your Honor. Most.
So. Get me the sound. Okay. There's the loading movements.
oh, no, that's from. Yeah.
Here's the president, Judge.
Thank you, Deputy Scott. Please be seated. Defense may resume.
May I proceed, Your Honor?
You may.
Thank you. Judge, if you would let the jury know that Mr. Bills requested that we refer to everybody by Mr. or Mrs. So
No, that was my idea. You can
just
do
wanted
full
to-
names or more formal titles, okay? And that's it.
I won't say Nicole anymore in court.
All right.
Ms. Wade. Did you ever prepare an affidavit describing your work on the Nicholas Salmon case?
Did I ever prepare an affidavit? No, we offered to, but no.
Who did you make that offer to?
Todd McMurtry?
Did you ever make that offer to Joey Burby?
I don't know if Drew did or not. I know we talked to Todd.
Did you know that Joey Burby had asked for an affidavit?
I know he asked for time records.
Did you know whether he asked for an affidavit describing your work?
I don't recall if he asked for an affidavit. He very well may have.
You remember?
Yes, he did.
He did, didn't
He did ask for an affidavit,
he?
estimating the number of hours akin to what would be included in a fee petition to a court is what he requested, which would have been based on time records, which we didn't keep.
The question is, he requested an affidavit, as you say you described it. Did you prepare and provide him with an affidavit?
No,
Do you remember back when y'all sent me a copy of the lawsuit that you were going to file against me in August of 2020?
yes, I remember that.
And you accompanied it with a settlement demand.
No, we asked you at that point in time to pay us what you owed us, that you had agreed under the contract. That's what we asked at the time that we sent you the draft complaint. We said, just pay us what you owe us, what you agreed to pay us.
You asked for 1.5 million.
Objection, Your
No,
Honor.
that's
That's-
not true.
Well, I've got the documents if she doesn't want to just acknowledge it.
Objection, Your Honor.
It's not true.
Okay, so we're going to stop there. And I'll ask the jury to disregard that testimony. Next question, Mr. Wood.
Did you make a demand to Mr. Burby, Mr. Beal, when you sent in the complaint? Did you make a demand in writing?
Objection, Your Honor.
Yeah, I don't know why settlement negotiations are admissible, Mr. Wood.
It goes to, I don't know, it goes to good faith. They make a demand I offered to.
I
go
don't need to hear the
arbitration.
details. I don't need to hear the details.
Well, you asked me.
I just wanted to know under the rules, but I think under Rule 408, it's pretty clear that offers or statements made in compromise are not admissible. So unless you can tell me why that doesn't apply, then I think we move on.
State of mind.
That is
I mean, it's just the truth. Why do we not want to tell the truth?
because we want to follow the rules of evidence,
We
Mr.
haven't been following them very closely lately, Judge.
Mr. Wood,
Yes,
tread lightly, please.
I have been.
All right. All right. Sustain. Next question.
Do you recall close in time to when you sent your proposed complaint that you were going to file against me? That was late August, remember?
Yes,
Do you remember that within just a matter of 2 or 3 days before that, that I had referred to you a potential client, Otis Redding III,
yes,
the son of Otis Redding Jr.,
yes,
about a family type estate issue which you were an expert in?
I won't claim to be an expert, but I am experienced in that area. Yes, and yes, you
But you're
did.
not an expert in that area.
I mean, as a lawyer, we're not supposed to claim to be experts. So I'm not going to violate the bar rules, so, but
Neither am I. Shouldn't violate that. Nobody should violate a bar rule, should they?
well, not lawyers.
Not lawyers. Or lawyers advising clients. Clients, you would not advise your client to do something that you believed violated a bar rule, would you?
No, I would not.
No. You recall sending me the text message on February the 10th at 7:50 p.m. And I'm happy to let you see it if you don't remember it. I can read it and see if it refreshes you.
Is that the one that you recited in the opening? I recall sending that, yes.
Thanks for calling. I'm sorry how things ended up this morning. We were both tired and scared, and I'm sorry that it has resulted in where we are now. I know you have been having a difficult time, and I'm truly am sorry for what you've been through. I had no idea what was going on with your family until last week. I don't know what was said to you today, but I want you to know that I don't think you're crazy. Never have. Never have thought that, have you?
I didn't think you were crazy, no.
Never have thought that, have you?
At some point, I didn't know what to think anymore, but
What
I
point?
don't have an opinion anymore. I did not think that at that time.
You're not now saying that you thought that I was mentally ill, are you?
I said before that I don't know what happened. That's all.
So
I
you're
can
not in a
say.
position to comment except what you do know, and what you do know from all of your interactions with me is what you said here on February the 10th of 2020. I don't think you're crazy, never have, right?
My interactions with you since that text
Didn't
have
ask you
been.
about that.
You did.
I asked you about February the 10th.
Finish your response.
I believe that you asked me even since then, and things were very different on February 10th, 2020, and everything has changed since then, unfortunately.
So as of February the 10th of 2020, based on your years of knowledge of working with me and my career, you never thought I was crazy, did you?
That's correct.
And at the time we signed the settlement agreement of March 17th of 2020, you affirmed that I was mentally and physically competent at all times, including the past when the various agreements had been negotiated, right?
Yes, I believe you knew exactly what you were doing.
I want to make a suggestion. Go get a physical, and even an MRI. Show your family you're listening to them and that you want to show them nothing is physically wrong. What's the harm? I know that these problems with them are ripping you apart, and it hurts my heart to see it. Have I read that correctly?
Yes,
That's what you wrote on February the 10th at 7:50 p.m., right?
I think
and you
that's
told the
right.
truth.
I did.
And then you said, just my 2 cents. I do love you. Always have. And whatever happens to our law practice, if you need me, I will be there for you. Have I read that correctly?
Yes, you have.
Is that what you said to me on February the 10th at 7:50 p.m.?
Yes,
And was it the truth when you wrote it?
yes.
And let me ask you, because this issue is still I'm going to ask Your Honor to follow closely my questions because I don't want to cross any lines. I'm not asking you about the substance, okay?
Okay.
I'm asking you, are you aware of an affidavit signed by Nicholas Sandman under oath dated February the 8th of 2021?
I am.
Now, I'm not asking you about telling us what's in that affidavit. My question is very precise. When did you first become aware of that affidavit?
I'm not sure at some point in this litigation. I'm not sure when.
Do you think it was closer in time to when it would have been provided to your counsel?
I'm sure I saw it right after it was provided to my counsel, whenever that was. I just don't recall.
And again, if you'll listen, follow me carefully. Whatever that affidavit said, I'm not asking you that until the judge admits it into evidence, if he does. But whatever was in that affidavit, you reviewed it, right?
Yes,
And you were totally aware of what Mr. Sandman said in that affidavit. True?
true.
You had that state of knowledge.
Yes.
May I just have a couple of minutes to confer with? Told you I was going to try to bring you another 30 minutes, didn't I?
Oh.
It's the one up there, I think. I guess it. Thank you. Yes, sir. Unfortunately, that's not it. So, that's it. One other thing. I think I see it. Okay. Bear with me if you would, John. You talked about what I kiddingly characterized as the Valentine's Day Massacre, February the 14th, 2020, remember?
I don't think it was kiddingly,
You think I
but
was gonna kill people?
I don't know what you thought, Lynn, but we talked about the Valentine's Day Massacre, yes.
And we were set to have a meeting at my office and have lunch and discuss the plans for Wood, Wilson, Grunberg, and Wade. Do you remember that?
I do, yes,
But y'all decided not to attend that meeting, right?
correct.
Did you know that I did not go to the office that day because I knew you weren't going to show up?
I don't know why you didn't go to the office. You called us and said you were on your way. That's when we left. I don't know what you did or didn't do.
So then I get a phone call. I'm told,
Objection, Your Honor,
I
testimony.
haven't finished, Your Honor. This is why things are taking so long.
You
So,
can finish that question.
so you know that a phone call was placed to me by Jonathan Grunberg telling me that y'all would talk to me on your time, which he said would be 2:30 that afternoon. You remember that?
I think he said after lunch, that he may have said 2:30 then. I don't recall exactly, but yes, I think it was 2:30. And
Yeah.
yes, I think he said that.
Y'all were all over at your house
Well, we went to lunch first.
and you took my employee, an employee solely of L. Linwood PC, Kimmy Hart Bennett, with you.
I didn't take anybody anywhere.
She was there. Somebody asked her to come.
I don't think anybody asked anybody to come. We just
But you don't know.
we just all left. I mean, she was there.
So the question is, Mr. Grunberg has recorded many conversations. Did he record that conversation when he called me at 2:30? Do you know? He's saying yes.
I don't know.
Well, let me ask you
Don't
this.
remember.
Have you seen a transcript of it or the tape itself? Have we had it produced to us? True. And Mr. Bill?
The witness can answer if she knows, Your Honor.
And I'm trying to make it get to the point.
Let's hear it.
So did you not see Mr. Grunberg when he called me that he had a recorder, his phone, maybe a recorder, I don't know.
I just don't remember. That was a crazy day and I don't remember.
Have you ever gone back and listened to his recording of that conversation and what he said to me and how he said it?
Not that I recall. I tried not to listen to things if I didn't have to. I don't recall hearing that. I mean, I was there, so I heard what happened at the time. We all talked to you, but I don't recall listening to anything.
You recall him telling me this is the way it's going to be?
I don't.
It'll leave it?
I remember him telling you that we were not going to come back if things did not change, something along those lines. Jonathan will be able to testify better to that, but I remember something along those lines.
And could you hear the conversation?
Yes,
Did I respond? Don't worry about it. You're locked out of the office. You got until 5 o'clock to get out. Remember that?
something along those lines, yes.
You remember the next day when after I had met with the office landlord that presented me with a copy of the lease, that an offer was made back to you all to come back to the office because you were on the lease. Do you remember that?
No, we were not able to get back into the office. At one point, I think you said that you had allowed us to come back and get the rest of our things. But I know that we had many communications with the building and we could not access the office until March 17th when we signed the agreement. That was the first time we were able to come back in and get all of our files and the rest of our belongings.
So we had the opportunity to come that afternoon on the 14th, didn't you?
We had about 45 minutes, I think. We raced down there. We got the stuff. Like I said, I took my computer. I left the computer that you had given me. I took my computer and some of my personal things. I mean, it was all crazy. We had a minute to go get some of our personal things, yes, but I couldn't take all of my boxes or my
I give
files.
you, Taylor and Jonathan and Chelsea, access for the next few days, at least through the weekend, to get your files off of Dropbox or your emails.
No. You need,
Deny that.
I do deny that. I don't remember when you shut off our access. It was that weekend. It was some point that weekend you shut down our access. And then I was never able to get my emails and was only able to get my files again. Kimmy transferred them to me after we signed the March 17th agreement.
You deny that you and Chelsea accessed Dropbox over the weekend, which I saw on the Dropbox.
I have no idea what Chelsea did or didn't do. I don't know why she would have done that. I'm sure I did. I'm sure I was trying to get my files.
And accessed the files on Dropbox.
I'm sure I did. I was trying to get my client files. Yeah, I'm sure I did.
And you were able to.
At some point I was, and then at some point you shut it off. I don't remember when that occurred. I think
Apparently-
it was that weekend.
Apparently it was not shut off that weekend because you accessed it, right?
I just don't recall. There was a time period when I was able to access it, and then there was a time period when I wasn't. And I don't recall when it was.
Talked about this. Were you aware that I had serious concerns that you and others had hacked my computer to obtain information?
I am aware that you said that you had those concerns.
And that ultimately I sent a letter asking for an investigation to the FBI.
I'm aware that you filled out an online complaint form that the FBI has.
And you are aware that within a short period of time after I met with Tyler Jones, for whatever reason, I made the decision to write the FBI and say, I withdraw my complaint. You aware of that?
I'm not sure if I know what when the timing was as far as meeting with Tyler Jones, but I know that you withdrew the complaint and then you sent it around an email saying, I was wrong. None of these people have done anything illegal.
And I wrote each one of y'all. And I said, I can't prove what I thought had happened. And I retracted the statements. And I apologized, didn't I?
You did, yes.
I even went so far as to say, look, if despite this retraction and apology, you still feel the need to sue me for defamation, I understand. And you should. Remember that?
There was something along those lines. I don't remember
Oh.
the exact wording, but it was something along those lines.
Thank you very much, Ms. Wade. God bless you.
All right, any redirect?
Yes, Your Honor, briefly. Okay, Nicole, I know we've talked, there's been a lot going on, so I'm gonna try to boil this down. We heard some testimony about a defendant Wood reposting some pictures of Jonathan's children. Do you remember that?
Yes.
Okay, the photos that defendant Wood posted, those are of Mr. Grunberg's minor children, is that right?
Yes, that's correct.
And did you see any of the responses to these posting of Mr. Grunberg's minor children on the reply channel that defendant Wood has on
Yes,
Telegram?
I saw a lot of the replies. They were disgusting.
And did some of the replies include comments about pedophilia?
Yes.
And you saw no evidence of Mr. Grunberg or Mr. Wilson conspiring with any of Lynn's children about his mental health or mental health evaluation?
There's no evidence whatsoever that anyone conspired with anybody about anything about his mental health.
And there was some testimony about the eat what you kill model. Do you remember that?
Yes.
Eat what you kill, that doesn't necessarily mean if you're working on a case that another lawyer has brought into a firm that you don't receive any compensation on that case just because you
Objection,
didn't
Your Honor,
originate it.
Leading.
Okay, overruled, all out.
No, I mean, that's the term that's used more for the equity partnership. So it's more of as an equity partner, you eat what you kill. It's such a bad phrase, but the lawyers use it all the time. For non-equity partners and obviously associates and so forth, I mean, no, you're doing work. A lot of times the non-equity partners will be referred to as service partners because you're servicing other people's clients. And of course, you're getting paid to do the work. But the theory is just that, if you have your own shop, for example, then you can't do work for other people. So then you're definitely on your own. But I mean, no, it's if you're doing the work, you're supposed to get paid for the work you're doing.
And the money that Ellenwood PC was paid in the Ramsey case, that the testimony was spoken about, all of that money came from a lawsuit that the four of you guys worked on for quite some time.
Yes.
And how much did Lynn get paid on that case?
I think we got about 45%. So 3, 4, can't do that math. 4 million? I don't know what that math is.
Would you say more than 2 million?
Yes, it's had to be more than 2 million. More than, I don't know. I can't do the math. I'm sorry. I've been up here too long.
That's
A
okay.
few million.
And so the 750,000, I think it was, that he paid each of you guys, was that in line with your normal compensation on contingency fee cases of what you guys would earn in your split?
Objection to the form of the question. There's no testimony to establish quote unquote normal compensation. They were paid they've admitted on a case by case basis under.
Okay, I understand the objection. This is the form. I think that ground was covered on cross. To the extent she can answer it, she can. It's overruled.
Go ahead, Nicole.
For the majority, for every contingency fee case that I recall being paid for, we received somewhere between 15 and 18% each. There were, I mean, it was usually 15. And then for Ramsey, that's the one that I mentioned before, where he said the compensation committee has met and they say that it's going to be 18. And then for Sandman, the discussion was that it would be 20, 15, 15. So it's always between 45 and 50%.
And so the amount that you guys received on the Ramsey case was within that range?
Yes.
And we also heard some testimony about hourly clients and how you were compensated for that at Ellenwood PC. Do you remember that testimony?
Yes.
So defendant Wood kept a percentage of every hour you worked, even if he did not do anything on that case. Is that right?
Correct.
And you still continued to pay during that time a fourth of the monthly overhead for Ellenwood PC?
Yes.
And do you remember that there's some testimony about the various salmon lawsuits and there being others?
Yes.
You and Mr. Wilson and Mr. Grunberg, y'all are the ones that drafted the complaints for all of the salmon lawsuits. Is that right?
Yes. I mean, a lot more than just drafting the complaints, but yes, we're the ones who did all of the work.
And did you receive any of the interest from the delay in settlement to wait until Nick turned 18?
We've never received one thin dime for all the work we did for the Sandman case. Not interest, not what he agreed to pay us, not. We've never been paid anything for all of that work.
And in regards to the Sandman matters, we heard some testimony about a request about your time or an affidavit. You didn't prepare any such affidavit because you had a settlement agreement with the defendants. Is that right?
Correct. It was the whole thing, the whole request was bogus. We worked at Lynn's firm. 1.5 didn't apply. There was nothing. I mean, Lynn had every record he could want about everything we had done. He had all of our emails. He had all of our paper files. He had everything on Dropbox, every draft, every letter. He had everything. It was not a legitimate request, and it was not a legitimate request. We know now that it was at his insistence that Joey requested that because they knew that we didn't have time records.
And,
And if we had, Lynn would have had them, not us.
and we heard some testimony about some affidavit that Mr. Stamen signed in February of 2021. Do you remember that?
I do.
So the execution of that settlement, or excuse me, that affidavit, that was a year after the events we discussed, the majority of the events we've been discussing yesterday and today.
Objections, Your Honor. This states the time period. July to,
Well, we don't know. We haven't heard her testimony. If you want to,
all right, I have
Yeah.
to recross it.
It depends on which events you're talking about. There were events that happened in February, such as us leaving, such as Lynn telling Todd McMurtry to get the Salmons to not agree. So with respect to that, it was about a year after that. Other things that happened, the settlement agreement in March, it was 10 months, however many months that is, 11 months. The stuff after July, it was 7 months, however many months that is.
And you didn't become aware of that until after some time you filed this lawsuit. I believe you testified, is that right?
Correct. It didn't occur until after we filed this lawsuit.
Thank you. Nothing further, Your Honor.
all right, recross on those points only.
Thank you, Your Honor. Could you take a look at plaintiff's exhibit 61?
Yes.
Partnership structure. This was an agreement between,
Objection, Your Honor, outside the scope of reading.
Wait,
they went into compensation. This is about compensation.
Reminder, I need to see pull up 61. So just
Plaintiff 61, not defendants.
plaintiff 61.
Thank you.
Okay. 61.
Yes.
All right, you can proceed.
Are you familiar with that document?
I am.
You drafted it, didn't you?
Yes.
Look at paragraph, and this was dated April 21, 2015. That's when, that coincided with when you joined over working at my office at Ellenwood PC, right?
That's when I joined Ellenwood PC.
And paragraph 4,
Yes.
Nicole will receive payment for her time spent on clients generated jointly by Lynn and Nicole, either a fixed hourly rate or a percentage to be agreed upon on a case-by-case basis. Have I read that correctly?
Yes.
Paragraph 7, Nicole will have no capital contribution obligation and will not be required to guarantee any leases or lines of credit during her first year after joining Ellenwood PC. Have I read that correctly?
Yes.
Paragraph 9, Lynn will retain all decision-making authority over Ellenwood PC and its operations. And Nicole will maintain full decision-making authority with respect to her clients and their cases. Have I read that correctly?
Yes.
The structure in Nicole's partnership will be reevaluated and potentially renegotiated after 1 year. Have I read that correctly?
Yes.
And then you prepared a document, page 2, and you said what Nicole brings to Ellenwood PC. You see that?
Yes.
And you said her own book of business
Yes.
estimated to be at least $500,000 per year.
Yes.
You never came close to bringing any book of business.
Objection, Your Honor, outside the scope of redirect.
I disagree. I think you opened it up. So you can proceed. Overruled.
You didn't bring $500,000 worth of business each year to Ellenwood from your book of business, did you?
No, I don't. Well, no.
You set up Wade Law LLC.
Yes,
Jonathan Grunberg, I've been calling him Grunberg all my life. Grunberg LLC, right?
I think it's JD Grunberg. I don't recall, but he set up
In his name.
He set
And
up an
then
LLC. in
Taylor
his name.
Wilson set up G. Taylor Wilson LLC, right?
Objection, Your
I think
Honor.
so.
Yeah, now we are beyond the scope of reclass.
This is on the fee splits, if you'll bear with me. I'm almost done, Judge.
We've talked a lot about this already.
Not about this. And it's
All
going
right.
to be about 3 questions if I can get through it.
You can proceed.
And then Mr. Grunberg and Mr. Wilson, they also formed another LLC called Grunberg and Wilson, right?
Yes,
And you were aware that any monies that L. Linwood PC paid to you were paid to Wade Law LLC, right?
after August of 2020.
So prior to August of 2020, who did you receive compensation from? I mean, in other words, when the Ramsey case settled and you got $750,000,
Oh.
who did I pay that to?
I'm sorry, I misspoke. 2015. I'm sorry, I
Thank you.
misspoke. I'm sorry.
2015.
After August of 2015.
Everything went to Wade Law LLC.
After August of 2015, everything went to Wade Law LLC.
And then sometimes payments to Grunberg and Taylor Wilson. And sometimes individually to Taylor Wilson LLC. Strike that. You were aware that there were some cases where you did not work and Grunberg and Wilson LLC got a fee and you did not.
Yes,
So it wasn't some across the board deal, was it?
I mean, if they did hourly work, they got paid for their hourly work. And on contingency fee cases, it depends on who
Whether,
worked on it.
and if you had not worked on the contingency fee case, but there were instances where they received to their individual or joint LLC fees, but you did not, right?
Correct.
And last question. You received from L. Linwood PC each year after you came to the office, I believe we said in May of 2015, 2015, 2016, 2017, 2018, 2019, you received from my office or through Danny Olive, my accountant, you received a 1099 reflecting the monies that had been paid to Wade Law LLC, right?
Yes, the first year for 2015, I got 2 1099s, one for me individually and one for my firm. And then for the other years, I got 1099s just to the firm because the money was going through the firm.
And you had not, the reason you got 2 in 2015 is you had not yet completely set up your LLC.
I hadn't set up an LLC at all when I came over. That's why this
Okay.
just is my name and I didn't have an LLC.
Whatever monies you received from L. Linwood PC, they were reported as income on a 1099 independent contractor form, true?
I don't know what the form is called. It's a 1099 form. I don't know what it's called.
You're not familiar with the 1099 that has to be issued to independent contractors?
I'm just not sure what the name of the form is, Lynn. It's a 1099. I know it goes to independent contractors.
And did you use it to report your tax income for purposes of determining your tax liability? Did you use the 1099s for that purpose?
Yes,
And it is true that from May the 15th, when you came over to my office space, until the day that our relationship terminated, that you never received a salary. True?
A salary? Yeah, no, I
Salary.
didn't receive a salary. I was a partner. I didn't receive a salary. I didn't
And-
expect one.
Whatever happened before, you will admit that at least as of February the 14th, our relationship, whatever it was, completely terminated. True?
If that were true, I wouldn't be sitting here with you cross-examining me again, but I don't know how to answer that. We left the law firm on February 15th.
And you were in essence told to leave. You were fired.
I'm sorry.
You were fired. Get your belongings, get out of my office. Then I found out, I'll go into that when I testify. You were fired.
I was not fired, Lynn. We left.
What happened? Did you
All right,
just
now
quit?
we are beyond cross. I don't remember anything about
Let me cover
firing.
this one point, because
No,
it goes to the way the income was paid. So whether you were fired or whether you quit, our business relationship ended on February the 14th of 2020. True?
Mostly, except that we were still co-counsel on a couple of cases and we had agreements about those cases. So it's hard for me to answer it the way you want me to.
Well, I don't want you to answer anyway. We thereafter negotiated an agreement with your lawyer, my lawyers, on how to handle cases that were still pending. Right?
Before that, you and we made an agreement on February 17th as to how we would handle things that had been settled and some of the things that were still pending. On March 17th, we again entered into an agreement with you on how things would be paid that had been settled and some that were still pending.
I think I follow you. On February the 17th, we entered into an agreement on how to divide up the contingencies to be divided. But then we had to incorporate that into the final agreement of March the 17th, which covered all issues in dispute. Is that a fair statement?
Yes.
Sorry.
Yes.
As of February the 17th of 2020, you and Mr. Wilson and Mr. Grunberg had absolutely nothing to do in terms of working in my law firm or for my law firm or on behalf of my law firm. Those days had ended. True?
Again, that's not entirely true because the discussion we had on February 17th, at that point in time, you wanted Taylor to continue finishing the settlement for the Salmon CNN. He had drafted the settlement agreement and he had drafted the papers to be presented to the probate court. So he agreed to continue doing that. You asked Jonathan to continue, I don't even remember what case it was, something Jonathan was working on. We were still co-counsel for another client. So I can't answer that the way you want me to because there were things going on.
I don't want you to answer it any other way than to tell the truth.
That's the truth.
Before March the 17th, no matter what I might have asked Jonathan to do on the 17th or Taylor, Mr. Wilson to do, those requests were withdrawn. There was no relationship in terms of sharing fees between my firm and your law firm as of March the 17th. Those days had ended. True?
Again, there was never an agreement between
Overruled.
your law firm and our law firm because we didn't have a law firm before we left Ellenwood PC.
You didn't have what?
We didn't have a law firm before we left Ellenwood PC. So you had agreements with each of us to pay us certain things. As of March 17th, we had left. You still had agreement to pay us. I don't know how you want me to answer that.
Well, let me ask you this, following up on what you just said. When did you form
No,
Wade Grunberg. She just testified.
No, that was not on
Have-
recross, no, excuse me, redirect.
She
We are,
just
we are
test-
well beyond the bounds,
May
sir.
may I make a point? She just testified that they had no law firm at the time that they left. And I have one question.
You said you had one question a while back.
Well, that's in response to what she just testified to. She's on cross.
All right.
So the question is simple. When did you form legally Wade, Grunberg, and Wilson LLC?
All right. We did cover that already.
I've never asked her that here.
You can step down, Ms. Wade. We're done. Plaintiff may call their next witness.
I have a whole question.
No. No, you may not. We are moving on.
Honor.
Jury, feel free to stand up, stretch in place if you need to. We need to move ahead.
Yes, Your Honor.
Hey, Rodney, 20 Jeffries there.
Plaintiff's call to the stand, Taylor Wilson, Your Honor. Is your water line?
George Taylor Wilson, GeorgeTaylorWilson.
Your Honor, just one quick clarifying question. Is the instruction that you discussed with us about formalities with last names applied to our own clients?
I think that'd be the cleanest way. So.
All right, I will follow that.
May I ask, Marlon, if Ms. Brown could speak into the microphone? I can't hear her.
All right.
All right. Good afternoon, Mr. Wilson. Can you tell us where you grew up?
I grew up in Marietta, Georgia,
And where did you go to college?
the University of Georgia.
And where did you ultimately go to law school?
I went to the University of Georgia.
And after law school, did you?
Maybe my hearing, because we asked Mr. Wilson if he could get closer to the microphone and speak up where I can hear him.
Okay. And you also,
Tends to be mumbling,
okay.
the way I hear it in my ears.
Please continue.
Excuse me. After law school, did you come back to the Atlanta area to practice law?
I did. I started practicing law in Marietta, Georgia, for about a year before I joined Ellenwood PC.
And so what year approximately did you start working with Ellenwood PC?
I started in November of 2015.
And we've heard some other firm names. Was Defendant Wood's firm at that time called Ellenwood PC, or was it one of the other firms he had?
It was Ellenwood PC. The firm that Mr. Wood has referenced is Wood, Hernacki, and Evans had already disbanded.
And in what capacity did you start working at Ellenwood PC?
I was hired as an associate.
And was Miss Wade already at the law firm when you came on?
Yes, Nicole had started at Ellenwood PC a few months before me, and Jonathan had been there for some time.
And we heard Miss Wade testify that Mr. Grunberg and you got promoted with the title partner in 2018. Do you remember that?
I do remember that, and yes, it was effective May 1, 2018. Mr. Wood promoted Mr. Grunberg and I to partner.
And I'll direct you to Plaintiff's Exhibit 5, which is already in evidence. What was referred to in opening as the Happy Camper email or memo, excuse me. I believe in Plaintiff's Exhibit 5, it says under point 3, effective May 1st, your LLCs will each be non-equity partners and LLWPC under the terms of my proposal with no ownership interest in the firm's assets or accounts receivable, and it goes on. When you, at this time, when you got this promotion to the title of partner, how did this feel for you at that point in your career?
I was really proud and appreciative of Mr. Wood making me a partner. It was certainly a big moment in my career, and the circumstances of it at the time maybe lessened my elation a little bit, because it was clear to me that I was being made partner in part because Mr. Wood no longer wanted to pay me a salary as an associate, and instead wanted me to start to fend for myself a bit more and be responsible for making sure that I could earn a paycheck myself at that time, because he was considering, prior to this email, Mr. Wood was considering basically disbanding Ellen Wood PC as it existed at that time.
And in the legal field in general, the change from associate to partner, in your experience, is that something that most attorneys are working for in their careers?
Absolutely. And to have been able to do it with Mr. Wood's firm was an incredible thing for me, especially at that age. And it just denotes sort of your standing within the law firm. An associate is understood to sort of be the lowest on the totem pole, and a partner, and announcing that you've made partner, sort of a recognition that you're deserving of that title, and I certainly appreciated that.
And we saw also yesterday at this time when you and Mr. Grunberg got promoted to the title of partner that there were some announcements put out by Ellen Wood PC. I think we looked at one Plaintiff's Exhibit 6. That was the Georgia Bar announcement. Do you remember that?
Yeah. Mr. Wood put out a couple of announcements on behalf of Ellen Wood PC, announcing Mr. Grunberg's and my promotion to partner.
So there were others other than the one we looked at yesterday?
Yeah, there were a couple.
And did you have, we also saw Miss Wade's website bio about her as an attorney on the Ellen Wood PC website. Did you have one of those as well?
I did.
And I'll point you to take a look at Plaintiff's Exhibit 12, which is not in evidence yet, Michael.
Your Honor, if I might, consistent with the court's order yesterday, unless you're working for a law firm, you told everyone to sit on the back row. And I've made sure that anybody that I even peripherally knew was told that.
Your Honor, the two individuals I'm assuming he's referring to is Mr. Wilson's wife and Mr. Wilson's stepfather, and they're associated with the partners or the parties, and we talked about this
You can
yesterday.
proceed.
Thank you. Taylor, did you get a chance to look at Plaintiff's Exhibit 12?
Yes,
Are you familiar with this?
I am.
Is this a true and accurate, are these true and accurate screenshots of what they're depicting to be?
Yes, they are.
And just in general terms, what are we looking at here on Plaintiff's Exhibit 12?
It's my biography under the attorney page on Ellen Wood PC's website as of May 2018.
And what about page 2 of this exhibit?
It's the same as of February 2020.
Your Honor, at this time, I'd like to move to have Plaintiff's Exhibit 12 entered into evidence and published to the jury.
Any objection to P12?
P12,
P12.
thought that went in yesterday. No objection.
P12 is admitted.
Thank you, Your Honor. I'll give Michael a second to catch up on the screen. Thank you, Michael. Can you blow this up for us? Okay, so similar to Ms. Wade's bio or website bio that we looked at yesterday, are these screenshots gathered from the online web archive that she testified about?
Yes, they are.
And I believe it's called the Wayback Machine.
That's right. Yeah. This was gathered from the Wayback Machine and the screenshots taken on the date shown.
And so I believe you said you were promoted to the title of partner effective May 1st, 2018. Is that correct?
That's correct.
And so at least by May 13th, 2 days later, or I'm sorry, 12 days later, you were listed on the firm's website as a partner. Is that right?
Yeah, nothing changed about my work for Ellenwood PC from my shift from associate to partner, other than how I was identified and that I was no longer going to receive a salary, but instead would be paid for my work in a different fashion.
And I believe page 2 of this exhibit from February 16th, 2020, if shows your firm bio, your listing as a partner didn't change between those 2 years, except for maybe you updated your information.
Yeah, I think it's the same. Yeah. And I don't think anything changed.
And your title didn't change.
No, my title did not change. I don't think anything changed.
And from the day you started at Ellenwood PC until the day you guys left, how'd you sign court pleadings? We heard Ms. Wade talk about how you have to give your little signature line and you have to list your law firm that you're associated with. What did yours say?
Every pleading I signed between joining in November 2015 and leaving on February 14th, 2020, identified me as a lawyer of Ellenwood PC.
And what about correspondence that you would send to opposing counsel? What did your letterhead say?
My letterhead said Ellenwood PC
And
at all times.
And what about your business cards? Did you have a business card at Ellenwood PC?
Yeah. Mr. Wood provided us business cards. They said I was a lawyer of Ellenwood PC.
And I'll point you to take a quick look at Plaintiff's Exhibit 7, and if you can tell us if you're familiar with this.
I am.
And is this a true and accurate picture of what it purports to be in Plaintiff's Exhibit 7?
It is a true and accurate copy, yes.
And is it a copy of your business card that you had at Ellenwood PC?
It is, and it's after we had switched office space. So this was specifically after my promotion to partner, effective May 1, 2018.
Your Honor, at this time I'd like to move to have Plaintiff's Exhibit 7 entered into evidence.
Any objection?
No objection.
7 is admitted.
Thank you, Your Honor. So you had your business cards, you had your letters, letterhead to opposing counsel, and we talked about your pleadings. What about your legal work? Did you ever do any legal work from the day you started at Ellenwood PC to the day you left through any other law firm or entity?
And there were a couple of letters I sent, and I think in late January or early February of 2020, after Lynn had announced the rebranding of the firm from Ellenwood PC to Wood, Wilson, Grunberg, and Wade, that was on that letterhead. Otherwise, no. I mean, every engagement agreement I ever signed, every email I ever sent, every letter I ever sent, every bill I ever sent identified me solely as a lawyer of Ellenwood PC, and all of my work was exclusively performed for and on behalf of Ellenwood PC.
And I believe Ms. Wade testified about the rebranding of the firm to Wood, Wilson, Grunberg, and Wade, that everything stayed the same except for it was just a name change of the firm. Do you agree with that?
Yeah, absolutely nothing changed. Mr. Wood just changed the name of the firm from Ellenwood PC to WWGW.
But your email domain was still the same?
Yes, it remained at linwoodlaw.com. I think the only thing that changed about the firm was the name, and I think Lynn had ordered a sign for our office space. Nothing else changed.
And did you ever practice law during this time period on any case outside of Ellenwood PC or the subsequent name of the firm, Wood, Wilson, Grunberg, and Wade?
No, absolutely not. All the discussion about other LLCs, those law firms, those companies never operated in any fashion except to receive compensation. G. Taylor Wilson LLC or Grunberg and Wilson LLC operated in no fashion except to receive compensation for my work as a lawyer of L. Linwood PC. They never had clients, they never had websites, they never made court appearances. Their sole purpose was to receive my compensation for my work as a lawyer of L. Linwood PC.
And in your experience, is that common practice in the legal field?
Yes, in fact, I've heard Mr. Wood.
I think she asked him his experience, not what I said.
But he can,
Well, 3 or 4 years. I don't know what his experience was, but that's not responsive to the question. I object.
all right, overruled. You can answer the question.
Yes, and in fact, I've heard Mr. Wood in this courtroom say that L. Linwood PC has been a member of other entities that were identified as the law firm at which he practiced.
And just for the record, I want to object and move to strike that. He's not here to testify to what I said in the courtroom. I haven't testified yet.
All right. Overruled, you can continue.
Thank you, Your Honor. Lost my train of thought. So I think it's fair to say you didn't perform any legal work or any other type of work through any entity you have an ownership interest in at any point during your relationship with the defendant. Is that right?
That is right. I was always and solely a lawyer of L. Linwood PC working for L. Linwood.
And was your LLC, through you and your work, a partner of Defendant Woods in L. Linwood PC?
I'm sorry, can you ask that one more time?
Were you, through the entity that you received payment through, were you a partner of Defendant Woods in L. Linwood PC?
Yeah, I mean, so he sent the happy camper email and telling us that our LLCs that we had just formed pursuant to his instruction would be non-equity partners of L. Linwood PC. But the reality is I was a partner of L. Linwood PC. This LLC simply received my compensation. The years, the almost 3-year time period after May 1, 2018, and when I left on February 14 of 2020, I considered, and I was, a lawyer of and a partner, a non-equity partner of L. Linwood PC. These other things just weren't part of it, except it's just where I received my compensation.
And I believe you stated that you set up these other entities at Defendant Woods urging. Is your testimony similar as Ms. Wade, that he had a conversation with you asking you to set it up for tax purposes?
Yes, and that's ultimately where it ended. But they were also formed during this time period in early 2018, where Mr. Wood was actively contemplating no longer having us work at L. Linwood PC, and instead for him to go be a solo practitioner because he doesn't really necessarily like working with other folks. He just
Pure speculation.
Well, he's worked with you for how many years? He may have some information about that. So you can cross him on it. And no, on this basis, speculation, I don't think I see that. That's overruled.
To talk about what I like and how I get around along with other people. That is
Yes.
ridiculous.
Well, we'll see on cross. Overruled.
We'll
You can
see on
continue.
cross. We will see on cross.
Thank you, Your Honor. Taylor, you can continue.
And at that time is when Mr. Wood and L. Linwood PC took on the representation of Mr. Steve Wynn. And Mr. Wood changed his mind, as shown in that email, and decided to keep the firm together. L. Linwood PC, 4 lawyers, now 4 partners. And that's what it was. I was a partner at L. Linwood PC, and that history just can't be rewritten. I mean, it happened for 3 years.
And so this whole notion of potentially disbanding and him going out on his own at one point, that never happened. You guys just continued working at L. Linwood PC altogether.
Objection,
Yeah.
that's a meeting. She's supposed to ask. for
Yeah, that calls for a determination ultimately to be made by the jury. So move on to the next question.
I believe you just testified about when all this came about with your other entities being formed. Did you, Mr. Grunberg or Miss Wade, ever perform any work outside of Ellenwood PC during that time?
No, we did not. The firm remained, always was Ellenwood PC with 4 lawyers.
And did you ever sign or accept legal fees into Ellenwood PC on behalf of a client, like in a contingency case?
Yeah, I absolutely. I signed engagement agreements on behalf of Ellenwood PC during both of these timeframes as associate and partner. I signed what's called settlement statements in contingency cases before you receive settlement funds and disperse them. You provide the client a settlement statement that identifies the proceeds, the costs, the fees, and authorizes you to do that for them. So I signed settlement statements on behalf of Ellenwood PC as well.
And I'll point you to take a look at Plaintiff's Exhibit 20 and ask you if you're familiar with that.
So,
And this has not been tendered into evidence, Michael. This has not been tendered into evidence. Yeah. And just for the court and Defendant Wood's purpose, the copy that you guys were provided is unredacted. The copy, because of the information in here that will be shown and published to the jury, is redacted.
All right. So for the purposes of the record, is the one that's going to be made part of the record 25 is the redacted version?
20 is the redacted
Excuse me.
version. Yes, Your Honor.
20. All right.
Taylor, are you familiar with this document?
yes, I am.
And is this a true and accurate copy of the document it's purporting to be?
Yes, it is.
And is that your signature on page 2 of this exhibit?
Yes, it is.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 20, the redacted version, amended into evidence and published to the jury.
The objection to plaintiff's 20.
No, Your Honor.
20 is admitted.
Thank you, Your Honor. And if we can zoom in on the middle part, Michael, please. Thank you. Thank you. So Taylor, you were talking to us about settlement statements and contingency cases. Is this one of those types of examples that you were testifying about?
Yes, it is.
Okay, and so in this particular case, was this a settlement statement for, well, one, actually strike that. Do you do settlement statements for hourly clients?
No. Hourly clients receive invoices every month that identifies your time and what you've done. Only clients in contingency fee cases where the firm only gets paid or expenses reimbursed if you win receive settlement statements.
And and I believe if we go to page 2 of this document, and if we'll zoom in on the signature line of Taylor only, please. Thank you. Is this your signature here that's listed under Ellenwood PC?
Yes, it is.
And did Defendant Wood give you authority to sign this settlement statement and others like it while you worked at the firm?
Yes, of course. And in this instance, I think specifically, not all that dissimilar to the Ramseys. Mr. Wood also had a longer relationship with Beth Holloway, and gave me specifically the authority to sign this one based on the nature of the work that was performed in that case, and that generated the result.
Thank you. And we've heard this term come up in the trial so far about space sharing or office sharing when lawyers do that. What does that mean?
It's when either solo practitioners or different law firms try to save money, I guess, by just sharing office space. They have separate clients with separate engagement agreements. They have separate client trust accounts where you hold client money. They keep client confidences separately. They're not portraying themselves as a single law firm, and they are not lawyers of one law firm. They are, if you're sharing office space and let's say there's 4 offices in it and there's 4 law firms, there's going to be 4 signs announcing who the 4 law firms are. It's not what we were. If that answers the question.
Okay, and I believe you were talking about separate client files and trust accounts. At Ellenwood PC, did you guys have one computer system that you guys operated out of?
Yeah, we had one computer system.
And I believe Ms. Wade testified that there was one online Dropbox server that everybody had access to. Is that correct?
Yes, for every client.
And who had access to the Dropbox server online at Ellenwood PC?
Mr. Wade, or Mr. Wood, Miss Wade, Mr. Grunberg, myself, our assistant Chelsea Gray, and Kimmy Bennett.
And is the Dropbox server at Ellenwood PC where the client files maintained, is that where client confidences would be kept sometimes?
Yeah, all digital client records would have been maintained on Dropbox. Any Ellenwood PC did have a physical file room, but that generally wasn't for client confidential information. It would usually be on Dropbox. In any case, everybody had access to the physical file room as well.
Everybody that you just mentioned who was at Ellenwood PC?
Yeah, not everybody generally, just the folks that worked at Ellenwood PC.
And was there anyone outside of Ellenwood PC that had full access to the online Dropbox server for the firm?
No, I would be very, very shocked, and it'd be a problem if somebody did.
And why is that?
Because the bar rules prohibit lawyers from failing to keep safe client confidences.
And did you ever perform any legal work and store it anywhere other than the Ellenwood PC Dropbox online server from the day you started to the day you left?
No, all my work was for Ellenwood PC, on Ellenwood PC's Dropbox, all engagement agreements, everything was Ellenwood PC.
And transitioning to billing hourly clients, did you bill them through one of your own LLCs, or was that done through Ellenwood PC?
No, all of my time for hourly clients was submitted on Ellenwood PC letterhead, identified me in the work I performed and my hourly rate, and all fees were paid by the client to Ellenwood PC.
And if you'll take a look at Plaintiff's Exhibit 15 for a moment, and this has not been published to the jury, Michael. And also similar to Plaintiff's Exhibit 20, the copies that Your Honor and Defendant Wood has is unredacted. What is prepared to be published to the jury is redacted for attorney-client privilege purposes, Your Honor. Taylor, are you familiar with this document?
I am.
And is this a true and accurate copy of a hourly invoice from Ellenwood PC?
Yes.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 15 admitted into evidence and the redacted version published to the jury.
Any objection to plaintiff's 15?
There we go. I'm just not sure what the redactions are for. I don't know if anything's confidential. Just a poll I sent to Steve Wynn.
And these are just the amounts that are redacted?
I want the jury to see the amounts.
It'll be the description, Your Honor.
The description is redacted.
Yes, of what kind of legal work was performed for attorney-client privilege purposes.
I understand why they might need to redact some of that, yes. But
Okay.
otherwise, fine with me, let it in.
All right, so plaintiff's 15 is admitted.
Okay, thank you, Your Honor. Can we go ahead and put that up, Michael? I apologize, Your Honor. It looks like we redacted a little bit more than I anticipated. So I'm going to move on and I will cover this with Mr. Grunberg.
All right.
Object to that exhibit. Sorry.
But Taylor, just generally, we'll get into the details of this. If we go to the top of page 1, this is an example of an invoice that was sent to an hourly client at Ellenwood PC. Is that right?
Yes, that's exactly what it is.
And is there some sort of software or computer system that these hourly invoices come out of?
Yeah, Ellenwood PC uses a software called Clio for us to keep track of our time. And it houses other client information as well.
And so you not only enter your time in this Clio system, but the bills also get generated out of it?
Yeah, the lawyer enters their time usually per 6 minutes. So in 0.1 increments of 0.1 into the software system, and the software system generates the bill for you.
And to your knowledge, did anyone at Ellenwood PC keep up with their time in a similar fashion that we see here in Plaintiff's Exhibit 15 for contingency cases?
No, to my knowledge, no one did. And that was Ellenwood PC's practice, was not to keep time records on contingency fee cases because that's not how we were compensated.
And I'll direct you to take a look at Plaintiff's Exhibit 54 and 54A, and this has not been published to the jury yet, Michael, and tell me if you're familiar with this.
Yes, I'm familiar with this.
And is Plaintiff's Exhibit 54 a true and accurate copy of a transcript of a voicemail that you received on February 11th, 2020?
It is.
And are you familiar with this transcript and the recording that's marked as Plaintiff's Exhibit 54A?
I am.
Your Honor, at this time, I'd like to have Plaintiff's Exhibits 54 and 54A admitted into evidence.
All right, objection to 54 or 54A.
54A?
In 54.
54A being the recording, 54 a transcript. And this is a transcript of the entire recording.
Yes, Your Honor.
All right.
And 54A is the entire recording?
Yes.
54A.
All right, yes.
No
All
objection.
right, 54 and 54A are admitted.
Thank you. And do I need to play the recording? I All right, and Michael, if we'll zoom in on the transcript so we can read it while I get this ready to play.
Taylor Wilson. That's a name I'm familiar with. This is the voice you're familiar with, Glenn Wood. I'm the Wood, the first on Wood, Wilson, Grunberg, and Wade. a law firm that was meant to be, a law firm that's going to flourish in love and peace and harmony. I think I have resolved very clearly your concerns about me. I think I have resolved very clearly my concerns about you. Now we're going to trust each other, which is what every law firm is built on, trust. Every relationship is built on trust. What love is built on, trust. Sometimes you have to break a heart to rebuild it. And when you rebuild it, it's stronger than it was before you broke it. Nothing's going to change in our plans, Taylor. All of the things that I said in my email last night, which I meant at the time, I no longer mean. Free will is the exercise of choice. Free will, fortunately, allows the person to change his or her mind. I've changed my mind. Proceed in your mind just like you would have before. Keep doing the work you do. Keep your files where they are. You don't need to keep up with your hours. That's not going to be relevant to your compensation. I keep my promises. You trusted me that I would. I always will. We won't see each other today, but I got some things that keep me out of the office. I'll probably be down tomorrow. It's okay for you to be in that office anytime you want to be. Don't worry about whether I'm there or not. It is what it is, Taylor. And sometimes we get in the way of it. When we do that, we create problems. So I'm just going to be that. It is what it is. It is as it shall be. I've never felt better about you. I never felt better about Jonathan. I got to leave the same message with Nicole. I've never felt better about her. All is going to be good, my friend, my partner. We're going to flourish and do good for other people. You're going to be a famous man. You're going to be a famous lawyer. You're going to do some fabulous things over the next 40 years of your career. I love you, and I will see you tomorrow probably. And if there's anything you need from me, as always, call me. I'll talk with you in the spirit of love. I'll talk with you in the spirit of trust. I'll talk with you in the spirit of respect. Talk to you soon. Bye.
So Taylor, in this voicemail, we heard defendant Wood say that you don't need to keep up with your hours. That's not going to be relevant to your compensation. I keep my promises. You trusted me that I would. I always will. Was that statement about keeping up with your hours in line with the practice at Ellenwood PC on these contingency cases, not to keep up with your time?
Yes, and it was specifically in reference to Nicholas Sandman,
And how do you know that?
because this was Mr. Wood rescinding an email that he had sent to us late the previous night on February 10th, where he effectively said he withdrew from any partnerships with us and that he required our hours.
I believe we need to see that email as opposed to him testifying off of document and have the ability to look at it.
All right. I'm going to allow the plaintiffs to control the manner of their presentation of the evidence. I think it's already been admitted, if I'm not mistaken. I don't.
Could I have a reference to what exhibit?
Yeah, can you remind me?
This witness has personal knowledge. I'm not sure if this direct email has already been admitted into evidence, but he's testifying as to his personal knowledge of what the email.
He's testifying the contents of an email.
Yeah. Do you have that email as an exhibit that you remarked?
Your Honor, I'm not entirely sure at this point. If the defense wants to bring that in on cross, they're more than entitled to. We have lots of emails and exhibits. I can try to find it, but at this point, I don't know the exact.
Why don't we wait and let him testify about it after we find it? Instead of telling us what it says, let us see it.
I mean, if you've got I'm fine with you summarizing it if it's already admitted and as an exhibit, but if you've got it in writing and you haven't entered it, then I think we may actually be looking at a best evidence issue here.
Well, this witness has personal knowledge of an email that he received. I think he's qualified and has personal knowledge to be able to testify to it. And I mean, defendant Wood is now trying to dictate what type of evidence we put in and when. And I mean, if we just let him finish his answer, we can move on.
I'm not trying to dictate anything. I'm trying to follow the rules. If he's going to summarize an email, put the email into evidence and then comment and testify about it. But it has to go into evidence first, and I don't know why they don't have it.
Okay.
Just
All right. So you can refer to it generally and its effect on him if it explains his subsequent actions, but going into the nuances and the specific things that were said in it, I think we can circle back to that
Yeah.
if that's something you actually want to go into.
And that's exactly what we were getting into, Your Honor, that
All right.
alone, because with this notion about them not having to keep up with their hours and Defendant Wood saying this on 2 voicemails
Okay.
to
I think I've
two
got
other
it.
plaintiffs. Taylor, if you go ahead and generally summarize and in effect that
Hold
it
on,
had
hold on, Ms.
you.
Brown. Mr. Wood.
Sorry, but I just don't understand what we're doing. They want to talk about an email. The rules of evidence would say, put the email into evidence, then talk about it. Summarize it. But the law of evidence requires that before they discuss it, that it be admitted into evidence. What if when we find it, it's not admissible? So we'd be testifying about inadmissible information. Seems simple to me, Judge. They want to talk about an email. They must have the email, put the email into evidence so we can all see it, and then he can say whatever he wants to about it. That's the rules of evidence. Thank you.
Okay. Ms. Brown, why don't you re-ask whatever question you had wanted him to answer, and I'll go from there.
Taylor, Mr. Wilson, I think I was asking you about this line in the voicemail that we heard Defendant Wood leave you that said, you don't need to keep up with your hours. That's not going to be relevant to your compensation. What did you understand him to mean by that's not going to be relevant to your compensation?
Ellenwood PC never compensated us in contingency cases based upon the number of hours that we had worked in the case. He compensated us pursuant to a particular percentage of the fee recovery. And he was just letting me know that that hadn't changed and I did not need to all of a sudden provide contemporaneous time records of the work that I was performing on contingency matters, and specifically with respect to Nicholas Sandman.
And Defendant Wood goes on to say that he keeps his promises and that you trusted him, that he would keep his promises and that he always will. Do you believe he's kept his promises to you?
No. And prior to this, he had already told me, like he did with other matters, what my compensation would be with respect to this particular matter for Nicholas Sandman as well. No, Mr. Wood's not kept his promises to me.
And in the later part of the voicemail, we heard Defendant Wood say, all is going to be good. My friend, my partner, did he frequently refer to you as his partner?
Yeah, he would do so to me. He would also do so in engagement agreements for hourly matters. He would do so to courts. He would do so in motion papers. Whenever you practice out of state, you have to file a motion to get permission to practice temporarily outside of where you're barred, the jurisdiction that you're barred in. And Ellenwood PC, including for Mr. Sandman, announced my status as a partner and lawyer of Ellenwood PC.
And prior to the fall 2019 timeframe, how was it in general terms working with Defendant Wood?
It was just really, it was really great. I mean, he gave me opportunities I never otherwise would have had. You can generally have conflict among people, and Mr. Wood could be tough, but we were really close personally, and we worked on just amazing. We worked for amazing clients on really fun matters, predominantly that Mr. Wood brought into the firm.
And did your experience working with him change at some point in time?
Yeah, it significantly changed no later than September of 2019.
And in general, just brief summary terms, what, in your opinion, changed from your experience of working with him from years past?
His treatment of us just did a 180. He became loud and angry, and just very, very difficult to talk with, or certainly to reason with or try to reason with.
And we heard Ms. Wade testify about stresses being high during the Elon Musk trial and the preparation for that. Is that around the same time period that you're speaking about?
Yeah, I mean, the specific time period I'm thinking of is when we were in the midst of a series of depositions in the Elon Musk matter, as well as having the Nicholas Sandman matter. And, you know, obviously we had other matters going on. We just looked at that settlement statement. But yes.
And moving forward to the January 2020 timeframe, had things gotten better, or were they still this 180?
Oh, they got progressively worse, beginning in the fall of 2019 and certainly by February 14th, and they continued to get worse after that. So I wouldn't say they were the same, but they never improved after the fall of 2019. They just got scarier and stranger.
And is this around that time period that we've heard referred to as the Valentine's Day massacre? They were saying it when it got bad.
Well, yeah, I mean, it during our time with Linwood PC, it culminated then. And when I say, I mean, at first the working relationship changed, and he was difficult to communicate with, but then it just devolved into very, very strong verbal abuse and threats, and the power to hurt you and hurt your families and your law careers, and all of that started happening in late January and February of 2020 when it got to the point where it's just not a possible relationship anymore.
Okay. And we'll get to some of those. So at this point, I'd like to point you to Plaintiff's Exhibit 52 and 52A. If you can take a minute and tell us if you are familiar with these exhibits. Are you familiar with this exhibit, Taylor?
Yes, I am.
Mr. Wilson. Is Plaintiff's Exhibit 52 a true and accurate copy of excerpts from a recording from a conversation with you and Defendant Wood on February 10th, 2020 at 3:40 p.m.?
It is.
And does the recording that is exhibited at Plaintiff's Exhibit 52A, is that a true and accurate copy that goes along with what is depicted here in the transcript of 52?
Yeah.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibits 52 and 52A brought and admitted into evidence.
Any objection to 52 and 52A?
Your Honor, are these the complete exhibits?
And I'm not sure this transcript is complete, so I'll object to the grounds of completeness, both as to the transcript and to the tape. If it's complete, they want to make that showing, fine. But I have the right to ask for the entire transcript.
All right. Ms. Brown, I believe you said that these are selected excerpts from this recording?
They are, Your Honor, and the rule of completeness does not require us to bring in the complete excerpt. If Defendant Wood would like to put that on, he got these recordings
I understand, Mr. Brown.
Yep.
So, Mr. Wood, have you identified what specific aspects are not included in this excerpt that you believe need to be shown or admitted contemporaneously?
No, and because the burden is on the plaintiff.
All right.
The rule of completeness requires that if I object on the basis that it's not complete, it's excerpts that they prepared, they have to produce a complete interview so that the jury will not believe or be misled because they take something out of context. And the law is very clear that they've got to put the whole interview in so that nobody can take it out of context. That's the rule of completion. And it's not my duty to do it. They got it right there. If they want it in evidence, the law requires them to put the whole thing in. If they've got nothing to hide about it, that would be consistent with the law. Put it all in there.
Your Honor, I object to the characterization that we have something to hide. These recordings are very long and lengthy. We have exerted what we think is relevant for the jury to hear and not to waste anybody's time. And again, if Defendant Wood wants to bring in the entire recording, he received copies of these years ago throughout this litigation.
All right. All right, Mr. Wood, if you can leave that to me, I'll instruct the jury again at the outset of trial. Sometimes it's just more efficient for me to hear the arguments at counsel in real time rather than excusing you to the jury room. Those aren't evidence and those aren't to be considered by you. I have reviewed and refreshed myself on that rule, used it before. Unless you can identify to me right now the statement that you think needs to be shown in context, I do not believe that that duty falls on the plaintiff, and I don't really need to hear any more argument unless you can give me the statement you think needs to be considered.
Talking to the rule that you said you just read.
106.
106.
24-1-106.
You don't mind, Your Honor.
You can look that up on your own time, Mr. Wood, not the jury's time.
Go outside and look it up.
Not the jury's time. No, sir.
Why are you treating me this way?
Mr. Wood, we're moving on. I'm overruling your
Make an objection about the rule.
Mr. Wood, I'm directing you to move on. All right? Counsel, you can ask your next question. We're going to
Thank you,
take this
Your
up when the
Honor.
jury goes home today.
Is 52 and 52A admitted
May I
into
have an
evidence, Your Honor?
opportunity?
Over objection.
May I have an opportunity overnight to review the entire transcript and submit the portions tomorrow that I believe need to be submitted under the rule of completeness?
You would, just like you would when you present evidence.
Thank you very much.
All right, let's move on. And 52 and 52A are admitted over objection.
Thank you, Your Honor. And I'm prepared to play once we get the transcript up on the screen. Thank you, Michael.
And that wasn't my name comes off on the goals or not. Okay, I'm not gonna wait. You wanna make that decision without your input? It's your discussion. It's your professional suicide if I take my name off that bar. You understand that, young man?
Lynn, if it's my professional suicide, you've been terrorizing me for months on end, and I'm not participating in this any longer.
I've been terrorizing you for months on end. When have I terrorized you?
Constantly.
And I told you today, have I?
No, and if you want to fire me, if you want to fire me, then that's your prerogative, but I'm not participating in this today.
Taylor, you gonna be a leader today, or you gonna be a follower? What do you want to be, a leader?
I'm not trying to lead anything. I'm just telling you that I can't, it's too abusive, and I'm not participating in it today.
When have I been abusive to you? I didn't talk to you yesterday, did I?
Yesterday, I'll give you credit that you didn't speak to me yesterday. Lynn, you have been, no, I've cared about you too much, and I haven't been willing to say it, and now I am. You can't speak to me or treat me like this any longer, and I won't allow it to happen, and I'm not doing it today. If you want to call me with a clear head tomorrow and discuss, I'm happy to do that, but I won't do it today.
You're putting conditions on me talking to you.
I will not be abused the way you abuse me any longer. Today is the last time.
Let me tell you what's going to happen to you. You abuse me.
No, I don't.
Watch what happens with the salmon. See, I'll show you what I think of what you've done to me.
You don't have to pay me the money that you've promised me if that's how you feel, okay?
I don't have to pay you the money that I promised you, even though you don't show me the respect you promised me when you were behind me on the letter here. So it's a one-way street. I got to keep my promise, but you don't have to keep yours. You better stop and think. I don't think you're talking like Taylor Wilson. I haven't abused you today. No, I haven't abused you today. I haven't abused you yesterday. What was the weekend abuse? I know I talked to you when you were at the zoo. I tried to make it short to the point on business. You told me I terrorized you for 3 months. I don't think you can back that up factually. I've had a couple of rough goes, friend. I've been fighting a battle with my kids. Do you care about your son?
Mr. Wilson, when was this conversation that we just heard excerpts from between you and Defendant Wood? When did this take place?
Took place on the afternoon of February 10th, 2020. It was the first and only time that I had stood up to Mr. Wood in any fashion about his behavior.
And I believe we heard Defendant Wood say on page 2 of this exhibit during the recording, "Watch what happens with the salmon fee. I'll show you what I think of what you've done to me." At the time that you heard him say that, did you have any understanding of what he meant by that?
My personal understanding was that Lynn had already promised to pay me 20% of the particular CNN fee, and that he wasn't going to do that because for the first time in this whole ordeal, I had told him he couldn't do it anymore. And that he was going to try to control me and my actions with compensation that was already committed to me for work that I had performed.
And sitting here today, what do you feel about this comment now?
I mean, hindsight's 2020. I guess it didn't take him long to decide that if I was willing to stand up for myself, that he wasn't going to pay me for the work that I'd performed for him and his law firm. Is it just his immediate gut reaction was, watch what happens to your salmon fee if you tell me I can't treat you like this. So that, it's just and as we keep going, it's just going to feel like trauma.
If we need a moment, we can take a moment. And do you agree with Ms. Wade's testimony that you haven't received any sort of compensation from the salmon fee or under the settlement, March 17th settlement agreement?
Excuse me, that's leading. He's not here to prepare Wade testimony. He's here to answer direct questions without him being leading. So I object to the form of the question.
I'll rephrase. Have you received any form of payment from defendants regarding the salmon fee?
No. No, it's about 13 months of work, and we were paid $0 for our work on behalf of Ellenwood PC for its and our client, Nicholas Salmon.
And what about under the settlement agreement? Have you received any payments pursuant to that?
No, we've made payments. We haven't received any.
And I'll point you now to take a look at Plaintiff's Exhibit 57 and 57A. This has not been published to the jury yet, Michael. Thank you. Mr. Wilson, are you familiar with Plaintiff's Exhibit 57 and 57A?
Yes, I am.
And is Plaintiff's Exhibit 57 a true and accurate transcript of excerpts from a meeting that you guys had with Defendant Wood on February 13th, 2020?
Yes, it is.
And is the recording that's exhibited at Plaintiff's Exhibit 57A true and accurate of the excerpts that are depicted here in the transcript on 57?
Yes, it is.
Your Honor, at this point, I'd like to move to have Plaintiff's Exhibit 57 and 57A admitted into evidence.
Objection 57 and 57A.
Same objection, Your Honor. It's not complete. Been taken out of context. And we're entitled to request them to put in the entire recording and the entire transcript under the law of Georgia, well-established law. So we object on the basis of failure to meet the rule of completeness.
All right, this time have you identified any specific aspects of this complete recording that you believe in fairness would place certain statements in context?
I did not know this was going to be put into evidence, so I haven't had a chance to review it. So if, again, the court would give us some time to review it, I'll be glad to identify it, although I don't believe that's the law. I think they have the duty to come forward to make sure that they're not putting in things that are out of context.
All right, you've explained that to me before, Mr. Wood. I understand your position. I don't agree. And so I've overruled your objection to 57A. It's admitted over objection. You can proceed.
Chance to come back and look at it and submit portions that we think need to be added like we did.
We can circle back on that.
Thank you very much.
And Your Honor, just briefly, I object to his characterization that he has not received this prior to today. Not only did he receive it in discovery, but he also received a copy of every single exhibit that we were even potentially thinking of bringing in at trial pursuant to the court's pretrial order, just for the purposes of the record.
You can proceed.
Thank you, Your Honor.
It would help me if they would identify for me the complete recording that they produced, and then I can go find it tonight.
I don't know if they're offering to help you at this time, Mr. Wood. So I think you're on your own on that point. So I'm going to ask them to proceed.
I know that.
All right. All right, members of the jury, that's enough for today. We'll see you back at 9 a.m. I have some things I need to take up without you. Take care.
All right, for the jury.
What?
Sorry, didn't we play that before they go
No,
home?
no.
They're gonna go home because of our case.
Let's see about, Bill, we'll take it up.
Sure.
Oh.
You're gone.
Start packing it.
Yes.
All right, you can step down, Mr. Taylor. There's some things we need to take up before we break for the day. Can we get juror number 15 back in here? I think he might have been waiting. No, he's not in the back. He's the one waiting in the hallway.
That truck driver that was back here for a while.
That's right.
Thank you.
Juror 15, you've been with us all day. And I think you understand the predicament you put us in. And I think next time you're going to understand that when you're picked for a jury, we got to have you back the next day. All right, you're excused from service. Take care. All right. At this point, that is the second time Mr. Wood has decided to impugn the character of this court in front of the jury. All day, we have been subjected to speaking objections to violations of the rules of evidence. I've warned him repeatedly, and at this point, I've reached my limit. And so I've done some research on this, and under Powers versus the State, 168 Georgia Appeals 642, I believe Mr. Wood has forfeited the right to conduct the examinations of any of the witnesses in this case. He's got co-counsel on this case. So Mr. Exum, you are now lead counsel for cross-examination and examination of any witnesses going forward. I'll reconsider it later in this trial if Mr. Wood can regain lead counsel chair, and I'll probably let him do closings no matter what happens. But based on the discretion provided to the trial court in this case to maintain decorum, to maintain order, I'm not going to put up with this any further. So make your record, but that's what we're doing tomorrow.
I object to that. I think it's a violation of my constitutional right to represent myself. I have been in this court many days, not just this week, but in the past. This is at times a contentious case. I have had one ruling after another, after another, after another, after another, always go against me. I'm not stupid. I know how to try a case. I know the rules of evidence. And so sometimes I get frustrated. And I apologized to the court yesterday. I told you there were times, and I do not mean to impugn this court. If I did, I know how to do it, and I wouldn't do that. I wouldn't do that. But if you take away my right to represent myself and put me in the hands of Mr. Exum, who is a great young lawyer, but he has no trial experience, then you have horribly prejudiced my right to a fair trial. I would ask the court, 3 times as a winner, allow me another opportunity. I'll watch what I'm saying now that I know the penalty if I cross the line, but it would put me, it couldn't get over it. John hasn't tried any cases. So I would like that court to consider giving me another opportunity. And if somehow you think I've impugned this court in this courtroom, put the hammer down. But just give me one more chance, because I'm in the middle of a trial that's extremely important. I'm doing the best I can. I did not mean to cross the line. Now I know how Your Honor feels. I apologize. I'll apologize in front of the jury. But I don't want to lose my right to represent myself, because as a practical matter, I've lost my representation because John has no trial experience. So I would ask you to reconsider that ruling and give the old man one more chance.
Mr. Wood, at the end of court yesterday, we had a discussion that we couldn't continue as we're going. And
I never thought I would lose my lawyer, me, and that you would subject me to trying this case with a fine young man, but a very young lawyer who's never tried a case before.
look, the fact, whoever you have as your co-counsel was your decision. That's not mine.
Well,
I don't know what happened to Mr. Reyes, but who you want by your side, that's up to you. He's the
Well,
lawyer here. And
in the interest of fairness, I would ask you to bend a little bit more and give me another opportunity. Listen, I won't have any excuse if you jump me tomorrow. I will have made my own bid. But I never imagined that in the course of making objections that I was going to lose my lawyer, me, and be put into the hands of a young lawyer who's excellent but has no trial experience. So now I know the consequences. I'm on notice. You've given me due process. Do it again, you're going to lose your lawyer. So I'd ask you to reconsider. I don't want to find myself in that situation, Judge. It would be a manifest injustice. So I'm asking again for the court, in the exercise of its discretion, to achieve justice and fairness. You've put me on notice. Mr. Wood, you do it again, you're off the case until sometime later. I'm not going to do it again. I'm not.
Mr. Beal, anything you want to add?
Yes, Your Honor. First of all, your ruling is not based upon mistakes. They are intentional representations of Your Honor's integrity, this court's integrity, our integrity as to every document, not to mention what he's saying about you and this jury online.
He can say whatever he wants outside of the courtroom.
Yeah,
sure.
And he can call me whatever he wants. I don't care. I'm not offended. But this is not how this process is supposed to work. And that's what's, at this point, I don't see a way forward.
Well,
Because we've had a lot of back and forth today, and it is not correcting your behavior.
Judge.
And you know not to do this, but just I'm not going to be one that's in your face. But you wouldn't.
I believe.
Go ahead.
I can disagree. I believe that I have very competently sought to defend myself as a trial lawyer. I have a duty to make objections, even if the court disagrees or Mr. Bill disagrees. I have an obligation to engage in zealous advocacy for myself, the client. And that's what I've been trying to do I've followed every ruling Your Honor's made. I haven't always agreed with it. But now all of a sudden on Wednesday afternoon, to deprive me of representing myself, what would this jury think? It would be game, set, match. I might as well just pack my bags and go home. And that's not fair.
All right.
I would ask you to give me one more chance.
I'll do this, Mr. Lynn. I will take it under advisement, but I should let you know that I at this point, you know, the apologies, I don't find them particularly sincere. And so I am just trying to do my best to make sure that this case, whatever the result is affirmed. And so that's what I'm going to be focusing on.
So
All right.
if my apology is insincere in your opinion, let's see what happens. Give me the opportunity to go forward. And the second you believe I've crossed the line, boom. But I had no idea that Your Honor was even contemplating the idea that you might yank me from representing myself. So you've given me notice. Now nobody can complain. I can't say you didn't warn me. I don't want to go home tonight not knowing because we have to prepare for trial tomorrow. So I would ask Your Honor once again, ask you to bend over backwards for me, which I think is bending over backwards to treat me fairly. And you've given me notice now. I did not have any idea that somehow the manner of my objections would result in you pulling me off the case and putting in a lawyer that doesn't have trial experience. Don't want to go home tonight and not know who's doing what. So I would ask you, Your Honor, in the interest of justice and fairness, to give me one more chance. If I cross the line, I'm not going to be able to stand up and complain. It's the right thing to do, Judge.
Mr. Beal.
Your Honor, as to notice, you admonished him for his misbehavior at cross and said one more, and you're forfeiting your right to the cross-examination. He's been on notice, and they are ad hominem attacks that almost can't be done at this point.
Being on notice about ending a cross-examination is entirely different than being on notice that you're not going to have a lawyer.
All right. Well, as I indicated, I would like to take another very, very close look at the Powers case that I cited to you and look at its progeny. And because this could happen 5 minutes into tomorrow, should I give you another chance? Mr. Exum's going to have to be prepared regardless, because it could very well happen tomorrow morning first thing.
Well,
So I'm not making that ruling right now, Mr. Wood.
Judge, it could happen tomorrow, 5 minutes in. But I'm not stupid. I'm not going to go in here and do something to put John in that position and jeopardize my defense. I might not agree with people on things, but I'm not stupid. My apology is sincere. I've asked you for one chance. You've now put me on notice of the consequences. I didn't know that before. Now I'm on notice. If it happens 5 minutes in, I knew it. You told me. If it happens 10 hours in, I knew it. You told me. But I believe I'm entitled to have notice of what your feelings are in terms of what you might do to me, to give me a chance to make sure that I don't cross some line with you and lose. I'm going to lose the case. If I lose myself, I'm not saying I can win it here. In fact, I don't control this courtroom. But I do believe that in fairness, I ought to have a chance. I haven't tried a case since December of 2019. I've told Your Honor that. I told you coming in, I had some dirt on my feet. I needed to knock off the dirt. And I believe that I thought I was doing a pretty good job, candidly. I have some strong feelings about certain things. I'll leave them out of here. I'll take it right off the table. It is what it is. I'll put my feelings about Freemasonry and other things, I'll take it right out of this courtroom and out of my mind in terms of being in here, going forward. And I think that's fair. I don't think I'm asking too much, and it would be unfair to try to come over here tonight and have John trying to figure out how to get ready and me trying to figure out how to get ready and not knowing who's going to do what when he has things that he does to help me you're basically taking the case and throwing it in the trash can for me. Or if you give me another chance.
All right, we're going
then-
round and
I
round,
would
Mr.
be-
Wood.
I would be the one throwing it in the trash can.
Mr. Wood, you point out something. You've talked a lot about your career.
Yep.
How long you've been trying cases. And I think it's possible this might be the last one that you ever appear in and make a statement.
I think it's true that.
I would hope that we could do better.
It will be my last trial. It's not even one I thought I would be trying. This is my last trial, no matter what. I haven't tried a case in 7 years or since 2019. And I've had a very, very difficult 5+ years since 2019.
All right, Mr. Wood, I hear you.
Judge, I'm doing the best I can. I'm now on notice, and I will commit to your honor that I will not come within missile range of incurring your wrath if you will give me that chance today.
All right. Mr. Beal, I wanted to point out one more thing before we concluded today, which was you probably noticed I had the clock going. So I had it set at 2:30. It's been counting down since then. I paused it for any more of the extended objections. And I would also contend that that would have to include time you're reserving for redirect as well. All right?
That's about.
Just FYI. Okay? All right, just
We
want to
might
put you on
have
notice
for
there.
A couple minutes, but I think we're rated about an hour and a half left. It's that the recordings are, some of this next one's kind of lengthy.
Understood. And then I'm going to be setting cross-examination for that same amount of time. I'm also going to be reserving the ability that if things are cumulative or repetitive or have already been asked and answered, to also step in and direct counsel accordingly. So the 2:30 isn't guaranteed. I can still move you along, is what I'm saying, is it's not an unimpeded 2.5 hours for either side.
That sounds like a good idea. Thank you.
May I go home knowing I have one last chance? You've shown me some mercy.
Mr. Wood, I need to think about it. I need to think about it.
Is there any way you could let me know before? I mean, we get up early in the morning to get here.
We'll see. I do think we need a ruling on the Sandman affidavit because that's been kicking around for a while. It keeps getting touched on. I owe him a ruling on that. And y'all have something substantive to respond to this obscure vein that hasn't been ruled on very often, but I don't see a way around.
No, Your Honor. And I don't.
So I would suggest that we, as I was already going to propose when we got to that point, we have a special verdict form of every which way you can slice and dice it, for disparagement, for breach, every issue preserved and delineated, and you preserve your objection for the record.
Well.
To its admission, I take it.
Yeah. And we'll be prepared to talk tomorrow morning, but we understand Your Honor's ruling. It's probably coming down.
All right. So then the Sandman affidavit itself is admissible in its entirety at the appropriate time. I think that would have to be through his deposition whenever that's presented.
Thank you, Judge. Judge, don't make me get on my knees in bed.
I'm not asking you to, Mr. Wood.
gotta go
You
home.
have said everything you can say.
Yeah,
I'll say
I gotta
that.
go home and eat. I gotta try to get some sleep. I don't want to be tossing and turning, not knowing what in the world's gonna happen to me tomorrow in court. I mean, I'm asking for some mercy here.
Okay.
And I know how Your Honor feels. You've made it abundantly clear. Let me go home, eat, and know that I've got to work tomorrow and behave myself so that I don't do anything that jeopardizes my ability to defend myself.
We'll be in touch by email.
Thank you very much, Judge.
Your Honor, as to the Sandman email, my client.
The affidavit or the email? What are we talking about?
What did I say?
You said email.
I mean affidavit, sorry. My clients and I or the whole team was talking, and I think there is a difference between admissibility and then it being evidence in this case that goes out with the jury.
Well, that's a continuing witness rule. I mean, there's every single one of these exhibits we're going to have to parse for what goes into the jury room with them.
Right. So we would contend that even if the affidavit can be
An exhibit, it wouldn't go out to the jury. I mean, I don't think there's any question of that. Just the way you can't put depositions back in the jury room. Federally, I guess you can do that all day, but
okay, thank you.
here we don't do that in Georgia for whatever reason.
Right. That's what we wanted.
If you can explain the continuing witness rule to me in detail, then please do. Case by case is pretty tough.
Awesome, thanks.
All
I
right,
think there's
with
some
that,
others too.
we're in recess.
Thank you very much.
Thank you very much.
Tomorrow morning.
God bless you. You too. God bless you.
Saying the transcript.
I'll talk to her separate.
Oh, you need.
Yes.
Oh, okay.
We're not off YouTube yet. We can't
Oh,
speak
you did. I thought you don't want.
because I think we're still live.
Yes, done.
Yes, yeah, I can get it for you about that. I mean, I try to do whatever you can, but I got one girl working and I'm out of town, so I can't help.
Oh, believe me, I'm a one-person
Yeah,
shop.
but we'll
It
get you
sucks.
Wilson. We'll get you Wilson special.
I'm lawyer, paralegal, everything. I get it.
I appreciate you.
I appreciate you.
Hey, man, when do we go off YouTube?
Oh, I don't have no idea.
It says live.
Well, you were Zoom.
Can you, ask Miss Sue to take us off?
on YouTube live.
Yeah, all the time.
Well, I'm in trouble on that.
And you're front center.
Yeah, I don't like that. The court court is usually not that. So I'm gonna just unplug, this works now.
Yeah.
Okay. Oh my gosh.
Yeah, you could have been used if you needed.
That's all right, yeah, let's do it.
I can tell you we're still live.
Here, I was about to kick it out.
Yeah, we're still live. I just pulled it up on the cell.
Let me turn the TV off.
Well, you sure? That's the live
Yeah,
feed.
the front and center. It just picked up the comment that you said about the court reporter being front and center.
It's still live. You see that red?
Yeah, it
Yeah,
says live.
can you ask her to take us down? Thanks.
And there's still 581 people watching. Yep. I think yesterday it said that 5,000 people watched. Like that
I
there
didn't
were
even know I was on there.
5,000 like discrete